folks. Good evening. Happy Friday. Well, the microphone just picked up the craziness that Leo did upstairs just now. But happy Friday. How you doing? We survived another week, arguably. So hi, Ian. Good to see you. A little bit of chaos to start the stream.
A little bit. Your mic is sounding, at least to me, a little echoey. I don't know if
Let me
or
see
a
if
little
I can't fit that.
tinny or
That's a little
something.
tinny. Little tinny. Let's see here.
It's true. You've got to find the Wizard of Oz setting and turn it all the way down to 0.
Yeah, I've got to figure something out. I have to figure a little bit out on how to get that up. Is that better?
That's way better.
Way better. Good. I was on the wrong microphone. It was actually going off my camera up there. So that's what happens.
That makes sense.
Yeah. Yeah, it was terrible. That's what happens though. There was we replaced the computer that was dying in hopes that we are going to improve a little power to be these live streams a little more efficient. Well, efficiency is probably the wrong term. Less technologically chaotic. Still the same amount of mental shenanigans. So I don't anticipate that changing anytime soon.
We've got a guest star.
I see the guest star. Guest star is ready for a big meal, I imagine, right?
That is why she is here. She's like, did you know what time it is? Because I have some opinions about what time it is. And those opinions basically are the dude doing this painting.
Yeah. It is time. It is time for you to put food in the bowl that I eat my food from. Yeah. That's what that time is. So it's been a week. How's your week, buddy?
It was pretty good-ish. No, it wasn't. I've been buried in work that I'm not getting much headway on. So you have that thing where you've got a deadline, but you've also got writer's block, and that's where I am right now. I'm trying to write a Supreme Court leave factum, and the thing is those suck because when they deny those, they deny it without reasons. They just by tradition they never give reasons for denying leave.
Well, they don't have to. Why would they ever give a reason? They're the appellate
the thing
court.
is,
How
is
dare
that,
you
like,
question
by
them?
tradition, you don't typically get reasons when you're denied a reconsideration at the Copyright Claims Board. But Janet got reasons.
Well, she got more than she bit off more than she could chew with that reconsideration. That wasn't just a reconsideration. That was, yes, we will reconsider flaming you with the fires of 1,000 suns. So that reconsideration is granted. You don't like it, but that's what happens. So.
I also got something else that's fun. This is the second page of it.
Oh, this one you showed me. This was great. I
have to do a video on that one because it's exceptional. But for the people in the chat who aren't sure what I'm looking at or what they're looking at here, that is a red ink thumbprint. Yeah. And
it's not blood. It's not blood, right? It's ink.
It's not blood because it's actually still red. But some idiots out there basically think that they need to sign things in blood, and so they but instead of actually having the courage to bleed on things, this guy's a bit of a coward, so he just uses ink. It is the hallmark of complete crazy town because nobody has ever used blood to sign anything in forever and a day. So that is where we're at with that. So
I would say that's a
gibberish.
a unique way of signing off. Now I loved it because it was not just signed, it was quote unquote autographed bottom of the page. So you have an autograph, not a signature.
He just printed his name in all lowercase because these people think that capitalization matters and they've got all this crazy. So anyway, it makes a whole bunch of demands of me, and Anyway, I'm going to take a second to go feed the pups, and then I'll be right back.
You do that. And I'll take a second catch up on chat and see what's going on with everybody. Okay, we'll pull Ian down until he gets back. That is way too big of a photo. I don't like that. Can we do something that's, there we go. There's a frame around that. So how you guys doing? How's your week? It has been a wild one here. Get you guys caught up. There's a couple stories I want to tell Ian. They're kind of interesting from this week. Not just law stories, but a little bit crazy stories. Yeah, it's been a wild one. The Karen Reed case is really all we have on the docket today. The reason for that is there's a whole lot going on in that Karen Reed case leading up to this. We've got a lot of contentious back and forth, and I figured that we might as well get into it a bit because we've got trial coming up that is scheduled to start, and yes, still scheduled to start April 1st. That has not been continued, so that's where things stand right now. But we can get into some of the specifics of everything going on there a little bit later. Let's get caught up. Reed has to be one of the craziest cases. It really is. Did I catch the leprechaun? Did not catch the leprechaun, Robin. Sorry, that was not in the cards. It just didn't end up happening. Ryan May YYZ from the depths of Alberta. I summon Cthulhu. I shouldn't have said that name out loud, but sure, why not? So, a little bit hectic, a little bit crazy, not as crazy as just us lefties. Cheryl blew up my car today, so it's sad. This makes me feel better. Got to go out this weekend and get a new used car. That's one way of doing it. I did see that there was a document dump in Coburger. I haven't been able to review the documents, unfortunately, but I'm impressed by new judges' rulings when it comes to evidence or other matters that are pending before the court. But I am impressed by the new judges' very keen understanding that the public has an interest in actual observation of trials and things that are going on. So there's a whole lot more coming out in that case than I think had been occurring under Judge. In the Karen Reed case, there have been some developments since yesterday's hearing that we're going to discuss, namely involving the possibility of arguments concerning attorney communications. So we'll have to see how that works. All right. Pup fed?
Oh, that's a whole thing.
I know. I told you. It's a while.
I have some feelings.
You may share them if you would like to.
They involve a lot of screaming.
Oh, so we should wait to bring that up.
Maybe some swearing.
So we should definitely wait to bring that up. You want to know what didn't involve swearing or screaming today? No, that's a lie. It absolutely did. It absolutely involved screaming and swearing. I had a case that was set to go to trial next week, Monday and Tuesday. And this case has been hotly contested for 2 years. Going on just over 2 years. And the ultimate trial in the case was supposed to be Monday and Tuesday of next week. I thought it had zero chance of settlement. Somewhat close to an understanding all the issues in your kind of like resolved, except for regular custody schedule and summer. Now, mind you, not a single contested hearing went forward on this case. Not one. I received the attorney's fee affidavit from the other side in the case. Any idea what the ballpark number was for 2 years? No contested motions, just back and forth and discovery.
$800,000.
No, divide it by 8 though.
$100,000.
$100,000. $100,000 for a custody dispute that has not seen a single contested hearing date. None. Everything was resolved by agreement prior to the hearing taking place. It was wild. Now, our fees in that were about half of that because the case was
$8.
pretty damn complicated. But
We're like, our fees are a pizza.
It's wild. The case was ultimately inherited by both opposing counsel and myself towards the end, and thank God that opposing counsel who inherited the case from a departing partner at the firm was more reasonable and someone I could deal with and work with on a regular basis. And I've known since I started practicing law, who kind of was in my, call them freshman class, basically. And it became a lot more cordial, productive after that occurred. But it was pretty insane. We did end up, after a full day and a lot of back and forth and a lot of tense moments and a lot of discussions that resulted in people leaving the room, going outside, walking around the block, we did end up getting it resolved, very thankfully so. So that put me in a very good mood. Followed by today, which was a case where I had to argue in front of a judge for 25 minutes on what the definition of winter break was.
Wait.
No, you absolutely heard that right. Absolutely.
They wanted the particular exact times, or they just didn't know what the idea was?
No, they wanted to know what the times were because there was a division of custodial days based on winter break from school, winter recess from school. But winter recess from school, winter break was not ever defined. Usually these orders say,
apparently
winter
I'm quiet.
break.
I'm trying to fix that. So chat, let me know if it's getting any better.
That does sound a little better. It does. So winter break is usually defined. I don't know why this is happening. So defined in the order as being,
Everyone's saying pump up the volume. I don't know if that's still true though, because I turned up the volume. So sounds like the fan is on. I have my computer on. It's got a fan in it, but
no, it's fine. I can hear you just fine. I can actually turn mine down a little bit. But yeah, winter break was the issue in dispute, the entire issue in dispute, the definition of what that winter break was. So more than a couple $1,000 spent by either side to resolve something incredibly stupid. That's what it was. Yeah. That was how today went. So great thing followed by not great thing. How it works.
that's kind of the nature of law.
Yeah, usually it is. Let's see. I'm trying to get something set up because, of course.
And now I'm realizing I am out of beverage, so I'll be right back. Probably with a better beverage. 1 second.
You got it. Okay. For those of you ever wondering, what you do or why, I don't know if I'm saying why, but custody matters and family disputes, why do lawyers try to settle them? Because of that ridiculousness, the $100,000 for litigation costs in a custody matter. That is neither here nor there. The good news is the matter's not going forward to trial, which is also very, very, very beneficial. I know chat's reporting that I'm freezing. I don't know why. I guess we'll just have to run with it for a bit and go with it. It is what it is. Live streaming is dynamic. Don't always have the ability to change stuff midstream. So, all right, let's get caught up. Thank you, Sandy, for gifting memberships. Ryan Man YYZ, thank you for gifting memberships. Fiona W, thank you for gifting memberships. Joshua, thank you for gifting memberships. You guys who gift memberships are incredibly generous. Thank you very much. And for those of you who just became members, please go check out the members only content, which is usually just me in my shop talking to myself. Is what it is. It's awesome. I love it. Torin 3, I saw a doctor this week to get better control of my ADHD and was told I didn't have ADHD because I've been too successful and reading is too easy for me. I had similar challenges because, reasons. Lawyers, well, not lawyers, people that are successful and it doesn't mean you can't have ADHD. And that's the big challenge that people don't often understand. So I'm sad that you had that happen to you, but glad that you had the diagnosis before. 23, I'm getting a second opinion, not going back there. I would say that that's probably the right call. Strange credulity, 3 questions. Why did Bev say material and deliberate, but then make 0 sanctions? Why make such a big deal? Will Proctor's firing affect the Commonwealth's case? Will he plead the 5th? Will Karen Reed documentary hinder her case? Okay, those 4 questions. Strange credulity. I hope that we cover all of those questions as we get to the hearing, which we're going to do in short order. Because, like I said, there's a whole lot that happened today that was, or not today, I guess it was yesterday, that was rather impactful. But I will save that to make sure that I don't forget those questions as we go through that. Queenie Bly, just cuz, go FNF, hugs to everyone indeed. Oh, the other thing that happened today that was really interesting that's never happened to me in a case. So the thing that happened new to me in a case, you guys, I know the audio is being changed because I'm turning the gain function down or up on the mic to try and catch a relatively reasonable volume. So I apologize. I will get it acclimated. Promise you. I don't really promise you much, but I promise you I will try. So while in court making this ridiculous argument over what constituted winter break and winter holiday period, we were in one courtroom and I am mid-argument and the judge's bailiff steps in from the back and whispers in the judge's ear, and the judge looks kind of scowling at a minute and then goes, "We need to clear the courtroom."
What?
Which, yeah, generally speaking, can give cause for concern.
Yeah, no, that's a big deal.
So we clear the courtroom, but it wasn't clear the courthouse, which was kind of odd. And we clear the courtroom, get into the different courtroom, and the judge is now saying, "Counsel, you can approach again and go back to your argument," which is always fun when you are mid-argument, mid-paragraph of a order that you're trying to ask the court to interpret and then having to go back and remember where you were. But the court said that they had, you'll love this, a sov sit yesterday that had a full trial that was there all day and was doing sov sit things.
Did he send me a letter?
No, they didn't send you a letter. They didn't send you on that one. That sov sit called the courthouse today to let the courthouse know that they had been diagnosed with having ringworm. So ringworm is just making an appearance in all the things in my life right now. So that was why, at the direction of the chief judge, rather the sheriff's department, who I guess their chief.
Were they like rubbing their butt on things?
I don't know. I have no understanding of why that happened or why ringworm by one person in the courtroom would cause the entire courtroom to have to get cleared. It was new to me. But did I go from the courtroom to the bathroom to wash my hands thoroughly? Mm-hmm. I absolutely did. Why is ringworm happening in courtrooms when my dog has ringworm? I don't know. It's just following me around. It's bad. I don't like it. It's annoying. So it's very contagious. I know that, guys. I am trying to manage all the things, including trying to manage why the computer is moving slower than I want it to and why certain things are pausing, because I can't always figure that part out. I'm trying to. Internet looks good to me. Internet is solid to me. Either way, I guess you'll have to see if, when we bring the video up, if the video can stay solid. Runkle is blurry. Yeah, that's because Ian sat down and it didn't autofocus back.
Oh, yeah. I'm like, wait, I guess I am. Let me unblur myself. Yeah, that's a total thing I got to fix. Will that? No, that won't work. Yeah. Give me a second. I got to get into the things here.
Patient zero is
yeah.
Rob. No, Rob is not patient zero.
Rob could not be patient zero, amongst other things, because the dude that had the ringworm would be patient 0.
Dude, the weird things that happen in court, I swear.
I assume there's not. You know what? I don't want to know if there's been pooper issues. We're just going to move right on past that.
We're not going to go through that. We're not going to talk about it. We don't need to go through that part. No, I don't need to hear about that. I was in the bathroom of the courthouse once, and they had someone who came in with an electronic laser mapper. And I was like, "What are you doing?" And they're like, "We're mapping the building." And I was like, "Well, why do you have to map the bathroom?" I don't know the answer to these things. I just do what I'm told, which is usually go to the courtroom I'm supposed to go to, argue the case, and then get out of there. But that is what it is. So let's see. Okay, so shall we get into the Karen Reed stuff? And the question for the chat that I have is, there was a hearing that took place at the very beginning of the day that involved Aiden Kearney, Turtleboy's text messages. Do we want to cover that or no? The only reason why I was thinking about it is you get a pretty good contrast between the judges.
That was a big contrast.
Oh my God. Maybe we should. Let's go ahead and do that. We'll cover a little bit of it, but the judge is rather combative with all parties involved. And let me tell you, I, by and large, appreciate this style of judge. So Court TV, don't yell at me, but I'm using your stream. Okay. I know you're here.
Court TV is normally quite lovely about that.
I know. I've enjoyed dealing with them. Well, not dealing with them. I've enjoyed their coverage. I've enjoyed the fact they get present in the chat and they engage with you all, which is a lot of fun. But what I enjoyed most about this moment was wondering, why can't we get this judge? So let's see. You guys are gonna have to let me know if you can hear everything or if I need to boost the audio. And we'll turn on closed captions. And here we go.
I know is that there are 2 phones that were served by Trooper and is in the possession of the District Attorney's Office. And the information is relevant material to Karen Reed's case. The reason why it's important and relevant is that.
See, that was not my error. That was not my fault.
The Court TV feed for this day is awful. You need to find the Boston something feed because I don't know why, but like Court TV.
Look, even Court TV is.
Yeah, sorry, Court TV, but I just gotta say your feed for this day was not good.
We'll come back to you.
Because yeah, Boston 25 was all right, or Boston 10. I'm seeing.
I know both. I know that everyone was having live feed issues, which is not uncommon for this particular courtroom. I don't know what they do to pipe the audio in, but why are you saying ooh for? I don't like when you said huh?
A case I'm covering that, so far as I know, no one else is interested in other than some of my followers, but maybe not many of them. But it just had an update. So I'm clicking the button to see what the update is because some new documents got posted via court listeners. So I'm trying to see what they are. So the judgment was entered. That is nice.
Okay.
And what is it? So GWAX, which is the case I'm looking at here.
Yeah. GWAX
has a response in opposition to a request for attorney's fees and costs. Because they're potentially subject, if they lose this one, to $1.25 million in costs.
1.25, right? That number was correct stated?
Yep, 1.25.
Okay.
They're not going to end up owing 1.25, but they may end up owing a good chunk of money. And yeah, I totally want to see it. So I guess I'm clicking some buy on Pacer buttons.
Core TV, as someone who routinely has tech issues with a way less significant consequence, and I mean a way less significant consequence, I cannot imagine the stress of what existed when you were having your feed cut out every 2 minutes. So I'm sorry that what you went. All right.
Yeah, Core TV normally has great feeds. Just this one, I don't know. Somebody, maybe like Lally, because we don't actually see Lally doing anything. Maybe Lally was sitting there wiggling the feed, wiggling the plug.
Just with his foot, he was just kicking the foot back and forth.
I mean, it's not like he's got any other role in this that we've seen so far.
All right, so this coverage starts a little bit into the hearing in Turtleboy, and you have I think Alan Jackson is addressing the court on why he should be heard. For those of you playing a little bit of catch up, there was a motion filed by the Commonwealth asking for certain amount of certain things that were turned over or were discovered in the criminal prosecution of Aidan Kearney, Turtleboy, in his criminal prosecution when they did a subpoena and search of his cell phones. They were asking that they be allowed to, I don't know if we would call it a transfer, but basically get that discovery in a different case where you're saying, hi, we don't need to meet a different threshold. Please let us just use that discovery that was received in that other case. And it was assigned to a different judge, but it's called under the Karen Reed case number. So apparently we thought that this is going to be in a different courtroom. Karen Reed's team shows up at the beginning of the argument. Hank Brennan is going, wait, why are you here? Because you're not a subject to this discovery request. Kind of forgetting that the defendant is allowed to be present at every single impactful proceeding in their case. So that's getting everyone caught up.
Issue will be dealt with at a later time.
Respectfully, I don't necessarily disagree that from an evidentiary standpoint or the disability standpoint, that can be dealt with at a later time, but the case should never be called without my client being here. She has a constitutional right to be here and to be heard, even on a Rule 17. The Commonwealth there's been Rule 17s for 2 years on this case, over and over and over, Your Honor. The Commonwealth has taken positions on Rule 17s. We've taken positions on Rule 17s dealing with third-party information, be it cell phones or text messages or whatever. I'm only asking that we be entitled to be heard on this issue, even though it deals with Mr. Carney's phone and he's got legal representation. It also attends to Ms. Reed's rights, and it's her case number. And the reason the Commonwealth is trying to bring it in is to deal with her case, not Mr. Carney's case. So she has to have a right to be heard.
Counsel, this motion's been pending for a week and a half now.
Correct.
I don't have any opposition from you. I don't have any submission from you.
We intended to submit oral argument.
I kind of feel like the judge is right
Did you
on
give
that
the
one.
court notice?
I agree. Like here's, and I get yelled at quite frequently. One, just address the judge's mannerism right away. Do you know how much I appreciate arguing with a judge where I know where I stand immediately, and that judge is immediately pushing back, and I get to just, I'm like, okay, here we go. We're going gloves up right at the beginning. I love it. It's phenomenal. People are yelling at me that I missed the best part. I did not miss the best part. Hang on. You guys want to see that? This stream, the stream I'm on didn't show it, but the hearing was called. Where is it? Here. Okay, here you go. We'll see the best part. There you go. You guys want to see this part? Here we go.
Start of the hearing, Reed was not in the courtroom, but then unexpectedly,
Oh, that's annoying.
walk in. Reed appears to glare at the special prosecutor in her case.
I'm not sure.
I would say that's a glare. Yeah. All right. That was bad. Let's see if we can't find a different clip of it. I don't know why you guys love that part so much. I didn't find that very significant. I get it. She walked in. The prosecutor was like, all right, I didn't expect to see them here. Threw them off guard.
I mean, I can see why she'd be pissed if she's like, why are you calling this without me? It's my case number. So, yeah.
I get it. All right, here we go. So unbuffered. Here we go. Let's do, because everyone wants to see it.
Now, is it
There you
just
go.
me, or is this the weirdest trial you've ever freaking heard of?
Unequivocally, beyond a reasonable doubt, the arguments that get made, the position people take, the absolutely combative nature of some people in one side or the other, it is wild to me.
Relationship between Karen Reed and Mr. Carney, but a relationship in where information
You know what else bothers me? The fact that Hank Brennan can't pronounce any single word right. What did he say yesterday? It was so I don't know if it's Carney or Kearney. I don't know, but Alessi.
It's Carney.
Okay, so he said Carney. So oh my gosh, he got one of the names right. My word. All right.
information, some of it private, some of it suggestive grand jury minutes, was passed purposefully from Karen Reed to Mr. Carney. Originally, a third party was used, an intermediary, where allegedly Ms. Reed would send the information to the third party, would then be sent to
Counsel, let me stop you there. Has the name of the intermediary appeared in the public record?
I don't know that. I know that the attorneys are very well aware of that person's name. It may be, but I don't know that, and that's why I refrained.
Let me ask you this, counsel. Does the
It's
name
not
of the
Runkle.
intermediary appear in Trooper Tully's affidavit, either in the substantially itself or in the addendum A?
I will need to re-review, but it very well may.
Well, that's a critical issue here with regard to the purported relevance of the data sought. Let me ask you this, Attorney Brennan. Have the extraction reports that have been requested been generated?
I understand they are available to Special Prosecutor Cosgrove and that they have the reports that have been generated.
Has the underlying data from the two phones in question been?
Do you know how much I appreciate this judge right now? Like, I have a heartthrob. This is my style of judge. I love it. Ask the question you want to ask. Cut them off if you want to. Make them address the concerns you have and do it in a direct manner. No passive aggressive, no sighing. It's just, has this been there? Is this there? Is it where it needs to be? Are you doing these things with the documents? Oh my gosh, this is amazing.
Been assembled?
I understand that it has. I cannot personally confirm because I have not asked to review it personally.
Do you know the volume of the underlying data?
I have no idea because I've purposely not asked to see it or ask questions about it.
Okay. Please elaborate on relevance as it relates to consciousness of guilt.
Yes. As Your Honor is aware, consciousness of guilt is a different standard than trying to prove a case of intimidation of a witness beyond a reasonable doubt. What we expect evidence will show, separately and in Mr. Carney's phone, is that there was a relationship between Karen Reed and Mr. Carney in which Ms. Reed would provide information indirectly and directly to Mr. Carney. That information would then be reviewed by Mr. Carney, posted on social media, and consequently was used, we believe, allegedly, to intimidate and harass witnesses. In the search warrant itself, there is extraordinary detail on how Mr. Carney targeted witnesses in Ms. Reed's case, with the express purpose, according to Mr. Carney, that this trial of Ms. Reed never go forward. We have a many-page affidavit that we have provided to the court. I can offer some of the most important parts if Your Honor would like.
Counsel, I don't think that's necessary. I've reviewed the affidavit in support of the search.
Oh, I love it. I love it. Oh, give me this judge all day. And I don't care if they're combative. That doesn't bother me. I know what I'm getting.
Warrant thoroughly. And
Combative is fine
and
if you're
here's-
at least
here's where I
you know
struggle.
where you
Yep.
stand.
So the case law says the party seeking the data in question has to make a initial factual showing that it's relevant, not potentially relevant, relevant. That's the initial burden. So to demonstrate her alleged consciousness of guilt, defendants, don't the communications sought or the data related thereto have to only involve communications between Mr. Kearney and the defendant?
Okay. It's a good pausing point because the judge hits on one point that ends up being kind of the fundamental point that of this hearing. The request for information in this particular hearing was a body of communications that was essentially the whole damn phone. And the judge is kind of focusing and saying, look, there's probably some communications that are relevant, but don't they kind of have to be between the defendant, meaning her statements, and this third party?
Yeah.
I'm not clear on your question, Your Honor.
How is anything beyond communications between Mr. Kearney and the defendant in this case relevant to her consciousness of guilt? Here's my issue. You have sought a broad swath of data. We don't know the volume yet, but it is from the addendum A to Trooper Tully's affidavit in support of the search warrant. It calls for data including calendars, alerts, reminders, notes, text messages, pictures, or videos from April 1st, 2023 through and including October 5th, 2023. 7 months of material that ostensibly could include everything from meeting notes, calendar invites, texts, videos, things that have absolutely nothing to do with communications between Mr. Kearney and the defendant. So how can the Commonwealth make the threshold showing that those are relevant?
First, this is a ruling with Mr. Kearney, so I'm asking that Mr. Kearney.
Oh, so that's why Karen stared him down, because he immediately goes and says, you can't be here. Oh, that makes sense. I'd stare him down too. This is her defense case. You're asking for a discovery. Yeah, wow. Okay. I'd make that statement. I'd do the stare. Now, I don't know that I would hold the stare as long as she does, but
Kearney is attorney being at the table. I'm not sure why we're being joined by Ms. Reed's team unless they have standing in this.
Your Honor, we're a little confused, and I don't mean to interrupt the proceeding, but as we're...
Can you state your name for the record,
Of
please?
course, I'm sorry. Alan Jackson on behalf of the board. We didn't see which case number was called for this Rule 17, if it was Mr. Kearney's case number or if it was Ms. Reed's case number. We were told, or at least our impression in talking to Judge Cannoni, was if this issue was going to be on our case number. I specifically asked that question at sidebar day before yesterday, and she said, yes, the Rule 17 that Mr. Brennan's dealing with is on Ms. Reed's case number as it pertains to her rights and the
This
issue.
meeting is being
Counsel.
recorded.
Counsel, it has been called in this case, but I don't know that your client has standing with regard to this particular issue.
now the judge focuses on a good point, and that was what Ian was saying at the very beginning, is she might have the right to be present for any hearings called in this case number. Whether she has the right to say anything is different. You know, you might not have the right to oppose certain things that are strictly Commonwealth seeking information from Commonwealth, because that's what this is. The Commonwealth is saying we want to get information from the Commonwealth in this other case and use it in this case. So you might not have the ability to say anything, but you have the ability to be present. And it is kind of deceptive not to. I don't understand this part because everyone else is in this courtroom on this hearing, understanding what's happening. I guess they thought it really was being called in Kearney's case number. So
So the case number, I just want to make sure procedurally I'm on the same page as the court and Mr. Brennan and Mr. Kearney. The case number that was called was the Commonwealth versus Karen Reed.
00117.
Okay.
That's correct.
And she needed to be here and she has a right to counsel and we have a right, we believe we have a right to be heard on this issue because it does attend to her rights going forward in terms of her case. I mean, this is her case.
I don't know that yes, it is her case, but what standing does she have to challenge a Rule 17 request related to documents produced in another case?
because it specifically pertains to the prosecutor asking for information in her case to move forward, her consciousness of guilt, etc.
Those are evidentiary issues, counsel,
Correct, but we
which can be dealt with at a later time. Those are, what you're suggesting are evidentiary issues which are not before the court. All of it before the court is a Lamprin hearing on material sought from Mr. Kearney's case. The evidentiary issue will be dealt with at a later time.
I
This
understand,
is,
Your Honor. And respectfully, I don't necessarily disagree that from an evidentiary standpoint or the disability standpoint, that can be dealt with at a later time. But the case should never be called without my client being here. She has a constitutional right to be here and to be heard, even on a Rule 17. The Commonwealth there's been Rule 17s for 2 years on this case. Over and over and over, Your Honor, the Commonwealth has taken positions.
Now I'm very curious. Emily, what is your wild wish?
She's hoping to have the judges swapped. I mean,
You know, the word
we all know it's not going to happen, but it is a
I know,
worthwhile wish.
the universe is not that kind. It's just not. I mean, the universe is plenty bountiful and remarkably kind and gives you a lot of things that you put out there and you say, universe, I'm going to put out positive energy and I hope this comes back. I don't think this is one of those times, Emily. I don't think it is. So, I can match that energy because let me tell you what, right now, I will say that a lot of litigators, most litigators, most good litigators are far more effective in front of a judge like this, where a judge that peppers them with questions and is direct and might appear confrontational, but is getting to the heart of the issue because the judge is being very direct and say, this is my concern, address that concern. And then you get to make the comments back. We're very used to arguing directly. What we're not really used to is, I don't know if I'm going to allow at this point in time, but you've got to be you're the person proffering the evidence. So you've got to kind of guess what it is that I need to see in order for you to put that in front of me. Or,
that's her go-to move.
Yeah, I don't want you to give me any, don't give me a reason for your objection. You should just know what it is you're objecting for, and you should be able to understand why the person is objecting to evidence you're trying to adduce. I mean, you should know. And then when I rule, you should just know why I rule. You should be completely capable of doing that, counsel.
We're just going to have a psychic meeting to discuss the contents of the objection.
What's the old Maxwell Smart where there was the cone of silence? Where it's like, just imagine the cone of silence, like just like judge, objection, cone of silence over here. Yeah.
The thing is, the cone of silence would actually make more sense.
Yeah.
Because it's actually just the cone of nobody talks.
Oh God. Oh. Cone of guessing.
Positions on Rule 17s. We've taken positions on Rule 17s dealing with third-party information, be it cell phones or text messages or whatever. I'm only asking that we be entitled to be heard on this issue, even though it deals with Mr. Carney's phone and he's got legal representation. It also attends to Ms. Reed's rights, and it's her case number. And the reason the Commonwealth is trying to bring it in is to deal with her case, not Mr. Carney's case. So she has to have a right to be heard.
Counsel, this motion's been pending for a week and a half now.
Mm-hmm.
I don't have any opposition from you. I don't have any submission from you.
We intended to submit oral argument as it attends to, and we're prepared.
Did you give the court notice of that?
God, I love it too, because you can see that it even throws Jackson off guard. Like you hear him pause and you hear him scramble, or he's like, oh shit, oh crap. We intended to submit oral arguments. Go. Yeah, he called you on that, didn't he? Right out in front of you. You didn't submit anything. You probably should have submitted something in writing to try and ask for time to be heard, but I don't know if you had the chance or not.
That
we did to Justice Cannoni.
Okay.
Day before yesterday.
I think that's what wins him the ability to speak.
And what do you propose, counsel?
The only thing I propose, I don't want to interrupt Mr. Brennan's argument, but when Mr. Brennan is finished, Ms. Little is prepared to address the court on the very issues Mr. Brennan is bringing up.
I'll take it under consideration. Is there any issue, counsel, with the current configuration, the court, such that that causes any issue for any of the parties?
No, absolutely not, Your Honor. Again, I will step back. I will be a little mouse in the room. I just need to be in the courtroom. And once Mr. Brennan is finished, before the court makes its ultimate ruling, and once Mr. Gradle is finished, I think we should be provided an opportunity to be heard.
I'll consider the request.
Turtleboy looks like he is.
Procedurally, the council wants to join in my file. That's an issue in terms of the file. So just put it
Thank
down.
you. Thank you,
Well,
Attorney.
Your Honor, I do object. Ms. Reed's counsel and Ms. Reed do not have standing for this motion. I don't believe they should be sitting at the table for this motion. It's a Rule 17 motion of third party. She has no privacy interest in these materials.
I don't give a shit if she has privacy interest in materials. I don't give a shit if she has standing to make an argument. She has the right to be present. So, on that issue, Mr. Brenner, you and I are going to fundamentally disagree. On the issue of whether she can submit argument, I'm inclined to agree with you. Mr. Kearney has counsel. I don't know that anything that Karen Reed's team can add anything to the argument, but be present. She absolutely does. Absolutely.
She has no standing to object, and she's not a party on the Rule 17.
Thank you, ADA Brennan. She is a party in this case, and I'll allow her to sit at counsel table and to have representation, and I'll consider whether I'll hear from her counsel concerning the substance
I like
of the
the
motion and her
thank you, but no,
Thank you, Your Honor.
considerations there
We
too.
appreciate the court accommodating us.
The judge also makes remarkably fast rulings.
he actually just decides on things instead of like,
Oh my
well,
God.
counsel, I'll decide later.
And he gives wide latitude in what you're allowed to argue. He might make a quick ruling, but you can jump back and you can argue with him, and they do effectively. This is clearly a judge that was a former trial attorney, and just, oh my God, why can we not have?
So, ADA Brennan, with the court's apologies for the interruptions, the crux of the issue, as I see it, with regard to relevancy and the Commonwealth's burden at this stage to show that the requested materials are relevant, involves the breadth of what has been requested.
And the judge does a road so far. The judge literally, like, after that little interruption, the judge goes, here's the road so far. Here was my concern. This is where we left off. Please address these concerns.
And perhaps you could speak to that and how materials that would be swept into this request are in fact relevant.
I understand the court's concern, and I've looked at Addendum A as well, and I've identified the information I think is relevant to the Rule 17 subpoena. So I agree the Rule 17 subpoena speaks broadly, but what is relevant is sections D, E, and F. Now, mindful that there was probable cause to obtain this warrant, which is a far stronger standard than what is needed for a Rule 17 motion.
I feel like he
Counsel,
should be
pardon me,
wearing
did
a
you say
colorful
D,
tie with
E, and
that
F
suit.
of Addendum A?
Yes.
Yeah.
So if we look at section D, there was probable cause
Maybe
granted for
something in
communications
yellow.
between Mr. Kearney and any witness or family members of witnesses involved in the murder of John O'Keefe, to include but not limited to Matthew McCabe, Jennifer McCabe, Brian Albert, Christopher Albert, Colin Albert, Juliana Albert, Michael Proctor, Elizabeth Proctor. And so
I'd lend him a
limited,
tie, but he seems like the
um,
sort of weasel who might not give
including
it
but
back.
not limited, would suggest
Oh, take it easy.
any witnesses in the Commonwealth versus Karen Reed case. E is pictures or video depicting evidence of intimidation of a witness. So similarly to D. And F, data evidence disseminating data depicting evidence of intimidation of witnesses of those same people. And so D, E, and F are squarely on point and relevant to the Commonwealth versus Reed case. If there is probable cause to obtain a search warrant, believing that there is information of those three categories on those phones, then I believe we're entitled because we'll clearly have met our burden of proof, not only because a Rule 17 is that it's likely relevant, much less than probable cause, but because of all the attendant information that we've provided. There is.
Hey, Brennan, let me stop you again. Would any of those categories include communications from Mr. Kearney with counsel from Ms. Reed?
No, I think those would be privileged. Secondly, there are motions filed in this case, not Karen Reed case, Mr. Kearney's case. One is the Commonwealth's opposition to defendant's motion to suppress and to restrain any searching of a computer or telecommunications devices. This was filed by Special Prosecutor Cosgrove. And in that motion, on page 5, he notes that the 2 phones that I'm seeking information from have already been searched. And he also notes in the motion that there does not appear to be any attorney-client privilege materials. There is a second source as well, and that is in the Commonwealth v. Kearney case, docket number 53, Commonwealth revised proposal for examination of digital material seized. That's relative to the 4 phones that I'm not seeking. However, it's instructive because in that motion as well, it talks about the history, and it gives assurance that there are no attorney-client privilege communications in the 2 phones that I seek. And so, given the separate evidence that we have, and these are clearly witnesses in our case, and the admission by Ms. Reed herself, I do not have the video, but she was recently on an air broadcast on a documentary last night, the night before, and the night before. There are admissions that she was, in fact, providing information to Mr. Kearney. And what is notable,
that documentary is going to cause her lots of problems.
It already is.
The consequence of Mr. Kearney's actions, which she helped fuel by providing this information and identifying the witnesses in her case. I do have a clip, if the court is interested, because it gives great depth and understanding to the intentions of the party in sharing this information. I have a clip available. If the court wants to hear it, I can play it for the court.
I don't think that's necessary, so I'll decline respectfully the offer, ADA Brennan. Thank you.
And so in light of the fact that this information was seized pursuant to a warrant of probable cause, in light of the proffer in the affidavit, in light of Ms. Reed's admissions of the sharing, and inevitably the obvious consequence to witnesses, this is relevant to conscience of guilt. The evidentiary basis is clear. I do not have access to this material if a Rule 17 is necessary. And again, I filed the Rule 17 out of an abundance of caution to be beyond reproach. If it is not necessary, I will simply go and obtain the information on my own, but I think it's more prudent to have a court order. It's necessary before trial. I'd like to review the materials that are relevant, and I agree the scope should be limited to D, E, and F, not the entire phone. And those materials would be provided to Judge Cannoni in a motion in limine regarding conscience.
How much do you want to bet that he agreed that the material should be limited to D, E, and F within about 2 minutes of the judge starting to talk?
I don't know if it took longer than 2 minutes.
I'm guaranteeing you he went in there swinging, and the judge, like, immediately, just by tone alone, he was like, oh crap, got to scale back the request.
I asked for too much. I'm getting blowback.
It is, and ultimately that ends up carrying the day, the scaled back request and what that request itself
also will dictate what witnesses we call at trial, which advance notice is important for both the Commonwealth and for the defense. It's in good faith. I provided both pleadings from Mr. Kearney's case, the search warrant, affidavit in support of the search warrant. I've offered videos of the admissions by Ms. Reed to the relationship. And so for those reasons, I ask you.
It's not even my problem, guys.
It's not a crime. And it would have been an unbelievable expansion of government power to search people's private information. Thankfully, the SJC said, no, you need to have a nexus between the phone and the crime. And they cited some other cases in terms of quotes about cell phones. Just 2 quick quotes, Your Honor. The cell phone is a repository of just about everything that is materially important to a possessor. Documents, messages, emails, notes, thoughts, communications, photos, loved ones, information involving loved ones. The court should not view lightly what the Commonwealth is seeking here. Cell searches would typically expose.
This is Aiden
That's
Kearney's
lawyer.
Yeah, it's Kearney's lawyer.
to the government.
He's got two.
far
Bettero's
more
not present
than the
tonight.
most exhaustive search of a home. So the
I appreciate that, counsel, but at the same time, the phone has been searched. The data has been obtained by the Norfolk District Attorney's Office. It's in it's in 88 Special 88 Cosgrove's possession, custody, control. It's already been seized. 88 Brennan is looking now, it seems, for a very narrow subset of that information that does not contain the long list of materials that you just rattled off from the Onyx White case.
But it never should have happened. The search never
But
should have
that
happened.
issue
It should have
isn't
gone through
before
the
me,
taint.
counsel. That issue isn't before me. The issue before me is
He's like, but it did. So
what he's looking for relevant.
Right. What do they have? What do they have to set that up? They have the fact that they spoke. And the fact that they spoke is not evidentiary. It's not relevant. If the fact that they spoke was the basis, we'd be at Onyx White. We'd have the wrong
Hang on.
decision in Onyx White, Your Honor, that just because people speak, the government gets to ferret around in their phones. It's a horrifying concept, Your Honor. That's really the crux of why I'm here. And the last thing I'll say, Judge, is that the fact that they got around the taint team we shouldn't just forget about the taint team. These phones need to go back through the taint team if they want to look at them. And on the taint team issue, there's more litigation to be done where the court already allowed scrutiny of the phones by a taint team for attorney-client privilege information. And my client at the time had many civil and other cases going on at the time.
Yeah, but right now, and here's the thing: the lawyer's making a good argument, but it's an argument for not allowing the Commonwealth to get the materials that they're no longer seeking.
yeah,
So-
that's kind of the problem. They've already got everything, so it's like, what is the privacy interest in stuff they already have?
Yeah, and that's the thing. So by Brennan going in there and kind of reading the room and realizing, oh, I just want communication between Carney and Karen Reed. Well, with that one, the threshold on relevance is so low because you have defendant actual communications, defendant's own communications. With that one, it's pretty easy.
Yeah, and he's not. Brennan isn't dumb. He's just mean.
So this ends up being, I'm going to call it, this ends up being a win for the Commonwealth for the based on the limited scope that they revised their motion to. This is a win for them. They won this argument. Now, they didn't win what they wanted, like all what they wanted. They won what he revised and said in open court. That's the outcome that occurred. So getting caught up. Let's go ahead and do this because I don't want the overlay that Court TV has on their live stream the whole time. So we're going to go to this other feed. We're going to get caught up to the beginning of argument in front of Judge Bev. We take a brief recess and we bring ourselves back to court. Let's see if there's any questions on the Carney thing because I think there probably were. My gosh, the chat flew in real quick. Shay B, Reed shared public information to Turtleboy. The fact of the matter is that her communications, because the Commonwealth has put forth this argument of witness intimidation as being facilitated by Karen Reed, and this argument as that demonstrating consciousness of guilt, that allows them to do a bit of discovery on the issue. And not only that, but it's not overly invasive to discover statements by the witness that she makes to third parties because the Commonwealth's allowed to get that in other settings as well. So I didn't see a problem with that request. Shy Gal, to think what we're watching is real life is what my nightmares are made of. Yours and mine as well. Absolutely. Katrina Bunny in another chat, someone called Hank Brennan Smithers. And I can't unsee the comparison. I don't like you for saying that. I don't know. When he stands up next, I don't know if I'm going to be able to unsee it. Plus, Turtleboy face palms during the afternoon. Keep an eye out for it. I'll see if I don't know if he's in this hearing or not. Ryan YYZ, methinks Mr. Brennan would prefer to be a prosecutor in a government-friendlier jurisdiction, perhaps North Korea. I see what you do there. Rosebud 26, a judge in Massachusetts that rules from the bench. Shocker. I loved it. It was so refreshing. I believe Judge Canoni does not make rulings because she has to seek guidance from someone, Billy's Momzilla, that you can speculate about that. I'm not going to go that far. I know a fair number of judges who refuse to rule from the bench because they don't
Yeah,
want
a lot of judges
make that
don't
call.
like that just because gives them some time to think, gives them some time to write it out. And a lot of the time what they're trying to do is they're trying to appeal proof themselves. Because and I suspect that's why she's doing it. I mean, she might rule from the bench a little bit more in a different hearing, but she knows everything is going to get appealed on this one.
Mhm.
So she's like, I'm going to just go in the back and I'm going to, I'm going to think about this one so that I can make sure that when you appeal it, that I've covered as
I've
many of the
got my-
bases as I can.
Yeah, I've got my bases pretty well covered. And I don't hate
I've
that.
done the
I
CYA
generally
on that.
appreciate judges that do that.
Yeah.
Melanie Schuyler, will it bias the jury if Karen Reed team gets called to testify? Let me put it this way. I don't really see a world where they can put the attorney in no circumstances. A judge can allow the attorney who's trying the case to be put on the stand in front of the very jury that they're trying the case in front of. Even in the Baldwin case, when Attorney Morrissey or the special counsel, special prosecutor Morrissey was testifying, jury was cleared. So no, I cannot see any judge putting the attorney trying the case in front of the jury in any capacity. Emily Aarons, please, can we have the cool judge run the trial? Kristen M96, I was watching Melanie Little. It sounds like Turtleboy didn't know this was being heard until the night before and in a different courtroom. Very interesting. I didn't know that. I thought there was notice requirements on these motions. Party information.
Yeah, it's just it sounds like they gave notice, but also gave a different room on that.
Interesting. Amber C. The bailiff held him outside the door outside door for unrelated hearing. I don't like anyone being held outside the door of any courtroom if it's a public courtroom.
I mean, there's times where it might be sealed off or whatever, but
it's one of those times. Court TV's in there. Public has the right to be in there, especially someone that's.
Oh, absolutely. If Court TV is allowed to be in there, they should at least be allowed to be in the room. And if they were trying to actually hold them out, like the bailiff saying, you can't go in there, that to me is strikingly a problem.
That's a problem.
Because, yeah, that is some effery. But I mean, like,
now,
I
will say, go ahead.
I've seen moments like at the local courthouse where at one point I was walking by and they had two bailiffs standing out front of a courtroom, arms crossed. I'm like, what's going on there? They're like, yeah, sealed proceeding. Like, you cannot go in there. And it was like, no media, no anybody. And I found out later that one was like a national security kind of thing, right? Where it's like, nobody gets to hear this. And so, fair. But
well, and I'm in juvenile court half the time, which our courtrooms are locked for that reason. Like, we're dealing with juvenile matters. But
yeah,
in this case, I will say this. Here was one observation I made about them coming in. It is rather bold and presumptuous. It's not walking in the courtroom. That happens all the time. But to walk directly to counsel table in the middle of some other attorney's argument. That part I thought was.
That is bold.
That's pretty bold. You can expect that a bailiff is going to approach you if you try to do that. But the judge knows these attorneys. Is not surprised by the fact that they're there.
This is also not a timid group, right? This is
I
like,
would say that they're not.
They're not shy. They're not, yeah.
Gwitty Bly, Brendan, we believe, grounds. He gets loose with that, especially as we get in the afternoon today or yesterday. Jessica Whaley, EDB requested a trade of judges on behalf of the law nerds. I would love for this judge to be on the main trial. At least he seems fair. He just is more direct. You get an understanding right off the bat of what his concerns are. AG, happy news. I put a total of 26 hours of steno practice into my machine in the past 2 weeks. Congratulations. I've done over 390 by the time school starts if I stay at the same rate. Happy Friday. Happy Friday, AG. Thanks for the update. Congratulations. CSI Canton Rob, why the prosecution O faces on the thumbnail? So the thumbnail of this case, the thumbnail for today wasn't O faces. It was demonstrating that literally everyone was screaming at each other. We have reached
With
the
their
point
O
in
faces.
trial with their O faces. We've reached the point in trial where people just be yelling and accusations are going left, right, center, everywhere. Everyone's being accused of something. Emily Hart, we will get to this. I will absolutely get to this. I haven't seen the motion, but supposedly the Commonwealth has asked for the text between Yannetti and Karen. It's just gossip right now, but I can see Brandon trying. He has filed that motion. That motion is in the docket. So I'm going to pull that up in a bit and go through that because it does bear some discussion. I have thoughts. A lot of you aren't going to like those thoughts, but we'll get to those when I'm still medium fresh, but after we get through some of the material. Okay, making sure I've got relevant stuff pulled up. Marvin CZ says, Runkle, I'm interested in GWAX. That's how I found you in LawTube in general. I'm looking forward to more coverage. There you go.
Well, there'll be more on it. The GWAX stuff doesn't always do the best because there's a lot of people who are like, why do I care about this? But I still cover it because I'm interested.
I like all the stuff.
And but I also need to do the coverage of this.
Yeah, that's worth some we'll call it mockery a little bit, but coverage. Jane Sanders, I'm just starting the stream from the beginning. Please make me laugh about this. Is everyone in Canton taking crazy pills? Survey says solid maybe.
I think that the people of Canton, their sweat is used to make crazy pills.
It might be. I don't know. Make it make sense. I don't know if I can make it make sense. I will try. We'll see. Calypso Vixen, so glad FNF and sorry for so many emails this week. There were a lot of filings, Calypso. So I do not hate the fact that you sent all those documents. Clueless, Closey, heads up, the new Badero letter drops tonight. So says Turtleboy's Twitter. I will try to take a look at that later. Marmar, I'll pull that up in a minute. In a bit. Patty Hoffman, catching up on this. Thoughts on Brennan going after Yannetti's conversation texts with Karen Reed between January 29, 2022 and February 2nd, 2022. Karen's legal team added the Commonwealth's witness list. Brennan's getting Turtleboy messages. He gets Turtleboy messages with Karen, not third parties or anybody else. But I will go through the rest of that stuff in short order. Promise.
I think Turtleboy says that he was using Signal with disappearing messages, so it's like, well, good luck.
They don't exist. They don't exist.
Yeah.
Julie is echoing the new Badero letter dropping tonight, according to Turtleboy. You got it. Billy's Momzilla, my son points out my ADHD, and I told him that Rob says is the superpower, and we laugh. It is a superpower. I can think about 10 things at one time, all the time.
It's just that you can't not.
No, I know. That's the part where the superpower isn't. Now, the superpower also is a superpower to hyper focus on things when I am very interested in them.
It's a little bit like Cyclops, where you've got the power to shoot lasers, but you don't have the power to not shoot lasers.
Kind of. Wow, that's actually a really good analogy. Like my eyes shoot lasers, but I can't turn it off. Yeah. Let's see. Strange credulity. I try to understand Hank is akin to attempting to play chess with a pigeon. He will just strut around, knocking pieces over and crapping on the board.
That is where pigeon business comes from.
That is the pigeon business part. Yep. Amy's positive pathways. Hey guys, working mental health field with all the stress this trial. Hope everyone is taking care and using self-care. Well, Amy, I echo that, and especially people who are very invested in the outcome of this trial. I think everyone needs to take a minute, touch some grass, and realize that this trial is impactful, but it is not something to tie your entire existence to. I got a back and forth with an individual on Twitter yesterday, and I was just trying to point something out. They took it like I was challenging their existence.
I mean, one of the funniest things I had recently was, so there was a bunch of people who were telling me that after, what's his name, Proctor was cleared, they were going to come back to my Twitter to tell me I told you so. They were like, I'll tell you, I'll be here to say I told you so.
No.
And anyway, they didn't show up.
Have they reappeared yet? I imagine they're still out somewhere, not appearing right now.
They have vanished into the wilderness.
Yeah, that seems par for the course. Blessed in Texas. Hey y'all, Ian, I was so ready to hear you say
I do have my flamethrower.
He does.
I just can't.
You just can't use it.
I got denied a burn ring permit.
Why?
Apparently, the burn piles I want to set fire to are too big.
So I mean, we can see logic in that judgment call, right? A little bit of it. No, not based on the proximity. Are y'all talking Baldonian lively? Not at the moment. There's too much to cover in Karen Reed, and my aptitude right now to track things when I've got trials and stuff going on is not really very expansive. Let's see. Oh, mispronounced name. Good point. I'd rather let the cops read my mind with a genuine telepath rather than hand over my phone. My memory is fuzzy. My phone is not.
Well, I mean, the other thing is your phone just contains so
Everything.
much. Like, it is so... and to a degree that, like, you would never put up with somebody, somebody tracking you to that degree. Like, if you had an ex who suddenly started monitoring your life, and they had sufficient things to monitor every place you'd been, every conversation you'd had, when you sat up, when you sat down, when you went to bed, who you might have gone to bed with, all of that sort of stuff. You would consider that to be extremely, extremely invasive, right? And we would actually expect that person to go to jail. But, like, the government goes, oh, I'm curious, I want to look in your phone, and you're like, oh, and then everyone's like, oh, no problem. Yeah, I put it this way. I had a client who I think might have been dealing drugs, but he was not convicted. And, one of the things was that his phone got destroyed in the process of him getting pulled over. And he happened to have a large drink, like a drink with and he also happened to have a few holes drilled in his phone, because normally your phone, like a lot of phones nowadays, are pretty waterproof. But he had several holes drilled in his phone so that it was not waterproof at all. And somehow, in the course of getting pulled over, his phone ended up in his drink and was ruined.
I'm shocked.
And the thing
I'm utterly shocked.
The thing is I'm like, it's not a bad idea. Like, and I'm not, engaged in like the sale or possession or anything of illegal anything, but just like the amount of shit on your phone, like, put it this way. The things I would do to get out of somebody sitting there and like going through a phone extraction, and I don't even do anything embarrassing.
I know it might be. I don't know that list has a real like. This is the end of that list of things I would do to prevent a full cloning.
They'd be sitting there like, so you sat at your desk for 16 hours. And I'd be like, yeah. They're like, so you got up to pee, and that's it. Yeah. You never made it to the kitchen to like eat? No, I was kind of in an ADHD zone. Like, just having that conversation would suck. Like,
well, it'd be really funny because they'd be like, you researched like how chickens eat food for 5 hours straight. Like, yep, I remember that rabbit hole. Yep, I very much do.
I have a similar one to this.
Bro, that I worked with agents. So you have to read. Emily says, I worked with agents who had a case where defendant's one door was lined with massive magnets that wiped all devices when they were collected during the raid of the house. That is exceedingly intelligent. Also,
I had one.
I don't hate the person.
I had one where it was actually set up with a giant electromagnet wired to the house wires on buttons that were beneath the computer. And so when they went to picked up his computer, they pick it up and they immediately gets sucked back down onto the thing. And they're like, what the hell? And
all the hard drives.
Oh, it didn't wipe, but the amount of corruption was substantial. And they're like, we can't do anything with this. It's just not, but he had it like right under under a thin layer of material, and it was like wired into his house wiring. So it had a lot of juice. And I'm just like, that is clever. That is industrious. And, yep.
Yeah.
My other favorite on that one is from a, it's not my story. It's another lawyer, but, so he had a client who had encryption on his computer and the government seized it. Now, what the government did was that they put a little hardware thing in there to monitor keystrokes. And their idea was that he would take the computer home, log in, enter his encryption key, and that would get recorded. And then they'd go and seize the computer again in a few days, and they'd go through it. So they return his computer to him, and saying like, "Oh, we didn't do anything. Everything is is fine," and so forth. And so the guy's like, "Okay," and he's like, "So this is not needed for evidence?" And they're like, "No, we don't have any charges against you because of course they're lying, right?" And he goes, "Great." And he pulls a hammer out of his bag and smashes it right in front of them and just like toasts the hard drive. And they're like, so they immediately arrest him. They immediately charge the guy for destruction of evidence. And he beats the charge because they said, we don't need this anymore. And so he's like, they said they didn't need it, so I didn't want it back. So smashy smash.
Emily's point is very well taken here. If you want to realize how scary it is to have someone's phone or have your phone searched, be an individual who has seen what gets pulled in those extractions. This is why law enforcement is very, very keen on not having their phone searched and very keen on kill switches. And so are attorneys. And so are people who are used to seeing these extractions. Once you see enough of these and see what gets it's recorded and logged.
The number of people who I've had to explain so part of the disclosure I've had here is like the pictures you took, and they're like, what? Oh, and I'm like, yeah, those ones.
Being in my field of domestic relations litigation, I wish I didn't see.
I had a guy
Half.
who they seized his phone because they thought it would have drug transactions on it. And the other thing that it had on it
Nope. I
was
know
a
what you're
lot of
saying.
him taking pictures
Uh-huh.
south of
We don't-
the border,
Mm-hmm.
including involved in various activities. And I was like, so I am required to tell you what's in the disclosure. There's a bunch of pictures. I don't think any of them are of evidentiary value except these ones. Here's pictures of drugs. But the rest of the pictures, do we have to go over those together? He's like, no. I'm like, thank you.
But so Emily, the funny story about this, but if you've never needed to unsee or probably the really boring work, funny story about this and this particular topic. We have very new associates, like brand new associates, just past the bar. And a couple of them are getting their first view of these discovery productions. And it is always interesting being someone who's practiced for as long as I have, kind of observing them as they make their first foray down this road of seeing the thing for the first time that they know they can never unsee. And then explaining to them and say, yeah, this happens quite a bit. So, buckle up, Buttercup. This is gonna keep on happening. And you don't really get used to it, but you become a little bit numb to some of the things. But to see that on the eye of a first year associate when they first open that file that they immediately regret opening is always something to behold.
Yep.
Yeah.
So.
Okay.
Yeah, there's there's things.
Let's get back on topic. That was a 30-minute foray down the road that we didn't think we would be on. There we go. All right, back to the motion. We're in front, sadly enough. Judge Cannoni, here we go.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed. Good morning, Ms. Little.
Good morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Unetti for Karen Reed.
Good morning, Ms. Giannetti. Good morning, Ms. Reed. All right, so we have a lot to cover this morning, but what I want to start with, I was just handed a couple of things too that I'm going to need some time to read.
To read, huh?
What I'd like to start with, it's paper 613 filed yesterday. Defendants assented to motion to continue trial date to a date on or after April 25th. Who's going to argue that? Because just because it's an assented to motion does not mean it's not likely going to happen. So I need to hear argument on why I should do this.
I know.
I'll address the court with court permission.
Yes.
As I indicated.
Let me go ahead and beat the punchline. To say that she was signposting what she was going to do,
Yeah.
she denies it. There were a lot of really good arguments made for why this thing should be continued. Very good, very persuasive, very strong arguments. Denied.
Also, can I say just how much I hate this? Because I have a Supreme Court factum I have to write. It has to get done. I have 60 days from the decision, which was issued March 6th. Which means that half of my writing time is during this trial.
That's going to be fun.
No, it's going to be I hate my life and
I
I want to, move into the woods and become a bear. I just, I hate that so much. So, yeah.
Hey, Warren. Glad to see you here, friend. Okay, well, like I said, very persuasive, very strong arguments for why the matter should be continued. First Circuit Court of Appeals has agreed to hear the matter of the habeas petition. Once the jury is sworn, jeopardy attaches. I mean, all very good arguments. Summarily denied. Now, I don't hate the basis of the denial. because it really is focused on kind of the judicial cost and the witness or the jury questionnaires having already gone out and getting that body of a veneer to come in and be interviewed. So you get it. You don't get it also because it was a damn good reason to be continued. But moving on.
The Commonwealth first, Your Honor.
Oh, it's defendant's motion. The Commonwealth opposed it.
You had
Wait,
asked
they-
who's arguing that for the Commonwealth.
They
I'm
opposed
sorry,
it?
defense motion.
Okay,
Okay,
that's fine.
sorry, I
He's-
apologize.
He says it's the defendant's motion. Commonwealth opposes it. Then she goes, "We'll start with Commonwealth."
I could go first if you'd like.
Excuse me?
And then they just go completely out of order, where we're going to hear the opposition first, and then we're going. It was very.
I could go first if you'd like, whatever.
I'm fine with him going first.
Okay.
I think the heart of this motion is that the defense would like to introduce the ARCCA witnesses as witnesses that were employed by the federal government.
We're going to go 1.5. I can't
I
take
think
his
the reason
timing.
for that is it creates the image or the projection that they are independent at the time they did their assessment, at the time they wrote the report, and then subsequently being employed by the defense has no impact on their objectivity at the time they did their investigation and report. I think this would be an unfair proposition for a number of reasons. It would undermine Rule 403. It would cause a trial within a trial. As we stand here today, the Commonwealth does not have a clear answer why
I'm
this
with you.
investigation was initiated, what the purpose of it truly was, the scope of it. We don't know every witness that may have gone before the grand jury. We do not know of all the communications between the federal government and different parties, including witnesses. We will, I expect, never have truly a full accounting of the relationship between the United States Attorney's Office and ARCCA and what, if any, impact the defense had on ARCCA witnesses at the time they did the investigation. What we know is it was a comprehensive investigation. We know that a number of experts were retained by the federal government, including the ARCCA witnesses. What we also know is
I don't like the
that
gray on
there
gray.
was an inquiry lodged by the defendant to the federal government to investigate her situation, her case. What we know is that the defense had the opportunity to provide information to the federal government advocating for their perspective on the case, including the specific perspective of Ms. Reed. We also know the Commonwealth was unaware of this initiation and engagement and had no.
Gee, it's almost like he's making an argument that someone had influence on the investigation. Isn't that strange? Wouldn't it be odd if people had influence on investigations? Wouldn't
Maybe
that be
somebody
kind of
who
improper?
might be found to have bias?
I don't know. But to say that an investigation went forward with people that probably shouldn't have had contact with the investigators because the investigation would go in a certain direction. But maybe that's just projecting. I don't know. Yeah. And this part is starting to really piss me off about Brennan.
Oh,
I'd
every time
welcome
he
ARCCA.
says,
I'd
like,
welcome ARCCA.
he's so disingenuous
them.
about that.
I want this. I want this. I want this. No,
Yeah,
you don't.
he's so
If you wanted it, you
disingenuous
wouldn't
every
file
time.
a motion.
Well, and he's
Sorry.
like, he keeps saying things like, I'm not trying to deny them their counsel. It's like, then, and the thing is if Bev actually had some spine,
She'd say,
Um,
all right, motion denied.
that's exactly what I'd be doing as a judge.
Right? Tell me you
I'm
haven't
not
been in
trying
front
to
of
deny
judges
them
like
their
that.
lawyer. You're not, Brennan? Sorry, are you confirming that you're not? Okay, motion denied.
Yeah,
Next.
tell me. So the other judge that we heard, tell me that other judge wouldn't immediately say that. Uh-huh.
Yeah.
He absolutely would.
Yep, it's just sorry. Okay, you're not, I'd welcome ARCCA. Cool. ARCCA's welcomed. You've consented. Done. Next issue.
Then why are we here? Counsel, why are we here? Why are we here?
Yeah. Or like, counsel, are you lying to me when you say you'd welcome them? Or
No,
Yeah, it just
we're not allowed to
annoys the
say,
heck
we're not
out of
allowed
me.
to say that anyone's lying anymore. We're not allowed to say that anyone's lying anymore, Ian. We
Except
got
she did.
everyone got scolded today. I know
Except
that.
she did.
I know that. I very much know that.
Had no input whatsoever. What we know is that the ARCCA witnesses were supposedly tasked to conduct an independent investigation, and they were given materials. We do not know who decided what materials to give them. We do not know what materials in totality they viewed. We know many of the materials that they weren't given. And so clearly there is a undefined relationship between the defense and the United States Attorney's Office around this time of this
There's
investigation.
an undefined
And we
relationship
subsequently
between the
learned that
defense
was a
and like
relationship.
Bozo
Everybody.
the Clown.
So to date, as we sit
Yeah.
here, we really don't know. What we know is ARCCA listed materials that they reviewed that came from our discovery.
ARCCA listed everything they reviewed. So
That we didn't provide. What we know is there was materials that they didn't review that were inculpatory. And so that's why we began by asking for discovery. We filed an extensive motion for discovery that the court allowed. It still hasn't been complied with. Perhaps some of it through no fault of the defense, because I don't think they will be able to comply with much of it. Other Rule 14 discovery obligations have not been complied with. We've received no information since that production on February 13th, nothing. And we know just inherently from that information that there is more. There are more communications, there's more interaction. And so it would be misleading to have ARCCA witnesses get on the stand and then suggest that they were independently hired by the federal government and all of their attempts and efforts and report was wholly and entirely objective. Just to give one point that emphasizes the concern, the ARCCA witnesses were never given information about DNA. And yet when they testified, one of the witnesses tried to address the issue of DNA because it was hurtful to their position. In their report, they say one of the reasons why they believe that there was no impact between the car and Mr. O'Keefe is because there was no DNA. Well, in fact, there was. There was DNA, and separately there was a hair, Mr. O'Keefe's hair. And so we know they didn't have all of the inculpatory information, and then the question still remains, how did they learn of that? How did they learn of that information before cross-examination? And so I think what is most appropriate before Your Honor makes a decision on the so-called objectivity of these witnesses is they should come into court before trial, well before trial, and they should answer questions about their directives.
Well before trial.
from the
It's
State's Attorney's Office. They should answer questions about the materials they received.
I know. You can go ahead.
There's like 8 minutes before the trial.
I know.
Like-
well before trial. Trial is, counsel, you say well before trial, 10 days. 10 days. Well before trial. How do you foresee this happening?
I mean, if it's Taco Tuesday, they've got enough time to take a poop before trial, and that's it. So
I mean, it depends on the tacos you're eating. It really does depend on the tacos you're eating and how much cheese is in them. I wouldn't really get ahead of that.
It's like, come on, well before trial.
Yeah.
They should answer questions about what they were told, what they knew about the case. They should answer questions about all of their correspondence with the defense, including phone calls, emails, text messages. All that should be produced. It's not a Lanigan hearing where I question their qualifications, but if we're truly going to think about presenting them as objective witnesses, they truly should be objective. And I think if we have an opportunity to question these witnesses, we will learn much more about the relationship. Inevitably, even if the ARCCA witnesses come in to be questioned as they should well before trial, in my opinion. We do not have the opportunity to question the United States Attorney's Office, who resigned to TUI letters, which inevitably have been
Yeah, good luck.
unhelpful.
Let me tell you
So,
how cooperative the feds
I
are.
think it sets a bad playing ground.
Yeah, the
for
feds
them
will
to
have sent
conduct
a
the
very
federal
nice
government, because then
PFO letter.
Commonwealth
Like,
will be
oh, that's
trying to
cute. You
explain
want information?
the inculpatory evidence, the role of the federal government, the limitations of the federal government, the fact that the federal government has closed this entire case in all related investigations, which implies something quite the opposite of what the defense would.
I'm not one to just cast aspersions on representations made in court, but I haven't seen. I don't know if that's true or not. I don't really care if it's true or not. But I mean, judging by like Aiden's there. Okay, there's Aiden in the background. I see him.
Yeah.
would like to propose.
He's got a
So
very
after
loud
the
tie,
case,
and I think
what the
that's on
court ultimately
purpose.
should do
Yeah.
Is they should present these witnesses as they did at the first trial. They were hired independently, and then subsequent to that, the defense retained them if that's what they chose to do. We still don't know that because we don't have any Rule 14 discovery. And
All right. That's this is the problem with that. I love this is we don't have any Rule 14 discovery. I love that. I'm really tired of this. I really am tired of this. It's not just casting aspersions. It's absolute statements. It's absolute statements of there's been nothing. And they'll say nothing. There's been nothing. And it's like, well, here's the thing. So I understand that you can get hyperbolic in argument. I do get that part. But there's a difference between like making a hyperbolic statement from time to time to emphasize an argument you are making, getting called on it and then correcting it, and making it during every single argument you make. And I'm really frustrated with it. So to say that he has no Rule 14 discovery, that was refuted by the very last argument we had in the very last motion where they said there's been this volume of information turned over. That, Mr. Brennan, is Rule 14 discovery. You might not have what you believe is complete Rule 14 discovery, but don't say, look right there, the transcript got it. Don't know that because we don't have any Rule 14 discovery. That is not correct. Yes, I can raise the court audio. Here we go. Something happened with the mics between the morning and afternoon. You couldn't hear Jack.
Inevitably, at trial, part of the credibility issue will be the information that they considered and the limitations on it, and ask them why they didn't ask for more information or why they didn't receive more information. Notably, we still don't have an answer to Mr. Klein, who was the third biomechanic person involved. And
Is his name on the witness list?
No.
I haven't seen it on the witness list.
No, Your Honor.
And we still don't know why the defense chose to call 2 of 3. As you noted,
Why does that matter? And how does that?
If you want him there, you call him.
You can call. They have told you they are free from their obligation.
that report is vague. And so it doesn't identify or articulate what.
Oh, this is cute.
What. So
This is cute. This is very cute. That report is vague. That report is vague. Hang on to that argument until we get the afternoon.
it's impossible for me to imagine how you would choose 2 of 3 of those witnesses. But more importantly, you can't effectively cross-examine a witness because, as we saw from the second witness, Dr. Rentschler, when he disputed DNA, which we don't know where the source of that came from, he is not held to the opinion in the report saying that we would have found DNA. He can simply defer and say that was somebody else. That could have been Mr. Klein, could have been Mr. Wolf. We don't know. So that report really is quite unhelpful. And I think we need answers to these questions before any of these witnesses testify. And I do not want to be moving during trial to exclude the defense witnesses for failure to comply, but we haven't seen compliance, and I don't think we will. So my suggestion is to follow the protocol of the last trial, but before that, these witnesses should be brought in so that we can obtain actual records, not just asking the questions and relying on their word. I think based on their past performances, that's insufficient. I think we should have a right to the records to demonstrate the relationship.
Ouch. Chrissy C. Brennan's website says Attorney Brennan personally handles all criminal matters and does not resign any portion of your case to an associate. This seems misleading, but on brand. I don't know that it's misleading. He makes every single argument on every single motion, and there is a consequence to that. What you will see.
He hasn't let Lally even get up out of his chair.
And this is creating a problem. And let me explain why it's creating a problem. There is a vast distinction between the arguments made by defense counsel and prosecution counsel. And it is in specific recitation of specific instances of conduct, fact, or evidence that is actually in dispute here. Brennan makes these arguments that are broad reaching arguments that would be, persuasive if you weren't a judge looking for specific facts to support the contention being made. Brennan doesn't point to anything specific. He just makes these broad assertions. There hasn't been any Rule 14 disclosures. The report is vague on its face. I can't have an effective cross-examination with this vague report. These are not actual statements. They are just sweeping generalities. And I think that that is in large part due to the fact that he's not sharing the load. There is, if he could point to one specific pin site within the statement, rather than a vague generality of the DNA. Tell me, Mr.
Sometimes
Brennan,
he's got pin sites.
But why is it so few and far in between? And why is it always in rebuttal? And why is it never indirect? Isn't that
I feel like he's got good rebuttal hustle where, like on rebuttal, he like frantically grabs that pin site.
the page, but he had it the whole time. What is he? So here's the other question about it. And I've done this too in trials where I will leave an entire section of information out of my direct examination, knowing that opposing counsel wants to go after that red meat. And they go in at it, and I have kept the best parts for my rebuttal, knowing that they can't resist it. And knowing that when I get my rebuttal, I get the last word. They can't say anything else in response. Now, in this courtroom, that doesn't fly that way because they're going back and forth on the issue. But
The problem
I don't
is if you
like
get a
the
smart lawyer,
generalities.
sometimes they'll just like sit down and you're like, oh, I don't get to rebut that now because they didn't bring it up.
And there have been times when that has happened where I've left that door open, but it's a risk reward thing. You know, when you're leaving that door open, they might not kick it, and you're going, all right, I can take that consequence if they don't. But if they do,
That's the thing,
ready
is you
with
got to
this.
be ready to live with your choice.
Thank you, Ron.
Your Honor, the Commonwealth and the defense certainly have opposite arguments when it comes to what the jury should be allowed to hear about how the ARCCA witnesses became involved in this case. Mr. Brennan speaks about the heart of our motion. The heart of our motion is that the Commonwealth wants to hide the truth from the jury. The defense wants the jury to know the truth. In the first trial, this court disallowed the ARCCA witnesses from testifying about who hired them. We were therefore forced to ask oblique questions, trying to show the jury that we didn't hire them, that we didn't provide them with information, that we didn't influence their opinions and conclusions. But we weren't allowed to tell the jury that the Department of Justice, the U.S. Attorney's Office, hired them. So the jury was left to speculate about how they became involved. I think the court will agree that it's ironic in a way that the court excluded mention of the Department of Justice and the U.S. Attorney's Office because the court rightly did not want the jury to speculate about a federal investigation. But
they speculated.
Mention of the federal government having retained
speculate.
ARCCA, the jury was left to speculate incorrectly about how they became involved.
They were also instructed more than once not to.
Yeah,
Okay.
and you know
This
what?
is
They were instructed more than once to not think of the pink elephant. Like, is this your first time hearing about a jury judge?
Yeah, I am instructed to brush my teeth for 2 minutes straight on all occasions. And I'm sorry, we're going through a toothbrush phase in the household with the kids. So that was the first thing that came to mind. There are various instructions that are given by a judge to a jury at all times, but there's a fucking practical reality that you understand that a jury is going to listen to maybe a tenth of it.
Yeah, maybe.
Speculate,
And
right?
but the point of the fact of the matter is, Your Honor, they did speculate. At least one juror thought that ARCCA was hired by Ms. Reed's car insurance or home insurance company, and think about the implications of that.
Which, to be honest, is not a bad speculation. Like if you're up there and you see and you don't have information of who they're hiring,
I thought that was
one
actually
juror's
a pretty clever guess.
That's pretty clever. Like that was pretty good, right? Like that's an astute juror.
If Ms. Reed's insurance company had hired ARCCA, they would have had a motive to absolve Ms. Reed of responsibility.
Can we pause here?
They clearly would have.
The thing is they would and they wouldn't, because
They
a lot
wouldn't.
of the time insurance won't pay out if you
If it's
are
intentional.
like if it's an intentional homicide. So actually, like, the jury got it
you
partially
can see
right
how
on
it-
their guessing. But yeah, I mean, if they thought, I mean, I would never want my insurance company investigating here because they'd be like, 1, she was drunk. 2, was an intentional homicide, and 3, it was an act of God, and
They would be
all
looking
the reasons
for-
why we
no,
don't have to
Ian,
pay.
You forgot. Or it was snowing. The most easily provable fact.
But the thing is, the insurance probably still has to pay even if it's snowing. So yeah.
This one is it was astute of the juror to get there, but the juror wasn't as informed enough to get all the way to the final conclusion. The layperson viewing the insurance, that's a logical conclusion. But only lawyers and several other, like a couple other people, are going to be able to go further and say, no, it wouldn't be, because the insurance would be motivated to find this.
Yeah, and that's the thing, is the jury was partially clever and partially dumb, and that is exactly what you would expect from a jury, right? So,
Yep.
yeah.
That clearly would have adversely affected their credibility in the eyes of the jury, and unfairly so.
Let me ask you a question. If I allow, and I'd be very surprised if I did, mention that this was a federal grand jury and that the federal, how does that not open the door to all of the...
I think it does. I think this is the biggest problem with the defense's argument here.
Opening the door to what, though?
Well, and that's the question. How far does mentioning the initial hiring require the ability to respond?
I mean, I might say, if I was the Commonwealth, I'd say let them mention the hiring, and let us mention that that they were clear.
Investigation closed.
Yep, that the investigation didn't.
But Unetti does. But Unetti doesn't want that, and I'm with this one here. It's once you allow one statement to be made, there's other stuff that comes in too. But again, I don't think Unetti has to push as hard on the investigation closing without anything else being done. I mean, okay, does the investigation closing mean that? I mean, clearly they listened to the information and the investigation, but the thing is, no one wants to get to the crux of the issue. The investigation being the investigation of the investigation.
Well, and here's the other thing. Let's say they do say that there was a FBI investigation, right? What's the jury gonna think? The jury's gonna think, "Oh shit, she is the most serious criminal ever," and they might think like, "Oh, did she try to did she try to kill the president or something?"
Yeah, you don't know, because you hear the feds are investigating. You're going, "Oh my god, this person's terrible. They're a monster. I should look at this more." I don't know. I mean, here's the other challenge about it. Technically speaking, and this is where I kind of agree with Judge Bev on the ARCCA and being able to say whether or not they were hired by a third party. Technically speaking, Karen Reed could have paid for a third party to do their own reconstruction and do all of the other material and do all of that separately, right? They either chose or opted to. I mean, chose or... I can't really, given the financial cost paid for other experts in the case, I can't really fathom that it was a financial constraint as to why they didn't hire independently accident reconstructionists. I
kind of feel like they had this beautiful
option
assessment drop in their lap.
They did.
And they're like, why not use this, right?
And they had the added smokescreen of, quite candidly, if I'm a lawyer and my argument in response to reciprocal discovery is, "Judge, I can't because it's federal."
Yeah, there is that.
I like being able to make that argument.
Well, I do. Also just the thing of, defraying the usual question of, so how much did you pay for this opinion? And I personally think that one should be a question that should maybe automatically come with a jury instruction, because it actually weighs very heavily for the state. Why? Because the state just has hired people, a lot of their experts are just on staff.
Salary. Right? They're on salary. The ME.
So you can't ask how much did you pay for this, because it's just well, I just get my regular salary. But the thing is that's still an issue, because their regular salary means they have to keep the job, right? But the defense, it always, so you've got the prosecution experts who stand up and there's it's just oh, I just get my regular salary. But the defense experts, it's always well, I got paid, $50,000 or whatever. And, then that's it tips the scale for the prosecution. Now, I mean, in a civil case, fine. Both sides are going to be paying their own experts and so forth. But I'm I don't like it in this setting.
Interesting question raised, Hale. Hail to the Redskins. ARCCA was hired by DOJ. They have no standing to opine on DOJ investigation. Yes or no? No. You cannot enter the mind of the prosecutor and give an opinion as to why an investigation stopped, terminated, went forward, how it proceeded. You can't go in their minds. Cases get dismissed, dropped, investigations drop off and fall off the edge, or result in charges or no charges based on any number of circumstances.
I mean,
yeah.
A lot of the time it's just we didn't get any evidence.
Or it's a judgment call. It's a judgment call that says we got some, but we can't. I don't think I can prove it beyond a reasonable doubt. Or I can prove it beyond a reasonable doubt, but it doesn't feel like the right outcome.
If you ever see investigations into like organized crime stuff, that's like,
oh,
we
yeah.
talked to 600 people. There was a guy in Vancouver. He was like a mob figure, very well-known gangster. He was shot in a nightclub. When like the nightclub was packed, everybody there denied seeing anything. Nobody saw anything in this packed nightclub as a guy comes up and, taps this guy in the back of the head. And it's like, so, the investigation ends with, well, we got nothing and we're not going to be able to proceed. And it's not because like that this guy's head just exploded for no reason, or that it was some sort of like random, like, accident or something. It was clearly a homicide. There was clearly someone who did it. It's just nobody's willing to talk about it because gangsters. So,
and
yeah.
Dr. Tracy, I'm going to push back a little bit. Judge Bev didn't say you can't, but you won't. She said you can't comply. You can't comply, but you haven't. That's a very big distinction. Won't implies that there was a voluntary decision being made, that you decided not to. Haven't is that whether through some decision that you made or some decision that's outside your control, there hasn't been compliance. And that allows the court to fashion a remedy. The remedy that the court has fashioned in that regard is a voir dire, the ability to ask questions of these witnesses before they take the stand. In retrospect, having reviewed kind of where we are in this case, I don't hate that. I don't. If there is something statutory that says information must be turned over, and it's not, even if you can't, if it says must, you have to, if you want to call the witness. If the court fashions a remedy, the remedy is voir dire. Okay, we get the information via some other source, namely that witness on the stand. So that is a little bit, that's one of Bev's fairer choices.
Yeah.
Testimony that Mr. Brennan just brought up that he'd be able to get into.
Okay, so first of all, and this is later in my argument, we're not asking.
So no, could you answer that now and then? I'll let you say
trying to, Your Honor.
Oh, you just said it's late. Hold on.
I want to slow this down because I heard this at 2 times speed when I was listening to this playing catch up.
You just said it's later in the.
Now, I'm going to make full disclosure here for me. Full disclosure for me. Of the attorneys in the courtroom, grand totality of all the attorneys in the courtroom, there are certain styles that I like and certain styles that I don't. I will say that Brennan is number one in the style I don't like, followed by Lolly.
I would say Lolly is number one in the styles I don't like because Lolly's
arguments were not as disingenuous. Lolly's arguments were not as
I have attention deficit. Lolly is like, oh my God, he is, attention deficit torture because you're just sitting there going, get to an idea, like get to something. I need stimulation. I don't need to hear about the snow again.
I know.
So
on the defense side, and this is me calling things the way I feel, the way I see it, Yannetti's always driven me nuts. Always driven me nuts. He's the first one to go to hyperbolic extremes on the defense team.
Oh, he's bombastic as heck.
He's bombastic. He's all over the place. He drives me nuts. I can't. So
Did you
I
see
do
him
get-
telegraphing his plans for what he's going to do on direct next time or on open next
No,
time?
I'm at the very end. Yeah, I did. I don't think he's doing opening statements. He's not doing opening statements. They actually confirmed that he's not handling opening statements.
Yeah,
But
and that it's not going to be Karen Reed was framed.
as the first statement out of the gate, yeah, Yannetti for me is always the more bombastic, and the Jackson but Jackson picks his moments. Yannetti is always at that level. It is like Yannetti comes in to make an argument. It's a very simple argument, and then all of a sudden you're getting everything. And you're like, okay, all right, here we go. Pump the brakes. Why don't we take it down to here? But it's with every motion. Hank Brennan's the same thing, but as far as on the defense team, if I had to pick a lawyer that I didn't like the style, yeah. Oh, this is terrible. I'm singing in my head, Mr. Bombastic.
How does that not open?
My favorite is Alessi.
Dismiss.
Oh no,
Judge Doolin
dang
basically.
it! No, what did I do? Hang on. I'm sorry. I was going to hit one screen. I hit the other. Hang on. No. Association. Nope. We were before this. I hit, and it just so happened to hit right on the stupid slider. All right, we're just gonna have to deal with it. Oh, that's so annoying.
I don't think anybody actually alleges that we're professionals.
Solid burn, though. Fun fact, Rob is allegedly a professional. I am just not a professional streamer. Oh, yeah. Some people love it. Some people very much love Yannetti. You know what? Maybe that's the karma I just put out in the world. Maybe I put out the karma of talking trash. And it was like, all right, we're going to make you hit the slide bar. All right.
The potential juror's answer, which that juror is giving under oath on the form itself.
Oh, now we're at the jury questionnaire. Dang it.
And that creates an enormous amount of social media and media.
Rightly did not want the jury to speculate.
Here we go. Hang on, sorry.
Know the truth. In the first trial, this court disallowed the ARCCA witnesses from testifying about who hired them. Told the jury that we influenced their opinions and conclusions, but we weren't allowed to tell the jury that the Department of Justice, the U.S. Attorney's Office, hired them. So the jury was left to speculate about how they became involved. I think the court will agree that it's ironic in a way that the court excluded mention of the Department of Justice and the U.S. Attorney's Office because the court rightly did not want the jury to speculate about a federal investigation. But by excluding mention of the federal government having retained ARCCA, the jury was left to speculate incorrectly about how they became involved.
They were also instructed more than once not to speculate.
And
right?
but the point of the fact of the matter is, Your Honor, they did speculate. At least one juror thought that ARCCA was hired by Ms. Reed's car insurance or home insurance company. And think about the implications of that. If Ms. Reed's insurance company had hired ARCCA, they would have had a motive to absolve Ms. Reed of responsibility. That clearly would have adversely affected their credibility in the eyes of the jury, and unfairly so.
Let me ask you a question. If I allow, and I'd be very surprised if I did, mention that this was a federal grand jury and that the federal, how does that not open the door to all the testimony that Mr. Brennan just brought up that he'd be able to get into?
Okay, so first of all, and this is later in my argument, we're not asking.
So could you answer that now, and then I'll let you say everything.
Your Honor.
Oh, you just said it's late. Hold on, you just said it's later in the argument.
I know, but
All right, now I'm getting back. Now I got to go back to real time. And now I got to go back to real time because I wanted to hear this. Yeah, go ahead.
I just did the Bev side, but she hates all of the pushback and so forth. So,
But it's
Yeah,
the
I
passive
don't-
aggressive. It's the passive aggressive. It's not the. Well, I forget what the other judge's name was, but the other
they
judge
just
would have.
really do not mesh well together.
No, these two have always talked past each other, always.
Yeah.
And it's these two. It is Yannetti and it is Bev. It is those two more than anybody else. Jackson will get headway. Jackson will make arguments. Yannetti is always on the wrong side of the coin when it comes to Judge Bev, and I don't always fault one person in that dialogue. Sometimes for me, I'm looking at the lawyer and I'm saying, here's the thing. If the judge is jumping down your throat and based on the style of your argument, why don't you change the style? Like,
That's
why
the
don't
thing
you,
is you've got to adapt.
you have
and-
to. Alessi, God bless him, has completely changed a little bit
Oh,
as the
Alessi
motions
can
have gone
pivot.
on.
Alessi can pivot, and I love to see Alessi. Like, you can watch him pivoting and trying different things as he gets pushback. Jackson and Yannetti, both of them are bad at pivoting. And yeah.
Exactly. Emily, this is
Yeah.
1000% the point. Let me give you an example. Here's a really good example based on a trial I just had. I had a witness that I had done a full day of prep for. This is a witness they were trying to bring in as an expert, a psychologist to testify as to the mind and mental state of a child. And I had done a full day of prep to cross the ever-living hell out of this witness. I was going in ruthlessly and had all of my notes pulled up and was completely prepared to do that. The first time that I objected, the judge shot down my objection so fast that it completely gave me a different perspective on how the judge would read the cross-examination I had fully prepared. And I mean, that judge shot down that objection to the point where it was defensive of the witness testifying. So I was going, oh shit, if I go at this witness, I'm going to alienate the judge. I had to, on the fly, after a full day of prep, throw every single note I had out the window and turn that cross-examination into a co-opting of this witness. I had to make this witness my friend. I had to completely change persona, personality, tone, questions, words, all of the above within about a 30-second window. That's what lawyers have to do. You have to adapt. Ian, you get a judge who's fighting you back.
I mean, I've had things where you go in and the judge says you can't do this, and you're like, well, it was my plan, so either you have to try to work around that, or you just have to figure out a way to roll with it. And honestly, rolling with it is going to be the much better way if you can do it. So, yeah. There's a judge who never wants to hear that anything bad about the police. And so, I mean, that really sucks if your defense is like that your client was beaten. But like, let's say you have something where you're on sentencing and you were going to argue that, the police treatment of your client wasn't enough to throw the charges out, but was still bad, and that your client should be given a break on sentence. Well, if that's the judge who comes out for sentencing, you drop that, right? You do not argue it. In fact, you might say something like, the police had a difficult scenario, situation here, and, because of that, there were some tense moments, but he takes responsibility for his actions. He takes responsibility for what happened here, and your client's going to get a better result from you doing that. You got to know what the judge is there, and yeah.
Here's the other challenge. Momo Shark. Sometimes I feel like you need to push back. Sometimes yes. Sometimes, and you have to pick how you push back. Some judges will view the pushback as inherently insulting, and you have to find a way to cushion that blow. And this is where you see Alessi. Alessi has searched for the right way to be a smartass in front of this judge. Let's call it what it is, right? He has searched for the right way to smooth talk Judge Beth, and the tone changes a little bit every time.
There's also two judges I know of, or I'm not going to name any of them because I might have to appear in front of them, but where even if they think you're right, they will still ask you tough questions. And the reason why is they want to know that you know that you're right and that you are like not right by accident.
Yep.
But they also want to test your argument. So if they're like, well, I think you're right, they'll still hit you with questions on it because in part they're like, I think you're right, but I want to check, right? And I want to see if you're going to fall on your face when I push on it.
Mm-hmm.
And so I've seen lawyers in front of that, in front of these judges get really upset because they're getting pushback. And it's like, no, with this judge, when you're getting pushback, you're winning.
And this is also why you need to hire lawyers that know the courtroom you're in, or that know the court you're in.
And if that particular, if there's one in particular I'm thinking of more than the other, which is why I keep saying that one. But if they think that you are making an argument that is stupid, then they don't get interested enough to ask you questions. So if you're in front of that judge and you get no questions whatsoever, it's because they don't think your argument is interesting enough to pick at. And so it means you're going to lose. And a lot of people don't realize that, where the judge is kind of nodding along, all that judge means is that they're just waiting for you to shut up.
Uh-huh.
And once you shut up, they will just rule against you. So
there's a judge in Fairfax I used to hate. I now love this judge. I mean, debatable, but this judge was one that had always given me a bit of a headache, but I learned how to deal with this judge. And I had a case where we walked into court and then all of a sudden the courtroom got changed. And the client looks at me and I'm scrambling. And the client is going, what is going on? And I was like, I need to find all of my statutory authority and case law. They're like, why? And I was like, because this judge is going to ask me 9 million questions, even though he knows I'm right. Like,
the other thing is, when I was a new lawyer, there were certain judges where I'd walk in, see that lawyer, and immediately walk out again because I needed to have better notes. Because they'd ask you things like, you'd go in, you'd be like, my client is here to speak to bail, Your Honor. And he'd be like, counsel, which section is it that grants you the authority to speak to bail today? And the thing is
exactly.
Everyone knows I can speak to bail today, right? This is not a thing. It's just that because it's a new, because you're a new lawyer, they want to test you on random stuff.
And fix tech issues. Give me 1 second.
Oh yeah, no worries. So they'll ask you questions like, oh, counsel, which section is it that says, what the test is for whether your client can get a conditional discharge? And you'd be like, well, here's the section, but really those criteria are set out in this case. And so, that's where we get most of the explanation of what these sections mean, Your Honor. And here's the test. And if you're not ready to give them that test, then you will get, and the thing is nobody ever will ask you that again in your career. I've never had anybody ask me, what section is it that allows me to speak to bail since then. They just want to know, are you with it or are you kind of dumb or what's the deal there?
Yeah.
So,
and it's not that they're actually going to rule against you. They actually might still rule for you. But what they're doing is they're measuring you. They're trying to
a lot of it is that they plan to rule for you. It's just, why are they going to rule for you, right? So, yeah.
And but this also gets back to the point that the chat has been making overwhelmingly, is that in this case, I tend to agree with the chat that I would look, if Bev was ruling in favor of the defense more consistently, then I would give more latitude for the cutting off and the arguments and the what's the authority. But
if she cut off everybody, that would be one thing. But she very much leans
not. Example: Judge 1, the first judge from the Carney case. That judge, he cut everybody off.
You can sometimes turn that into an appeal ground on the basis of the judge treated me differently than they treated the other side. But you have to be really careful.
You know how she gets around that?
How's that?
Under advisement for everything. Everything is under.
I'm just thinking of a particular appeal decision where they were arguing, here, the lawyer was arguing that because the judge kept cutting them off, that the judge was biased against them. And you know what the appeals court ruled?
It's a tough sell, Ian. How'd they rule in this one?
They said the judge kept interrupting you and questioning your positions because your positions were dumber than the other side.
And,
so
there's that. That happened.
The appeals court was like, yep, you got interrupted a lot because they just didn't know why you would say the things you were saying, and they were stupid. And I'm just like, okay, so they successfully managed to get a decision that says they are big dumb.
Yeah. So this is why I wanted to catch up. I wanted to kind of back up on this one because I wanted to see what Yannetti was doing leading up to this. Because of course I heard the shot heard around the courtroom, but I haven't replayed it in real time.
My client, and it's the opposite of the truth. There was another juror that speculated that the ARCCA witnesses were just attention seekers, looking to make a name for themselves in a high-profile case. That's also the furthest thing from the truth. They had never heard of this case before the Department of Justice called it. That's how the Department of Justice wanted it. They wanted clean experts who would take a sober and...
See, this is...
As opposed to taking a drunken look at things, which is the job of the Canton Police Department.
But I like that Yannetti is now capable of apparently understanding what the Department of Justice wanted, their desires, their intimate understandings.
Strictly scientific look at the evidence. The federal prosecutors did not want them to be tainted by news reports or opinion pieces. And recall that the Commonwealth attacked ARCCA on cross-examination for the discovery that they were not provided. That was patently unfair. ARCCA should have been allowed to explain why they were given what they were given and who gave it to them. The inference is, and the Commonwealth suggested, that it was the defense that was playing hide the ball. When that inference is, again, the furthest thing from the truth. In terms of the information that the federal government got, Mr. Brennan engages in a ton of speculation about what.
Did I pass him getting cut off?
I mean, it'll happen again.
I think I did. Hang on, where was he?
Would have adversely affected their credibility in the eyes of the jury, and unfairly so.
Let me ask you a question. If I allow, and I'd be very surprised if I did mention that this was a federal grand jury and that the federal, how does that not open the door to all the testimony that Mr. Brennan just brought up that he'd be able to get into?
Okay, so first of all, and this is later in my argument, we're not asking.
So no, could you answer that now and then? I'll let you say everything.
To, Your Honor.
Oh, you just said it's late. Hold on, you just said it's later in the argument.
I know, but I said you interrupted me, and I was just about to say, but I'll address it now.
Okay.
Oh, woohoo! Wow. Go Yannetti. I wouldn't have the balls to do that. To college judge, you just interrupted me and I was gonna do it just now. That's a getter. Wow.
Yeah, it's a risky move though, because this could end with him getting like absolutely dragged onto the
No, but he does. He pushes back. It's way to go. Like, way to go. That's a move. That is.
Yeah, it's just you gotta take some risks with it, because and
I would not have the balls to do that. I would not have had the balls to do that. I can tell you that right now.
And the thing is that sometimes the pissing the judge off is also the smart move.
That was
if you've got a judge who might give you appeal grounds. But somebody in chat called it. Look at Turtleboy.
Yeah, I was gonna say, look at my pause game. Look at the pause game.
Look at Turtleboy.
Crap. I'm not the only one that was surprised by that. I was
also look at the person just above Yannetti's arm.
And
all
of them are looking at the judge and how the judge is going to respond to this. Every one of them. Everyone is so two people on the right are looking at Yannetti going, holy shit, did he just say it? And the two people on the left looking at the judge says, yeah, he just said it. What's she gonna do? Wow.
Yeah, is this about to turn into something epic?
Are we about to get a bailiff in here for not the right reason? But yeah, everyone is kind of, that's a big pushback. That's a big pushback.
I mean, the thing is every defense lawyer at some point in their career will have to make a decision about whether they're willing to leave out the back door. And if the answer to that is no, you might need to pick a different profession, because sometimes it comes down to you gotta be willing to make that call.
Yeah, and I will say there's no attorney on the defense team that I don't feel is not willing to do that, and I will say that chief among them might be Yannetti, who I
kind of feel like Yannetti might have already done it before.
He might have. I criticize him for the hyperbolic statements, but he also gives me the impression that he'll do a night in jail or a couple. He'll happily do it.
I mean, one of the I see transactional attorneys do not have to make that call. That is true. So I've got a couple of things I would love to. One of the things I'm planning on doing, I think, is so in my local jurisdiction, there has been this push to say that that accused people sometimes they'll put on conditions that they must carry a copy of their release order, which can be in either electronic or paper, edition. Now the thing is that that's kind of a trap, right? Because either you got to carry around this piece of paper that you're going to lose and that ends up getting just destroyed because, you've got some homeless guy who's carrying around a copy of their release conditions and, it gets destroyed in the rain and whatever else. But the other thing that happens is, and they say, and you must produce it on request. So what happens is you get people who put it on their cell phone, and then when the cop says, hey, you've got these conditions, I need to see, because they don't actually know that you have that term to produce it on request until after they've already figured out who you are and what your bail conditions are. So it's a stupid condition. But what they'll use it for is they'll say, you have a condition that says you have to show me your bail documents. And then the person gives over their phone unlocked to that bail documents thing. And what does the police officer do? Well, they promptly go and start digging through it for every other bit of information that they can find, because now they're holding an unlocked phone. So what I want to do is buy a whole bunch of branded USB keys. Just like this, but just with the Runkle of the Bailey brand. And when then they could be given out to every accused who gets that condition with their release conditions on it. And then when the officer goes, you need to give me your release conditions on which can be in electronic or whatever form. They go, here you go.
Yep.
And then here's the choice the officers got to make. Some sketchy MF has just handed them a USB key, which is the most dangerous thing.
You know what?
If you don't know the history of it to put into your computer.
You know what?
And then they have to
RFID.
decide, am I going to stick this into my work computer today?
Use an NFC. Reprogram the NFC. Like a little RFID chip. Like just reprogram it. Be like, here, officer, give me your phone.
I mean, this is the funnier way because it's just, hey, officer, you can plug this in if you want. And any officer who has half a brain will be like,
No.
nah, I'm good. The other thing that might be really funny, QR code might be funny. The other thing I thought would be hilarious would be to get it in like some like format that is not commonly used, like zip disk. Or the
Oh my
really
God.
fun thing would be to print
3.5 inch
Laserdiscs.
floppy, or just do a 3.5 inch floppy.
Exactly. It's like, here you go. And it's like, well, it's in electronic format. Here's the 3.5 inch floppy drive. And then just be like, how?
Mhm.
Like,
Yeah.
okay. Just be like, okay, let's mess with this. So,
Yeah.
but that is the kind of thing that will get me yelled at by a court. And I'm okay with that.
Okay. So back to Laura's point. So does the judge respond? Because we've been in this pause mode for 10 minutes as we've argued about or gone on tangents.
You
You say
trying to,
everything.
Your Honor.
Oh,
if-
you
if-
just
if
said
I
it's
could-
late. Hold on. You just said it's later in the
I
argument.
know, but I said, you interrupted me and I was just about to say, but I'll address it now.
Okay.
We are not asking that the jury be told that there is or ever was a federal investigation. That phrase, federal investigation, never has to be part of this trial. We're only asking that they be told that the Department of Justice or the U.S. Attorney's Office hired these witnesses. That's it. We don't have
And
to
that's
speculate
reasonable.
about an investigation, whether there was an investigation, whether there was a federal grand jury, what that grand
I think the Commonwealth can go into a little more of that. I think
Do they want
you guys,
to, though?
yeah. I by the way, I did watch the entire first trial. I have seen them go back and forth. I really have. I just think that even your job is to keep going back and forth and keep changing. But yeah,
Yeah.
I don't know that the Commonwealth wants that information in. So if I'm Yannetti, I almost would have taken a different approach here and said, fine, let them get into it. Sure, let's go down this road. Let's walk down this road. You want to do it? Let's do it. But then the argument is that you're a trial within a trial. You know, Bev's call here isn't the worst
grand
call.
jury did, what that grand jury considered, nothing. That's not what we're asking. And the problem here is that without knowing that the Department of Justice or the U.S. Attorney's Office retained ARCCA, the jury's left to speculate about how they became involved, and it all inures to my clients, to prejudice my client. Thinking that they were potentially hired by an insurance company of Ms. Reed really perverts the truth in this case. It's unfair to my client, and it's the opposite of the truth. There was another juror that speculated that the ARCCA witnesses were just attention seekers, looking to make a name for themselves in a high-profile case. That's also the furthest thing from the truth. They had never heard of this case before the Department of Justice called them. That's how the Department of Justice wanted it. They wanted clean experts who would take a sober and strictly scientific look at the evidence. The federal prosecutors did not want them to be tainted by news reports or opinion pieces. And recall,
Here's a very good question, though, on the part of the Commonwealth that I would ask. If that is in fact the case, did you have any opportunity to provide the ARCCA experts with information of your own selection? And if that's the case, then I think that actually contests a lot of your argument. Like I said, I don't think this is the big ticket.
I think it helps them a lot if they can make this happen. So I would be
If they
pushing for
can,
it.
I would be pushing for it. I see why they're pushing for it.
I mean, 100%. I was like, I expect to see them make this motion, and I was
You
happy
also
to see it.
you're happy to see the motion made. I also think you're actually viewing this, that the likelihood of this motion being granted is,
And if it isn't, then you just add it to your appeal grounds, because
and
at the end of the
move
day, you
forward.
say, like, she knew that there was a real risk of, you know, a real
Confusion.
risk of bias here. So,
Confusion.
Yep. And she chose to proceed with it anyway. So that's, you know, she has made that call. I mean, to a certain extent, they kind of, like, she is really building this up to, you know, to a conviction.
So,
And I think that they need to get as many appeal grounds on this as they possibly can, because
they need to. But
need
here's the thing. No, Ashley, and you guys in the chat, I understand that. I understand that he gives them everything. The challenge is that because of the position and because of the angle the feds approached this as investigating the investigation, which is what we're speculating, that the feds were investigating the investigation, right? The feds were getting information from everyone except for the Commonwealth, because they were investigating the investigation. So they were getting information, and the United States gave them the whole file. Okay. Which included parts, but not all of the Commonwealth's discovery, which I'll give the Commonwealth that. But it also created a situation where the Commonwealth couldn't provide information, narrative, or otherwise of their own. So there is a part here where you're looking at this as being this entirely unbiased and unpersuaded investigation that aimed in a certain direction and wanting to be able to portray that to the jury. I get it, but I can also get the counter argument that it might be misleading to phrase it as such, if there's a avenue that the feds get information from one side but not the other. So no, and
I
the
mean,
thing is, the
feds
Commonwealth
not have
the
access
Commonwealth,
to, like,
not at the initial stages.
Wouldn't they have access to the evidence that the Commonwealth collected?
No. Why? They would have to subpoena it from the Commonwealth, which puts them on notice, which is what the feds are trying to avoid. Why would the feds
Didn't
put the Commonwealth on
know
notice?
there was a federal investigation
At
here?
some point, do we know when? I don't know the answer to that question.
I thought it was, you know, early in the process, but I could be wrong.
Either way, if there is an ounce of truth to that there was an avenue for the defense to give information, but the prosecution didn't have a similar avenue. Look, this one to me is a big ticket item for the defense, and I see why they want to make it. I also see why Bev doesn't want the feds mentioned in any regard. I think that creates a challenge for the defense, but the defense also had the option of hiring an independent investigator of their own that they would then have to say in front of the jury that they paid for this person. So you have a strategy call made by the defense to opt for the feds, who did this investigation remarkably thoroughly, but then also trying to play a little game of hiding behind the smokescreen the feds give, because there's no a way of getting disclosure. They did this. They reached the conclusion we wanted. We can portray them as being independent. When the option that the defense had was to hire an independent or hire an investigator of their own or a reconstructionist of their own to provide that information to the jury. One of those avenues has the potential of being, at least in some part, misleading. I don't know. I see both sides of this argument. I do. That's me calling it. If my timeline is flawed, it's flawed. But that's me calling it how I see it right now, based on my interpretation of it. Is that if you limit the information going to the jury that it was the feds hired these individuals, I don't think you can do that without allowing the Commonwealth to cross-examine and open the scope a little bit to going, well, what was the scope of the hiring? What were they tasked with doing? What information, from whom did they get it? I think there's a way where if you open that door, I don't know how you close it and how you create a framework around it where you're not allowing people to go down and get additional information. That might be a way. No one, I mean, this might be a way where they can get around it. And they did this in the first trial, by the way. Mary Lou Crafts asked the question: Can they question and say no insurance for Ms. Reed hired you? They tried to do it in the first trial.
The thing is the more questions they ask like that,
the
more the jury's gonna speculate. Because if they're gonna be like, "Did insurance hire you?" No. Did this hire you? They're gonna be like, they're gonna tell, like, the jury's gonna hear it's really important that you know who hired them. But for some reason, defense is playing hide the football here. And so they're going to be sitting there speculating extra hard.
So the more you ask questions trying to narrow down the scope of what it is that they did or did not do, the more you're begging the question of, well, why don't we have the actual information? This to me is a catch-22 for a judge. That personally, if I'm a judge, I don't know how to make this call. I don't. So, and let me concede the point. Even if my timeline is completely wrong, even if all of the other stuff that you're talking about is all right, I still don't know how I make this call.
That the Commonwealth attacked ARCCA on cross-examination for the discovery that they were not provided. That was patently unfair. ARCCA should have been allowed to explain why they were given what they were given and who gave it to them. The inference is, and the Commonwealth suggested, that it was the defense that was playing hide the ball, when that inference is, again, the furthest thing from the truth. In terms of the information that the federal government got, Mr. Brennan engages in a ton of speculation about what happened or didn't happen based on nothing. There's no affidavit to establish any of that. I will tell the court that I received a subpoena for my entire file from the federal government, and I complied with that subpoena. We had nothing to hide. We provided everything that the Commonwealth provided to us, to the federal government. They chose what to give ARCCA or what not to give ARCCA, and they did that again to preserve the scientific integrity of their opinion. So, again, we're just asking that ARCCA should be allowed to testify that they were hired by the federal government to prevent speculation about who hired them or why they became involved in the case. If the issue is we don't want the jury to speculate, the way to do that is to tell them the truth. We did not hire them. We did not influence their opinions. We didn't even know that they existed until that TUI request was complied with. And all of a sudden it was revealed to us that the federal government had hired these ARCCA witnesses. And we read that information at the very same time that the Commonwealth read that information. Those witnesses, importantly, were available to be called by both sides. The Commonwealth chose not to speak to them. The Commonwealth chose not to contact them because the information was exculpatory. The jury should not be left with the impression that Karen Reed or the defense team had anything to do with hiring them or with their conclusions and opinions.
There's a caveat to that with Mr. United's argument. Momo Shark asks, is defense required to pay ARCCA for their testimony expenses now? Yeah, they're no longer part of the Fed. They're no longer, yes. So there's a caveat. Everything that Mr. United is saying right now is and could be true for the initial hiring. But it is absolutely and unequivocally fair game for the prosecution to get up and ask questions about the fact that they were paid after that first trial for testimony that was presented, the fact they were being paid there at that moment in time. And then the defense would get back up and rebuttal and say, but we didn't pay you at any point in time prior to your conclusions being reached, right? That would be the back and forth. But yes, it is 100% fair game for the prosecution to get into the payments being made. And yeah, these ARCCA witnesses would be paid by the defense for their travel, transportation, and testimony at this trial.
The conclusions and opinions were revealed to us at the same time, and the court should guard against rank speculation. Mr. Brennan's other arguments about what they were provided or what the relationship was or what the understanding was, that's all cross-examination material. He's free to explore whatever he wants on cross-examination.
Yep.
So with that, Your Honor, we would ask the court to issue a ruling that does not mislead the jury about how ARCCA came into the case.
Okay. Any follow-up?
Yes.
See, that argument's not going to ask the judge to issue a ruling that would not mislead the jury. The inference is that the judge's ruling, contrary to your position, is going to be misleading. You get pretty dicey with an argument that ends on that note. That's just me observing it based on the judge and how she's been ruling. The goal is to get the right rulings, because certain things, the certain bells cannot be unrung by the appeals court.
Respectfully, the Commonwealth does not look to hide the truth. The reality is, if the jury is going to hear information, they should hear the entire truth, not a version or a slice of it, not one advocate's side of the truth, the whole truth. And if we interject that these witnesses were hired by the federal government and the jury is entitled to hear the whole truth, then they should know the motivations behind the hiring, the input from the defense team prior to their decisions, and what, if anything, they considered, and what their directive was. We don't have any materials.
Did he just what, if anything?
Regarding direction.
Yes, he did.
Purpose. We have nothing. Now,
I hate him.
didn't know that Attorney Yannetti's file was subpoenaed. That's new to me. Perhaps the Commonwealth knew. I've never heard that before. I don't know how the defense knows what the federal prosecutors wanted.
It's the first time he's ever cushioned that. It's the first time he's ever cushioned that, where he's saying that's news to me, right? That's news to me. But then he says, I don't know if the Commonwealth knew. It's the first time he's ever made a representation with that effect, where he then goes and says, but it might have been said earlier. I don't know.
They've never discussed that with us. We don't have that type of relationship with the federal prosecution in this case or their investigation. We didn't have any interaction, not because we chose to hide from exculpatory evidence or we were hiding from the truth. We weren't invited. We didn't know. Now, I hear now that Mr. Yannetti's file was subpoenaed and information, whatever it was, his entire file was given to the federal government and they chose whatever they chose. This report by ARCCA was produced by letter February 12, 2024. We know from at least some of the materials we got, there's a document from Attorney Yannetti on March 29, 2023, describing his client's best memories of events, a number of pages talking about the case. So there clearly is a relationship that we are not privy to. I'm not casting aspersions or trying to suggest
Yes,
anything
you
improper
are.
about the relationship. I'm not suggesting that, but
Yeah,
it was
yeah.
obviously.
I'm not
That
like every time he says I'm not doing
be
something,
honest. Be honest.
he is doing exactly that thing that he says he's not. Like every single time he's like, well, I'm not trying to keep their lawyer out. Yes, you are. That is exactly what you're doing. I'm not casting aspersions. Yes, you are.
Yes,
like
you
just
are.
own your shit.
Yeah,
Just
take it because the argument's not bad. The argument that says, look, there's a communication, there's something written down here that says Karen Reed's best recollection of the events that took place, and that was provided almost a year ago, March of 2023. Cast the aspersion. Make the fucking argument.
If that's where you want to go with it, do it.
Do
right?
it. Do it.
Say
it's very clear. She provided them a narrative in March of 2023. Of course, that's going to persuade where they go with their investigation. My God, just make the fucking argument. Sorry, Ian. I did not mean to cut you off.
No, just have the courage to like. Yeah, I hate the way he does it of like, I'm not saying this, and then he's like, well, I am actually totally saying that. He does it all the time. It is like his go-to move. And it's just
this comment might be my favorite so far the whole night. Not 647 says I'm not casting aspersions, but Avada Kedavra.
Like, I hate it so much.
Oh, it's so bad. Just cast the fucking aspersion.
Yeah, I mean, sometimes you got to just stand up and say, like, well, defense counsel provided them a narrative. So what, so that, we want to be able to cross-examine on that. Right?
Oh my God. It's so annoying.
A relationship between the parties that the Commonwealth was not involved in. And so we can't take a fraction of something and say we present them as independent witnesses when there was a purpose, there was an agenda, and it wasn't in the Commonwealth's interest, obviously. The ability to cross-examine a witness is only as good as the evidence and information you have. As you've seen from the ARCCA witnesses, from my opinion, my perspective, respectfully, is
He's
when they answered
terrified of the
questions,
ARCCA
perhaps it was
witnesses.
not perjury,
Yes.
but it was quite misleading, suggesting no relationship with the defense, talking about DNA with no DNA evidence.
Here we are at the perjury, misleading. It really get.
I do not think.
I'm not
that-
casting aspersions, but perjury.
Unless they've established their credibility. I don't see that in these transcripts. So I will need materials to hold them in check and to hold them accountable for whatever it is their bias. And so
If you want to hold them in check, get a chessboard.
You mean like the entire transcript of the voir dire, their testimony at trial, all the information you got in the document dumps? Stop pretending like you have no information, like you're completely unprepared to cross-examine them. If you're completely unprepared to cross-examine them, it's because you're an idiot.
Yeah, at this point, it's a you problem.
Yeah.
He's like, I'm completely unprepared to cross-examine them, Your Honor. And the proper response from the judge would just be to lean forward, tap the mic, and say, skill issue.
aimlessly is totally ineffective. It's a recipe for disaster, and that's not the type of examination we're going to engage in. If we're going to tell the whole truth,
No.
it has to be the whole truth. And I think that becomes a dangerous game. There'll be an entire trial trying to advocate influence or no undue influence with these witnesses. It's unnecessary. It can be resolved through questioning these witnesses prior to trial and following the same protocol you did last time.
All right. So if the defense intends to call the ARCCA witnesses, we need to have a voir dire next week. All right.
So they're going to have to fly out.
I'll put this under advisement.
Can I just ask?
I didn't catch that. I just heard Elizabeth Little say, well, what? Hang on. I didn't catch that the first go around. Listen up.
Defense intends to call the ARCCA witnesses. We need to have a voir dire next week. All right. So we're going to move on. I'll take this under advisement.
Can I just ask the
I missed the what?
I missed that one too. It was a, huh? What? What? We're going to do this again? What? Now,
Well, and also they're going to have to call the ARCCA witnesses and be like, we need you here next week. And they're going to be like, well, we are people who like have a schedule and, you know, we do things. We have the busy.
Now, for everyone that's challenging and questioning why this discovery or why the voir dire is going to occur, keep in mind this is a whole new trial with a whole new trial record, a whole new record of information coming in. So even though we've heard it before, even though we've heard the testimony before, heard the all this other things before in the prior trial, it's a different trial record. It's a different trial. There has to be different rulings that are based on information elicited at this trial. So this makes sense. This is logical. I know people were shocked by this, but I'm saying, you know, if you have to lay a foundation for why you're making a ruling that either allows or excludes, you have to do it with the same factual record in the trial that existed at the past case.
But why doesn't she need to do that with the dog?
I don't
food?
know. Don't look at me. I'm answering the questions that make logical sense. I'm not answering the questions that don't make logical sense.
Yeah,
There's
the
too many of
problem
those.
is that like once you start exposing anything to like holding it to equal standards, everything falls apart.
And
Because
Cricket,
it's
this is a very, very different question. So why was the defense reprimanded for something that occurred in the first trial? Very different question. One is factual predicate and foundation to allowing a witness to testify and discovery obligations in an existing trial. The other one is the possibility of making an intentional misrepresentation to the court, which is the duty of candor. Those are two different inquiries. One of them impacts your ability to actually be a practicing lawyer in front of that judge. The other one just impacts what evidence you can get at this trial. That's the distinction. Now, I don't agree with the sanctionable stuff and all the other comments you made about that. I don't think she holds both lawyers to the same standard, but that's not here nor there. But she refused to voir dire the plaintiff's experts. She hasn't actually, oddly enough, I think we actually might get of voir dire. That's where my gut is leaning on Crosby. But it will be closer in time to when it's being offered in rebuttal.
Parameters of that voir dire, the purpose of that voir dire?
Unless Rule 14 is complied with, it will be for the Rule 14 information.
Exactly. She's saying it's the same reason as it was the last time.
We can discuss this later. Let's move on, and I'll hear any objections later.
He's like, but we already did this, and it's going to be so expensive.
All right, so the next motion is the defendant's motion for stating grounds for objections. I'll hear you on that, Mr. Kennedy.
This is going to make me so fucking angry. I know this. Oh,
Yes, I believe my written submission essentially makes the argument, Judge, but
Okay.
During the last trial, as a result of our inability to state in one or two words the basis for an objection, we had to go to sidebar far more often than we'd like to, and we're also conscious of the fact that we have a jury sitting for weeks at a time away from their.
wait, side note. Did I blow past the stiffle? I think I did. No, I'm not there yet. I'm not there yet.
But now you've given it away.
It's at 93 minutes and 12 seconds. Okay, we're close to stiffle.
Families away from their jobs, and any sort of view that one side may be delaying the trial could engender some hostility from the jury. So there were many times during the trial, I won't speak for my co-counsel, I'll speak for myself, where an objection was made. I had no idea what the basis of the objection was, and the court made a ruling on that objection, and I had no idea what the court's basis for the ruling was. We would go to sidebar, and the first thing the court would ask the Commonwealth is, what's the basis for your objection?
To make a record at that point.
Well, I understand, but it's what's the basis for your.
This is the problem that I have immediately, right now, with that first fucking answer that Judge Bev gives. What's the point of asking, and I'll get to this. What's the point of asking? And then she goes, to make a record. Well, Judge, here's the thing about a court proceeding. The record is being made at every single stage. In every conversation, when I'm saying it from my counsel's table, when I'm saying it from the podium, or when I'm saying it at sidebar, it's to make a record. Everything is a record, including the basis for my fucking objection, which I'm allowed to say on the record on every occasion, and have you rule and overrule my objection and clarify the basis for overruling my objection on the record. Every one of them. This is the most outrageous thing to me. And here's how, I'll tell you how I would handle it. I think I've mentioned it before, but I'll tell you how I would handle it.
Your objection, if it were that obvious that it could be ruled in open court, we should have known the basis for the objection. I didn't know
I
it.
agree with that.
And
I should have known the basis.
Well, I'm hearing it for the first time at.
I didn't catch that part. That's fucking bullshit comment, Judge Bev. Are you kidding me? Did you catch that?
Go back. I'm not sure if I got it right.
Wow. That was these two hate each other. I think they hate each other.
Well,
sidebar.
Go-
What's the basis
go back.
for your objection?
Hang on.
If it were that obvious that it could be ruled in open court, we should have known the basis for the objection. I didn't know
I
it.
agree with that.
And
I
I'm-
should have known the basis.
Well, I'm hearing it.
I don't know. There's two ways I can read that. One, I can read that as her being really snippy and going, you should have known because you're a moron and you should
That's
have known.
exactly how I read that.
The other way to read it, and I think this is actually what she intended, and being, is her saying, I agree, you should have been told what the basis was.
No. And I disagree with you emphatically because of how she rules on her fucking motion.
Fair.
I agree. And I'm going to play it again. Listen to her tone. It's snarky. And then when she gets to her ruling, it's not even a half a second consideration.
Like, that's the thing.
This is not how you handle this. This is not appropriate.
For the first, it's, what's the basis for the objection? If it were that obvious that it could be ruled in open court, we should have known the basis for the objection. I didn't know
I
it.
agree with that.
And
You
I'm-
should have known the basis.
Well, I'm hearing it for the first time at sidebar. There were objections made that I thought had no basis in the law or evidentiary rules whatsoever. But in any case, this will avoid us having to go to sidebar multiple times.
And the
There were
thing
times
is
when we
you
had to sort of
can't
pick and choose
necessarily
when we went.
know, because even if the objection, like even if you just ask somebody for something that is obviously hearsay, you can't necessarily know that the
What the exception they're relying on that can
well-
get challenged upward. Like, let's say that you ask someone a question that's obviously hearsay, right? But the objection is, you remember when Judge Escarati would do this and say, overruled on that grounds? Like,
I mean, this is the thing, is I've also seen people make some stupid objections. And so, like,
but and that's why the overruled on those grounds. That's why you need to know what they are. To this point, Mary Lou Crafts, appellate point, only if the record is preserved.
and
That's
this is the
the
thing,
issue.
is if I was them, I would just be objection sidebar. Because that's what
Every-
they have to do. Every
Yep,
single
and that-
objection. And,
and that's
it'd be like,
that-
objection granted, sidebar. And she'd be like, why do you need a sidebar for the granted objection? In case it's appealed, Your Honor.
Yep. And this is where I think I've called it, not it's called training the judge, but it basically is, if the judge denies you a sidebar on even one instance, there's your appellate record. Every single time you said, Judge, objection, overruled, sidebar, Your Honor. What's the base for the sidebar? I need to understand the court's reasoning for the ruling. Every single time.
What's the basis? Is I want one.
Yep. What's the basis? You have to articulate why you have overruled this objection. First, they need to articulate what the objection is, and you need to articulate why it's being overruled. Are you overruling it because it's not hearsay, or are you overruling it because it's subject to an exception? So you train the judge. You make the first day of trial so absolutely fucking painful. And then you file your motion to reconsider.
To sidebar
And
because,
I mean,
again,
your
we didn't
motion to
want object-
reconsider will probably include, you know how much that sucked?
Or the sidebars continue until morale improves. The sidebars will continue until morale improves. Yeah. This is a good comment too, Nico. Imagine Cesar Milan training Beth. You have to.
Hostility from the jury. My motion also points out, Your Honor, there's at least one case that talks about how an objection could be potentially waived if it is not stated with.
And this is a part where Judge Bev comes back and says, well, that sounds like a you problem. If you're not able to state your objection, or if you want to be heard on your objection, you need to actually make it a point and make it a sidebar. So, Judge Bev, you created this issue.
Yep.
Particularity. We think that this would, and look, different judges have different opinions regarding this. I've been in front of plenty of judges over my career who endorse speaking objections, as long as there's no, trying to coach a witness or, trying to influence a witness in any way.
I wouldn't have used the word
And that's not
speaking
what we're seeking
objection.
to do here.
I wouldn't
Objection,
either.
hearsay, the objection, lack of foundation.
Because he's not asking for
Just
speaking
very
objections.
Basic objections. I think there's no prejudice to stating them in open court. It will move the trial.
I've told you, I've had judges that have said that you can say the objection, but you have to use the rule. Like, you actually have to have a number, which sucks. But if you're allowing me to state the basis and I have to cram on remembering what the rule number is, fine, I'll do that.
The thing is that, like, here we don't have numbers, right? But just objection hearsay is super common. And, like, if you want to actually argue the objection, the jury's got to go. But objection, objection hearsay, you can do. So, yeah.
Trial along more quickly. It'll allow my client to preserve her due process rights, and we'd ask the court to change its ruling from the first trial.
Okay, that motion is denied. So the next motion, defendant's motion. Motion eliminate to exclude false and irrelevant statements of Michael Proctor, 591. Does the Commonwealth intend to put this evidence into the case?
We do not,
Okay.
so we can agree to that motion.
All right, so that motion's allowed, Ms. Giannetti. There's a defendant's motion for reconsideration of the March 6th court order denying defendant's motion to exclude witness Crosby. Mr. Alessi, what I'm going to do with that is if I can readdress that before rebuttal, before the witness is called. So we don't need to do this now. We'll wait and see what Dr. Russell's testimony is and if the Commonwealth's going to call the witness. All right, so we can address it later.
Thank you, Your Honor. And
Okay.
also just so I'm clear on that, and to the extent we argue for the need for a voir dire, would that also be part of Your Honor's consideration?
So if I feel I need to reconsider it, that's the time to do it, after
Thank you.
Dr. Russell's testimony. All right, there's a motion, it's 599. Defendant's motion eliminate to prohibit the Norfolk District Attorney and Massachusetts State Police from having juror contact. So we don't need to belabor this. We talked about this before. No one has contact with the jurors other than the court officers. So defendant's motion eliminate to prohibit Norfolk DA and Massachusetts State Police from having juror contact. I'll also include prohibiting defense counsel and the media as well. No one is to have contact with the jurors. The court officers are the only ones that have ever had contact with the jurors. So there's that.
She's like,
So I think
problem
now we
solved.
move on to something that may take a little bit more time. The defendant's motion eliminate to exclude the testimony of Dr. Judson Welcher. How do you pronounce his name, Mr. Brennan? Welcher, and the Commonwealth's opposition. So who's arguing for the defendant and how
Brennan got a name pronunciation right. I'm shocked.
long do you think this might take? Because we can do some of the quicker Commonwealth motions if you want.
I am going to do it, make the argument, Your Honor, and I estimate 40 to 45 minutes for this motion.
Okay. Mr. Brennan, how long do you think you'll take?
It's really dependent on what Mr. Alessi says, but I can't imagine it's more than 15 minutes. perhaps.
Alessi.
Okay.
Yeah, he gives the correct pronunciation of a witness of a witness last name, and then immediately mispronounces name of opposing counsel.
All right. Before we go
I
there,
feel
there are a
like-
couple of the Commonwealth's motions. It's
It might be intentional.
I just either that or he's just an idiot. I can't figure that part out.
It feels intentional.
But then again, there's things that he says that are mispronunciations that are clearly not intentional, that are just stupid.
Yeah, just.
seem pretty quick. That I just wanted to know if the defense had objections to it. To appoint a stenographer, we've already done that. Prevent identification of jurors and impound the juror names during trial. Why don't we do a few of these, then we'll take the recess.
Greg, this is a good point.
And,
Chronic sidebars possibly alienating the jury. It's slippery slope, but I think for day one, if you do it one day, you're not going to alienate them too far.
It's your number one, 575. Commonwealth's motion eliminate to appoint court stenographer, prevent identification of jurors, and impound juror names during trial.
Well, I think that there's also probably the possibility that you could kind of sneak it out to the jury in the sense of, you'll be like objection and the judge will be like, denied. You're like sidebar. And then eventually like somebody's going to get frustrated and is going to go like, counsel. And you'll be like, judge, you said we had to do this.
Yep.
And then she'll be like, that was supposed to be at sidebar. You're like, sorry, Your Honor, my bad, but the jury doesn't forget.
And the jury doesn't
you
forget
just
that.
you just kind of sneak.
I get it.
And then the jury's like, well, it sucks that the defense has, that the court made the defense do this.
Yeah. Kate, I answered this question before as far as didn't they already get a voir dire? They do get a second voir dire because the judge wants to overcome that Rule 14 issue. This is a Rule 14 issue, not a Daubert issue. Rule 14 and discovery obligation. That's why she's asking for that second voir dire, not on a doesn't have the capability or capacity to testify. But I think that she will likely have a voir dire, maybe if it comes to Crosby. I don't know. I'm not going to hold out hope. But yeah, Lolly has been relegated to a very miserable looking associate attorney. Like just looks miserable.
They've put him in the chair in the corner, and yeah.
Commonwealth believes appointing a stenographer is a prudent practice.
We've already done that.
preventing identification of jurors. This case is a case that has garnered extraordinary public interest by the profession.
You did that argument.
Question, sidebar discussions regarding jururs.
Listening to
Edward Kirkpatrick has a good
And in
point
fact,
on
in
this one.
Massachusetts, it's not just the
You
First
have to read
Amendment,
the
but
room
it's
and
also a
adjust to the
Commonwealth.
judge. The second half is you need. This is adjusting to the judge. Adjusting to the judge doesn't necessarily mean making friends with the judge. It means doing what you need to get what you need out of the judge.
Correct.
And sometimes that can be pissing the judge off.
Training
because, you know, or making the judge, you know, realize that, like, okay, if you're going to do this, we're going to make it into a big fight.
Yep.
So sometimes that can be your strategy.
Yeah. And you also pick a villain. Like you pick one person to do that. Like, so I wouldn't be surprised if Yannetti during the first day starts objecting and I would pick Yannetti because Yannetti would be the one that would flame the judge the most. So if Yannetti during the first day is handling the cross-examination of all the witnesses and starts immediately peppering with objection, sidebar, the judge is going to explode.
Yannetti gets to be designated a-hole.
Yeah. And then you let Alessi get up and say, well, judge, you can always reconsider your that would be my strategy.
All right, to know what's going on in the courtrooms. And when
So I
justice
saw
is
something
open
in
to
the chat
public,
that gives me an
it
idea.
serves as a check.
Oh no.
Is there a way that we can send Lolly as a gift a coloring book for him to use while he's in there? Or like the coloring page from like a Denny's, like the kids with like the 3 crayons. Can we do that for Lolly?
Terrible. Or a map of Canton that's actually just masked as like one of the mazes where he has to draw the line.
And you just like sneak into the courtroom ahead of time, leave it on the on his where he sits.
So I want to fast forward a bit because I actually want to get to some of the motions I think were one. I need to get to the I need me some Alessi in my life. I just need it. I'm sorry. It's a cleansing moment for me to hear argument by someone who concisely conveys the argument.
This next week. We'll have it before they testify. The all Rule 14
I
discussion.
just want to make sure that we're very well defined on what issue is before the court that would justify a
14.
voir dire. I just want to make sure. I don't think that's been clearly articulated.
That's how you preserve a record. Judge, give me a reason.
Okay.
We need to know. I think Mr. Alessi is going to handle the argument in substance, but I need to know what are we dealing with for a voir dire?
Okay. All right. So what I need you to do beforehand is make sure that all Rule 14 discovery is complied with. And if it is, then we'll see. Okay.
So it's basically
Yes.
defined on Rule 14.
Yes.
Got it. Thank you.
Does
Yeah.
that work for the Commonwealth?
My concern is if we have questioning of the witnesses the day before their testimony, and part of that includes the production of records, and they don't have the records with them, they're going to be unable to produce them because they would have to return home. And so having
Yeah. Side note. This is the Commonwealth getting fucked. So she's like, I'm going to allow the ARCCA witnesses to testify. We're going to do a voir dire the day before. So this is the judge saying, I think you have everything you need to do a cross-examination. What you're doing is asking that essentially I give some remedy for a Rule 14 violation. I think I can't not give a remedy for Rule 14, but it's going to be the same fucking thing you had before. So day before, you get to a shot at cross-examination, and then trial.
So we'll need that, Mr. Alessi, okay? Well in advance.
Yeah,
That would be part of the Rule 14 discovery. If they comply with Rule 14 discovery in advance, you'll have all that.
That was exactly my understanding, what Your Honor was suggesting, and we will comply with that.
So see where we stand. If we need to address it, we'll address it before then.
my discovery motion extends beyond Rule 14, and the reason why is it includes the communications between the parties, which is necessary to understand. It's not simply Rule 14. We have a court-ordered discovery motion that we filed that includes the request for this information to show bias, and I don't want that to be overlooked.
All right. So talk to Mr. Alessi in advance. All right, and I'd like you to be able to tell me before we start the trial where you stand with that. Okay?
Yes, Your Honor.
And what you still think you need, Mr. Brennan.
I'll inform the court.
Okay.
And I'm pleased to speak with Mr. Brennan at your Honor's direction.
All right, thank you very much. All right, so now we'll go on to your motion, Mr. Alessi.
The most prepared attorney in the courtroom on every single fucking hearing so far. It's just, I love him and I hate him at the same time. Like
The thing I hate about him is just that I'm not him. That, like, he would be the lawyer who makes me look bad.
I have never been this prepared for a single hearing in my entire career. No, maybe one or
God.
two. Maybe one or two.
Well, and the thing is not only is he prepared, but he's also got everything memorized. And, like, that is a whole thing which, you know, it's like, oh, and so, you know, hey, I need you to cover something different. And he's just like, let me just do that. So it's like, damn.
I love it. I love it.
May it please the court. In my presentation today, with regard to Dr. Welcher,
Wait, I want to catch this because a lot of people were talking shit about this. This is a pivot. This is a pivot. When we talk about pivot, get ready. This is a pivot in tone, inflection, how you handle it.
may it please the court. In my presentation today, with regard to Dr. Welcher,
No, I was just wondering if you're going to tell me what you're going to tell me and then tell me what you've told me. Do you plan on
What?
doing that or are you just outlining it?
I do not, Your Honor.
Thank you. Go ahead.
What the?
In my presentation today, Your
What
Honor,
in the
I'm
sentence
going-
was that?
It was so this is what Alessi does. And there's a part of this which I didn't think is being disrespectful. Alessi kind of got he didn't care for it too much, but you can actually see, look at you can judge by Judge Bev's facial expression just based on the look at the faces of the other people in the courtroom who are looking up at the bench.
Dr. Welcher,
No, I was just wondering if you're going to tell me what you're going to tell me and then tell me.
See, you got smiles over here who are looking, who are kind of, because Canoni is definitely smirking at this.
Tell me what you've told me. Do you plan on doing that or are you just outlining it?
I do not, Your Honor.
Thank you. Go ahead.
Now, Alessi didn't care for it, and he continues on, but by tone, he conveys disappointment, but then actually pivots and doesn't do it. Alessi has this habit, though, and Alessi's habit is basically he gives an outline. He says, Judge, in my presentation today, he says, I'm going to refer to these documents, and he says, these are the documents you have them in a binder. They're tabbed A through G, right? And then he says, and then I'm going to do it this way. I'm going to do it chronologically in this fashion, going from A to B and C. And then he says, and then I want to focus on points C, D, and E, right? So he does. He gives an outline. I love it. I love it. Canoni makes the comment here, which I think Alessi doesn't care for, and I wouldn't either, because I think that there's a great deal of respect in giving this presentation. And I do believe that Alessi was about to give an outline. But he doesn't. He changes, he turns, he pivots. But he also, by his inflection and tone, made it very clear in the courtroom that while Judge Canoni might have viewed it as a joke, he perhaps didn't. And she backs off. I don't know. I like the way he presents. I like that there's a style to it, and I like that it's predictable.
In my presentation today, Your Honor, I'm going to, just so Your Honor has the documents in front of you that I'm going to be referencing. I'm going to be referencing.
He absolutely was going to give an outline. That was the flip of the page. Absolutely was going to. He absolutely was. I love it, but he didn't.
The 140 slide presentation,
Okay.
what the Commonwealth has dubbed a report.
Good recovery,
which is
though.
Approximately 12 pages of a letter dated January 30, 2025 from Dr. Welcher to Mr. Brennan. And I am also going to be referencing case law that the parties have cited. What Dr. Welcher has submitted is notable both for what is submitted and what is not provided. Dr. Welcher has gone extraordinarily well beyond not only his area of expertise, but he has, and that's in terms of what he has provided, but as remarkable is he has not provided any documentation of how his methodology is tethered to any study, any common acceptance, or any of the Dalbert factors. And this, again, is a pattern of the Commonwealth, where they provide, as they did with Dr. Wolf, as they have done with Dr. Crosby, they provide
And she's going to admit it.
long qualification lists, and then are complete.
What's crazy is, yeah, you see this. He throws him off. He takes a little while to get back to it, but he does. This is set up. And if you actually, this is about to 1.25. If you actually know how Alessi presents and his speed of normal presentation, this demonstrates how much that initial interruption cut him off. If I'm opposing counsel, if I'm the Commonwealth, I am taking very careful note of how long it took him to get back into the rhythm, and I am pocketing that for any direct examination that Mr. Alessi does, and trying to cut him off with objections to get him thrown off of his game.
Yeah, I mean, that's one thing you've got to learn is how to bounce back from objections.
Yep.
Or sometimes how to shut. When I was a junior, like first year lawyer, I had one prosecutor who kept objecting and it kept throwing me off, but he kept losing the objections. And so finally I'm just like, Judge, he's just doing this because he can see it's throwing me off. And the judge was like, Crown, I expect your objections to be, to be correct.
Yeah.
And the prosecutor made a further objection about a minute later, and it was again bullshit. And the judge just was like, denied, and without me anything. And he's like, Crown, knock it off.
Yeah, yeah.
And
do it again. I'm going to start doing sanctions.
And there was another moment where the Crown got up to start objecting, and the judge just went and shot him the death glare. And that was even after that one probably was objectionable.
Yeah. I mean, you alienate the judge. So, I mean, people are saying that Judge Bev was being disrespectful. Personally, based on the facial expressions of the people in the room, I don't think she intended it to be that way. I think it was perceived that way. I do. I think it threw Alessi off. I don't think she intended it in that fashion. I think she was poking a little jab. But Alessi didn't appreciate it. It threw him off, which also makes me wonder about if I'm the prosecutor, if I'm Hank Brennan, I'm wondering how to piss him off. But Alessi does recover.
You gotta poke people.
He recovers and he gets pretty quick back into his argument. And in doing so, he gets back into a rhythm. And I've always liked his rhythm.
Completely silent on the tethering of the methodology to a common acceptance or the Dalbert factors. So that is the jurisprudential motivation for
y'all. If you can't recognize that this judge is going to be disrespectful and that every judge is going to be disrespectful, and that sometimes you can call it out, sometimes you can't, sometimes it's appropriate, sometimes it's not. I get it. You guys hate Judge Bev. In this one, I don't care if you have one opinion or the other. What I'm saying is, from the lawyer's standpoint, you got to be able to pivot and recover. You have to. And he does.
And sometimes this is what lawyering is. Sometimes lawyering sucks. You're going to get people who will be disrespectful. You'll get people who will be rude. There are lawyers whose entire strategy is trying to piss you off. And sometimes it's by being like actively shitty, like in ways that you're just like, and you got to roll with it, right?
Yep. What's crazy to me is that y'all are nuts. It is wild. If I say one thing that is possibly giving the Commonwealth an ounce, or giving Judge Bev an ounce, or giving something, the commentary that jumps down any one of the lawyers on YouTube their throats if they're making a comment that could possibly.
But we're going to keep doing it when it's justified.
No,
'cause-
I'm not going to stop. Jeez.
For me to hit the case law with regard to why that deficiency is fatal to their burden of proof under the Massachusetts law. So I'll start with case of Canavan, the SJC's decision of 2000. And I am going to provide 4 parts of Canavan. Number 1, it's in head note 11. And this case was about, as the court may know, the Commonwealth, not the Commonwealth, a party proposing an expert that was commenting on, which was fashionable at the time, multiple chemical sensitivity. And the expert witness trying to state that an individual suffered from multiple chemical sensitivity. Here's what the SJC stated in response to the expert that was proffering that testimony, and it's extraordinarily close to what is happening with Dr. Welcher, what happened with Dr. Wolf and Dr. Crosby. The SJC said there was no evidence in the record to show that Dr. LaCava, that was the proffered expert, used a reliable methodology to transform his general finding of chemical exposure to his more specific diagnosis of MCS, multiple chemical sensitivity. Immediately after that, the High Court said, and I quote, Dr. LaCava referred to the, quote, literature as confirming the existence of MCS and asserted that based on the examination and tests he conducted, the employee had symptoms highly suggestive of environmental sensitivity. However, Dr. LaCava did not identify any specific studies that showed the existence of MCS based on specific symptoms and did not identify tests that can be performed to prove that the patient suffers from MCS. Skipping one sentence. Thus, the only evidence on this record tending to show that the employee suffered from MCS was Dr. LaCava's assertion. The purpose of the Lanigan test is to prevent an expert from offering testimony to a fact finder that is not based on a reasonable or reliable methodology. We cannot conclude that the expert's mere assertion that a methodology is reliable is sufficient to pass the Lanigan test, absent any other evidence showing its reliability. And I have used the Latin phrase ipsi dixit, translated into because he says so, or he said. And it's not my pejorative. That's the ipsi dixit comes right and is used in case of Canavan. And that's what the SJC calls it when you don't tether a methodology to a study or common acceptance. It's just that expert witness saying it. The reason I perseverate on this is because that's exactly what Dr. Welcher is doing.
Perseverate? What is his fucking grammar? What it is? How? What is that?
The dude is a thesaurus.
What is that word? Perseverate. To repeat or prolong an action, thought, or utterance after the stimulus that prompted it has ceased. Perseverate. What the fuck?
I'm just going to say, he's the guy who wins at Scrabble.
He's the one who has the note cards at home with a new word he's going to learn every day.
No, he's got the note card at home with the new word he, he's run out of the note cards because he learned them all.
Perseverate.
140 slide presentation.
It is a relevant term, especially if you've got like a psych background, because
nowhere in either of those voluminous documents.
So, as an example of where it would come up is, let's say you've got somebody who is profoundly schizophrenic and they have a delusion. That delusion may perseverate even in the face of very strong contradictory evidence. So, they'll say like, oh, this guy is like an FBI agent. And you'll be like, and he's secretly here to monitor me. And it's like, really? That dude? The dude who is currently like, peeing on an electric fence? And he's like, yeah, he's just doing that to throw you off. And it's like, or maybe he's just the kind of person who's dumb enough, like,
to pee on an electric fence.
Yeah. So, yeah.
does he mention one word about two things he did. He did an analysis. He has a purported methodology, just like Dr. LaCava in case of Caravan. He doesn't mention one study to support his methodology. Unless there be any concerns, the law is clear that the Lanigan analysis is applicable to medicine, science, and technology. And clearly, Dr. Welcher is in the technology area, and the Delbert Lanigan analysis is referred to as the hard science. So he also, Dr. Welcher, conducted an experiment, and I'm going to treat that separately from the lack of a methodology. So I want to stay just with the methodology that is purported to be used by Dr. Welcher. So keeping on with case of Canavan, Dr. Welcher also is proffering to provide
This makes perfect sense. Perseverate is used in medicine all the time.
Yeah.
Isn't he a malpractice attorney?
Oh, that may be it. That would do it. But I mean, the thing is he's got a vocabulary that doesn't quit. So
yeah. Audrey, thank you for that. That's actually remarkably informative. Thank you very much.
opinions on the medical causation of the injuries to the right arm of the deceased. It's clearly what he is doing. Here is what the SJC said about causation. It's head note 14, and they labeled the heading of it causation. The SJC said, quote, "There is no suggestion that the judge conducted a Lanigan analysis to determine whether Dr. LaCava used a reliable methodology to conclude that the chemical exposures to which the employee was subjected caused, and caused is italics in the opinion, her to suffer from MCS. This was an error." They went on, quote, "Because understanding medical causation is beyond the knowledge of the ordinary layman, proof of it must rest upon expert medical testimony. Because and I'm skipping several sentences, because the judge below did not conduct a Lanigan analysis to determine whether Dr. LaCava relied on a reliable methodology to determine that chemical exposures caused the employee's MCS, it was an error to admit the opinion." In the concurring opinion of Justice Greene,
My God, please let him do one half of the closing. Like, please let him do it.
Oh, just give him the whole close.
Just the inflection, the tone, the pointing out. He is the definition of let me fucking spell it out to you in crayon. And I'm listening to it. I'm like, please do. Just keep on doing it. Because I feel like he takes away the effort. I don't have to partake in the effort of reading. But when he shifts tone, it's like I have a word, or it's like I have the document in front of me. He goes, skips a few sentences, and he continues reading. I'm just going, just please, like, please. It is so much cleaner. And also the volume at which he speaks. And like I said, the inflection, how he changes like crazy up and down. A lot of people, I get some people don't like him or me. And for someone that's listening to an argument and trying to follow the argument along, he is the best at this. He's not all over the place. He is linear. He is explanatory. He doesn't ever make the assumption that you know what he's talking about. He will always start at the beginning, which is huge when you have a jury.
he added an important point. I quote, "Further and perhaps more importantly, the application of the standard will make little difference in how an appellate court decides a hard science." The issue was, what was the standard of review? Is it going to be abuse of discretion? And the concurring justice said, in hard science, it really doesn't make a difference. But here is apt for what we're here for today. The goal of Lanigan, as was the goal of the preceding tests, is to keep unreliable or so-called junk science from fact finders, thereby reducing the prospect of the return of verdicts or the rendition of decisions with dubious validity. So I rehearse apt provisions of the case of Catavan because the SJC sets forth what the burden is of the proponent. And I know Your Honor has heard me make this argument before, but I am now providing the SJC decision for direct support, what I've said with regard to the experts, Dr. Wolf, Dr. Crosby, and now Dr. Welcher. Next case I provide is Commonwealth v. Misc. and that is another SJ decision.
Did he say Meeks?
Meeks.
And if I'm not mistaken, I think all of the cases that I'm providing in my oral argument are
Cited
cases
by
cited
Commonwealth.
to by the Commonwealth as part of this motion. I'm not 100% sure with regard to Meeks, but I think it's a decision that they cite as well. And oddly, all these decisions favor the defense. So here is, I'm only going to need to read one part of Meeks, even though it's a very long decision of 2006. It states at 2006 Westlaw 2819423, and this is on page 53 of the Westlaw copy. Quote, at trial, this court will require the Commonwealth's firearm identification witness to provide on direct examination, et cetera, et cetera. Last sentence. Such discovery is essential to an effective cross-examination and therefore to a fair trial. And I've made this argument many times before about the prejudice to Ms. Reed from the pattern of the Commonwealth to provide experts, long reports, long CVs, completely silent on tethering the methodology to a study, etc. And the SJC points out that that information is essential to an effective cross-examination and therefore to a fair trial. And with regard to the last case that's really more apt to the experiment that Dr. Welcher apparently performed, not apparently did perform, that is the subject of his slide presentation. And this is, there's various experiments, but the most prominent of which is painting someone's arm blue, painting a hand yellow, and then trying to use the results of that experiment to support some wayward theory as to how the SUV made contact with the decedent. There's no doubt that's an experiment. So it's important when I get to that experiment, what the legal standard is before such an experiment can be admitted in evidence, and what's the test under the Commonwealth v. Davis and Lanigan as to how an experiment could possibly come into court. So you've heard of the case, and I know Your Honor knows of Rintolo. We basically cited it for the proposition of qualifications, but substantively, we haven't talked about it. And I know Your Honor is well familiar with it, so I'm just going to summarize what's apt for our motion. What the High Court said there is that the precise question is whether Giulianelli, this was the paint expert proffered by the Commonwealth, possessed sufficient education, training, experience, and familiarity to determine forensically when and how the paint was applied to the basement floor in the victim's body based on the information he was provided. And a large part of Rintolo was, listen.
I can't help but laugh. The inflection change and when he leaps forward. He leaps forward forensically. You follow along, and he's very good at getting your attention at certain inflection points. Now, I think there's a little bit of a not drop the ball, but I would have tried to get out in front of something before Brandon brings it up, but we can get to that in a minute.
This person was a paint engineer at his company, and he had a lot of experience in that. But what he really didn't show and didn't have was experience forensically addressing the question. And that was certainly a big part of Rintolo. So the court, to that point, said there is a significant distinction, however, between what Giulianelli had done in the paint industry for over 20 years and what the Commonwealth asked him to do in this case. So the court went on and discussed the difference. And it said he also, this is Giulianelli, he also did not do any research on the topic or search for any academic or industry materials on this topic. So the court, with that predicate as to what was lacking, which is completely the same as what's lacking with Dr. Welcher in his experiment, the court said this, and this is on Westlaw copy 14, head notes 19 through 22. I quote, expert testimony also may be based on or informed by the results of experimentation. Skipping. The conditions in the experiments must nonetheless be substantially similar to those at the crime scene for the experiments to be of any value, and where new hard science is involved, an appellate court will always take a hard look at the trial judge's decision to admit or exclude the evidence. So here's what happened that's very apt to Dr. Welcher. Our analysis of Giulianelli's approach begins with the important principle that judges should closely scrutinize expert testimony where the testimony is prepared solely for the purpose of litigation, as opposed to testimony flowing naturally from an expert's line of scientific research or technical work. There is no evidence whatsoever in the Commonwealth papers that Dr. Welcher had ever performed this experiment as part of his line of scientific research or technical work. From all indications, it appears that he performed this experiment specifically and exclusively for purposes of this litigation. And that's where the SJC started. So they immediately said, if it's just experiment done for this litigation, we right off the jump have a big issue with it. The SJC then goes on with this very, very questionable area of experiments and said, rather than flowing naturally from his work, therefore, his experiments greatly differed from the work he ordinarily performed and the observations he had experience making in the key. And his opinions were developed solely to assist the Commonwealth's prosecution of the defendant, which from all indications appears exactly the purpose of Dr. Welcher. And here now to the tethering of the methodology to a study which Dr. Welcher does not do at all. The court said, footnote 31, because Giuliani conceived of and designed the experiments without any stated basis in existing science or literature, and because neither the Commonwealth nor the trial judge applied the Dalbert-Lanigan factors, it would make little sense to attempt to apply them here. The SJC said, we're not even going to go do this analysis because the proposed expert didn't cite to it. So we're not going to guess at what happened. And it then said, relatedly, and I'm quoting, the Commonwealth has not pointed to any basis in existing scientific literature or research for Giuliani's methodology or experience. Instead, it appears that Giuliani designed these experiments on his own without any guidance. Reading down below, quote, Giuliani's experiments also did not appear to have been performed consistently with basic scientific principles.
Here's one of the challenges. At this point in time, he's lost the judge. He's so far down the road of legal argument without, I think he's lost the judge.
I mean,
That's
I
the
think
one
he lost the
downfall.
judge before he walked in.
Well, that's possibly the case, but I think it's the one downfall
He
of his
woke
style
up
of
this
argument.
morning and lost the judge.
Well, the judge was never there.
Just by existing.
Yeah, just by existing. I don't disagree. I think at some point in time, his argument tends to run on. That's the one downside to Alessi.
We have no evidence in anything the Commonwealth submitted that the experiment of Dr. Welcher was performed in accordance with any scientific principles, because his report and slide presentation is completely bereft of any citation to basic scientific principles. Next, the court said Giuliani did not repeat or validate any of his six experiments.
Here's the thing. And someone said, where was it? Wait, hang on. Citing all the case law appeals will be a cinch. The case law is cited in the motions and the brief. It's in writing. You don't need to go back and rehash it in oral argument. Oral argument is the point where you bring up additional points you think are going to make your case and win the argument. The case law is already in there. He's already cited it. He doesn't need to rehash it. But so you're trying to pick, which is why he's jumping around in the cases to pick specific points.
Experiments is also significant. There is zero in the current record that Dr. Welcher repeated or validated his experiment. Nothing. That is the legal standard for experiments in the Commonwealth of Massachusetts. It's not the defense creating the standard. It's not the defense suggesting what the standard should be. What I just read is a 2021 opinion of the SJC. With those important legal precepts stated, I now turn to the letter, what the Commonwealth provides as, or calls a report, which is the January 30, 2025 document from Dr. Welcher. And I start on page 9 of that report. And if Dr. Welcher had adhered to his own standards about what a biomechanical engineer is to do, my presentation would be much shorter. So let's see what he said the role of a biomechanical engineer is.
This is where he gets more effective. I get laying the case law out. I get highlighting it, but he becomes so much more effective here.
And then what he did, because this goes to the point of him exceeding the scope of his qualifications wildly. So on page 9, he said in the first full paragraph under numeral 11, he says, in the middle of the paragraph, my biomechanical engineering analysis is determining the effects of physical forces on the human anatomy. I have not made any type of diagnosis. He then goes down below, in 2/3 of the way down, he says, injury causation analysis is a multidisciplinary endeavor that employs objective medical and biomechanical data and analysis to determine whether a MVC caused a pathological condition or symptom diagnosed clinically. Continues, the entire body region will be covered under 3 of the 4 main branches of impact biomechanics, which are injury mechanisms, mechanical response, tolerance, and the biofidelity of surrogates. Thus, injury criteria are needed by biomechanical engineers to describe the relationship between one or more physical parameters and the injury they cause. These criteria usually take the form of a simple mathematical expression or a force or acceleration level. I couldn't agree with him more that is what biomechanical engineers do. And he then goes on the next page, first full paragraph, I understand my current assignment in this matter is to analyze the available data in this case, including but not limited to the data in and damage to the Reed 2001 Lexus LX 570, and to determine the events that applied forces to Mr. O'Keefe that resulted in the damage to his body, structural failures, fractures, injuries. I agree completely again. That's what a biomechanical engineer is supposed to do. And what is it that he's talking about with force acceleration? At the risk of getting a little too nerdy, but it's really important.
No, you can speak nerdy. The chat will appreciate it. Like the chat will appreciate if you decide to speak nerdy.
What biomechanical engineers do is they apply Newton's second law of physics, which is force net equals mass times acceleration. That's the mathematical formula. Because biomechanical engineers want to know what's the force being applied, and when you do that, then you can then say, okay, is this force capable of causing this result? And if that's what Dr. Welcher had done, again, my presentation would be very short. But that's the setup that he says are his guardrails, his boundaries. Now let's see what he actually did in this cases where we have great objections. It's his conclusions and opinions, which take up about 1.75 pages only on page 10. Let's see what he did and how he honored or didn't honor his own standard. And I'm going to, hopefully to assist the court, identify what I believe should absolutely be disallowed from him opining on. Conclusion opinion number 1. I'm not going to talk about things that we aren't contesting. I want to go to the things that are clearly wayward and improper. 1C. He cites to Julie Nagel and occupants of Richard D'Antonio Ford F-150, Ryan Nagel and Heather Maxim, arrival in time outside 34 Fairview, not seeing anybody exit Lexus or damage to the Lexus.
Yeah. What the fuck is he doing testifying? Why? How is he reciting that? He's a biomechanical engineer. How is that any part of his testimony? At all? Like, what force caused what consequence? This part I don't get.
What he is doing is he is not only using, but he's trying to credit contested testimony.
So let me find out. Do you intend to introduce that testimony, Mr. Brennan?
And this part pisses me off. Let me find out. Do you intend? Please pitch a softball to the prosecution a little bit slower. Do you intend to adduce that? No, Judge. Of course I don't intend to adduce that. What the fuck else is he going to say? Yes, Judge, I am absolutely going to have him testify to observations made by third parties. No. Now, Alessi does something really good here because this catches Alessi off guard, but he does something pretty impressive. He uses the clarification and spins it into his own argument.
I intend to introduce that testimony prior to Dr. Welcher testifying. It's not in the record. He would not be able to testify to it, but if it's in the record, with
All right. That's a very apt question, and Mr. Brennan's answer underscores the issue. So what I understand completely the foundational evidence issue. I understand all of that. But the transcending issue is an expert witness can't use contested testimony because experts are not allowed to credit and talk about the credibility of witnesses. It's clear case law in every jurisdiction, including Massachusetts. And he does that throughout his report. And we've provided in our supplement correction the clear case law. I'm not going to go through it because I know Your Honor knows this. It's almost Hornbook law. So based upon Mr. Brennan's answer, it only underscores and establishes our concern. So 1C should be excluded. Now to 2. 2A Romanettes 3 and 4. Romanet 3, 2A3. No evidence light was broken at 1 Meadows Ave. When does a biomechanical engineer get to testify about a contested issue and say no evidence? That's not for a biomechanical engineer. And when he set up his own boundaries, he didn't talk that he was going to be looking at contested evidence. Romanet 4, 2A4. No fragments of taillight on or in snow behind O'Keefe Chevrolet. That's an evidence, collection of evidence, preservation of evidence, etc. It's not for a biomechanical engineer. Then he goes on to 2C. Testimony of Jen McCabe. That's his heading. Karen Reed stated to her, etc., etc. In other words, given Jennifer McCabe's testimony, and then he talks about what he believes Ms. Reed knew. That is not only trying to credit testimony, we've got now a biomechanical engineer that is going to be stating the Commonwealth's case for it. What is the biomechanical force calculation for talking about Julie Nagel, Ryan Nagel, Jen McCabe's, or frankly anybody's testimony? It's unprecedented. Now, continuing on page 11 at the top, and this is C Romanet 1-1, 42622 Julie McCabe, 42622 state grand jury page, etc. Grand jury minutes. That's testimony. It's testimony of lay witnesses. Inherently, he is crediting that testimony as truthful. That's not what any expert can do, let alone a biomechanical engineer.
Not only that, but that grand jury testimony is unchallenged, sealed, and not known to the public. And it's unchallenged. There's no cross of that.
Number 3, the location and orientation of the laceration on John O'Keefe's right forearm and arm are consistent with the geometry and orientation of the right tail light of the Reed 2001 Lexus LX57. So let's cut through the euphemism of orientation. What he is referring to is pattern recognition. He is saying that the pattern of the lacerations on Mr. O'Keefe's right forearm are supporting his opinion. Where is his qualifications to determine pattern recognition of a wound on a decedent? They don't exist. 4, and that should be stricken and not allowed. 4, perhaps the most egregious of all, and I respectfully submit what I've pointed out are incredibly egregious. 4, the totality of the evidence is consistent with the right rear corner of the Reed 2021 Lexus impacting, etc., of his head on the frozen ground. So there are several maladies with that statement. First, where is his qualifications to testify as to frozen ground? He's not a pedologist. He's not a hydrogeologist. He's not a geologist. He has no basis to testify in that regard. But more importantly is his phrase, the totality of the evidence. And if Your Honor now looks at what he considers to be the totality of the evidence, it is extraordinary. He is, and I will state each one, he is becoming a medical examiner. He's becoming a lead investigator. He's becoming a cell phone data forensics expert. He is also, once again, talking about testimony of individual witnesses. So he says the totality of the evidence is consistent with the right rear corner of the Reed Lexus impacting John O'Keefe and Mr. O'Keefe, etc., and of his head on the frozen ground. So what he's doing is he's now talking about cause of death and manner of death.
Do you intend to introduce that evidence, Mr. Brown?
Wouldn't be introducing evidence of frozen ground, Dr. Welcher.
Well, that's not a fucking answer.
That's, yeah, I was like, that is the most, yeah.
He's talking about, he completely dodges whether he intends to introduce cause and manner of death through this expert. And he's like, I'm not going to ask them about the ground being frozen. Well, can we get a clarification on whether you actually intend to go down this road?
Is there other parts of the
Cause of death.
he would not be offering a cause of death?
As he nods his head. Look at that. As he nods his head.
Cause of death.
Cause of death.
He would not be offering a cause of death.
Uh-huh. He's sitting there nodding his head. He would not be offering a cause of death. Mm-hmm.
I think the spirit of the report is putting all the information together to see his observations, but I recognize that he's limited to his field. Hard ground and the cause of death are not within his field.
Do you? Do you? Really?
Again, appreciate that apt question, and I'm going to go into why there's still an issue. So I think it's best just to go through each one. Thank you. So 4A.
That is pivoting. That is, Judge, respectfully, let me give my presentation.
He says and this is what he means by totality of the evidence. Cell phone data. Where's his qualifications to discuss cell phone data? That's a data forensics. We had obviously many moments. I'm sure your Honor may wish to not remember, but with regard to Mr. Green, et cetera, we went through a lot of issues about the expertise needed, the methodologies, the various tools. Where is his qualifications to talk about cell phone data? There are none. It's improper. So A in its entirety should be stricken. C, forearm lacerations 3 above. So that goes back to the euphemism orientation where he wants to talk about pattern recognition. And it's interesting that the Commonwealth vigorously contested Dr. Russell, and we all know her credentials on pattern recognition, but yet they're proffering a biomechanical engineer to talk about pattern recognition. D, air temperature and frozen ground. I'm understanding, if I understand correctly, that the Commonwealth is now stipulating to excluding that. And it's really the frozen ground aspect of it, of D. Then E. I'm sorry, Mr. Brennan.
I don't mean to interrupt. The frozen ground, we're not going to bring in the air temperatures report because it talks about the density of the strength of the tail light. That's part of the decision. It could be evidence before he testifies about the weather we have.
That's fair game. If he's a biomechanical, that's what biomechanical engineers are allowed to testify to. Material strength under certain conditions. That's biomechanical engineering. That part's appropriate. But a lot of the other shit, like this taillight can withstand this level of force and impact, or this taillight would crack under this level of force. That is appropriate. Like, that's fine. Don't tell me how the lacerations on the arm got there.
We can rely on that to talk about how that might affect the tail light. But the frozen ground, we agree. That did not come from Dr. Welcher.
We have no objection to the air temperature testimony of Dr. Welcher.
Okay.
E, hat line and fracture location consistent with fall and posterior head strike. Extraordinary.
Little hyperbole.
Even the medical examiner in this case.
I mean, he's good at sort of the drama
Yeah.
But that is clearly
without necessarily having the same fight.
Without
that,
going too far. So you chuckle at it instead of going, all right, tone it down.
Yeah.
example of what I'm talking about in terms of Dr. Welcher going well beyond his field. He's talking about hat line and fracture location. That's a wound to the back of the head. And to make matters worse, he makes clear fall versus assault. He's making a distinction between a fall and an assault occurring. We've contested Dr. Wolf on that issue. Now with
that is wild to me that they're asking for the biomechanical engineer to introduce evidence as to whether the injuries sustained were as a result of a fall versus an assault. I think they can testify to, I mean, you guys, we've talked about this before. They can testify to what a certain level of force would do to a body, whether it would cause the body to be projected a certain distance, or pirouette, or flip upside down, or whether a certain level of force could potentially break a human bone. These are things you can testify to. Whether the injuries sustained were as a result of an assault by a human or being struck by a car, I can see that there's a certain level where you can say that's clearly not an assault because the level of force in an assault could not have done that. But that's not what's being offered. You're trying to bypass that and getting all the way to a conclusion that the biomechanical engineer can't do. Maybe all the information together, honestly, that's a determination for the jury. This is one of the ultimate issues. This is one of the ultimate question, or one of the ultimate issues that's for the jury. That's invading the province of the jury to determine whether the injury is sustained as a result of an assault or a vehicle impact. It's not one for the biomechanical engineer to testify to.
With regard to F, this is the wayward, undocumented experiment that Dr. Welcher conducted.
Wayward.
F, Romanet 2 should be excluded. It says drop test conducted by me with a hybrid 3 falling backwards, measured heads, G's of approximately, et cetera, et cetera.
Greg.
That experiment I've covered in
Oh,
what the
Brad.
case law requires for him to show. There is zero support for this experiment. I went through in Ventola, I won't repeat it, of all that needs to be established before an expert can talk about an experiment. Dr. Welcher supports his experience with zero. This very experiment that he did, this drop test, has zero documentation of where the methodology for that is supported by science. Recall in Ventola, the paint person conducted an experiment and the SJC said, yeah, you
I know the court audio is low. I have it boosted 600%. It's a max the court volume can go.
conducted it. Yeah, you know, this is your
All right,
area.
we got to get to Brandon.
But you've got to show all of these things.
He goes on for a
including
few more minutes.
Where is this supported by the scientific?
I'm particularly disappointed that
All right. So you had a breakdown highlighting each and every paragraph of these reports and the specific issues with that. So you had case law providing the foundation for the interpretation. You have the parameters within which the doctor said he's going to testify. And then you have pointing out specific parts of the record and the report as being inconsistent with what the case law allows and what the doctor said their specialty was. That was Alessi's presentation. Clear, succinct, linear, love it. Great. Little long-winded, don't care. Love it. Contrast that with whatever the fuck this is.
that Mr. or Attorney Alessi sees this as some type of trial by ambush. I'm not going to digress the way he has, but the case study in that is the ARCCA, and that's why I'm concerned about waiting until the day before trial to get simple Rule 14 discovery.
Just immediately conflating the issue. Immediately conflating the issue. I hate this. I hate this. The issue before the court is not my expert. It is your expert. Every single time it always comes up. Every fucking time. Now, here's where I didn't hate Brennan when Brennan was challenging the prior experts, challenging Dr. Rosser. You want to make that challenge? Fine, make that challenge. And force the issue and go through the Daubert analysis and actually have that contested hearing. That's fine. But when the same challenge is raised as to your expert, don't deflect and go entirely back to a different argument and conflate the
It's
issue.
so unfair that they're asking for the same stuff I have been asking about every one of their witnesses. Like, how dare they?
That's the frustration about it. Each one of these motions stands independently. And it really fucking pisses me off when this happens because one, if we really want to play a game of whataboutism in this trial, as far as disclosures, late discovery, late information, do we really want to play that game? Really? Because I can tell you who's done it the majority of the time of this entire fucking case has been the Commonwealth. Shit that goes missing, shit that shows up 3 years later, all of the above. Stop trying to conflate the issue and distract from that by pointing the finger and say, well, we don't have discovery. Fuck off. No, you turned over a video 2 weeks ago that had never been seen before. What are you talking about? So it's stupid. It is not legally sound. It is not the proper way of making an argument. Can it be effective? Frustratingly, it can. In front of this judge, it appears to be effective, which really pisses me off. Really makes me mad.
I mean, the problem is that it's a sloped playing field. So the the defense and the the Commonwealth are not getting equal rulings. So yeah.
And Mr. Welcher have some similarities because they're biomechanical engineers. Now, in our production, we gave over 8 gigabytes of information from Dr. Welcher. We gave any reference material, whether he was going to use it or not.
Do you know how small 8 gigs is these days? Like, don't tell me you gave 8 gigabytes of information and pretend like that's a large volume of information.
This is a peeve of mine when people like describe how much they, had in the form of gigabytes. Because you know what 8 gigabytes could be? It could be a 30-second video. Or it could be tens of thousands of pages of documents. It's just like
you know what it could be? You know what it could be? It could be 6 gigs of an install package for the 6 gigs of install package for the software you need to read the 2 gigs of data that they gave you in conjunction with it.
I mean, I had something where like the video file was like, it was something like 750 gigabytes. And I thought, holy shit, this thing is going to be forever. And I am just like, oh my God. And you know what it was? It was about a minute. And Elf Wiggins got it. It's casino footage. It was about a minute of casino footage.
Oh, yeah. Those are massive.
Like, you could count the guy's nose hairs because it just allowed you to, the thing you see in in shows where they're like, zoom in, zoom in, zoom in. And you try that on most videos and you zoom in and what you get is like blurry pixelation garbage, right? But with casino video, when you're like, zoom in, you could be like, oh, this guy should have that birthmark checked.
Or it's like I can see the crown on his tooth.
Like I have literally told clients, I know what brand of pants you were wearing on that day when they've done something in a casino, and they're like, how do you know this? I'm like, because I can zoom in enough to read the label on your pants. So we good.
Yeah.
The thing is casinos have this. Casinos have this because, they need to be able to read your cards. They need to be able to see very, very specific things. They, they'll catch the moment when somebody does something, fidgety with their hands. They will count, they'll see if somebody's using a tapping system to count cards, where they're holding their fingers differently to try to help assist them with counting cards. All of this stuff, but they can. So the file size doesn't mean shit. I've had things where it's like, oh, right, I'm going to need forever to go over this because the file, the video file is 200 megs, but it's a very long video file with very poor graphical quality. And so that's a much nastier thing to get in disclosure because then you're going over 8 hours of video going, trying to figure out is that blob my client? So
this was a stupid argument to begin with. I hate the conflating of issues of look what we gave and look what we got back. It's stupid. Stand on the merits.
It's a stupid argument, and we're all dumber for having listened to it.
We are, because here's the issue. Address any of the points that Mr. Alessi just articulated. Can we please just address one of them? Just point them out and address it and actually go and refute the contention being made.
We gave all studies, all data, anything that he considered, even if it was irrelevant, we provided to the defense. It was an extraordinary
You mean 8 gigs? How much of that was irrelevant? Sorry.
production. I've never seen a more complete production. But
Every
I love to
single-
hire the title to the defense.
By the way, I've never seen a more complete production. In my head, I was like, some would say it was the greatest production of all time. I've never seen a more complete production. I mean, many say it was the most thorough and comprehensive production I've ever produced of all time.
Rob, do I have to get the flamethrower?
No, you don't. But I heard that in that statement. It made me laugh.
All of the raw material, all of the
I will get the
studies, all of
flamethrower.
reference material. It's not limited to this report. As you can see, Dr. Welcher was extraordinarily thorough. You can see in the letter report all of the different things that he looked at, far beyond what any other expert has looked at in this case, far beyond, I dare say, what ARCCA even considered in this case. And so it is obvious.
Some would say he considered way more than any other expert in the expert of time. He's the most expert of all experts. This is what it is. This is the argument being made.
Yes, but maybe not to the defense, so I will narrow it. That Mr. Welcher, Dr. Welcher cannot come in and talk about the opinions or testimony of witnesses as it relates to their statement. So, for example, as Attorney Alessi points out, 1C, he won't be able to come in and would not want to come in and say that the witness did not see damage to the taillight. She'll testify to that herself, that there was no damage. In fact, all the witnesses did not see damage to that taillight. As to 2C, the testimony of Jen McCabe, that is for reference. Testimony of Jen McCabe is for Jen McCabe and the jury. He will not be offering testimony of Jen McCabe or offering anything that relates to it. Similarly, 2.1 regarding Julie McCabe and grand jury minutes, he won't reference grand jury minutes in the abstract, let alone the details of it. Number 4, he will talk about the weather if it is already in evidence. It's a proper basis for an expert, but he will not be talking about the frozen ground. Similarly, in 4G and H, this is reference material regarding Julie Nagel and the Ford occupants. They'll testify to what they did and what they saw. And the people inside 34 Fairview, even though every single witness said John O'Keefe never came into Fairview, that is left for the witnesses, not for Mr. Welcher. And so the basic argument of the defense is that this biomechanical engineer should not be testifying using his principles and his education about demonstrations. What is suggested is that there's no evidence that he ever engaged in these demonstrations before, that they were exclusive for litigation, they weren't tethered to a specific study, and the methodology for each one is not outlined in a report. I wasn't sure if he was talking about Dr. Welcher or he was talking about the ARCCA experts.
Oh my God, stop. Narrator injects, but he did not stop. He kept on going.
Because when I'm looking at the ARCCA report, which apparently they're very comfortable with, we don't even know which witness did what. Importantly, when we look at the ARCCA report, you have one witness who decided to build a potato cannon for no reason that we know of.
No. Not gonna let that one slide. He built a potato cannon, and I remember this part very specifically because I immediately wanted to go outside and build a potato cannon and shoot a glass at plastic and see what level of or what speed I would need that glass flying at to break the plastic. I wanted to do that job. I remember being intently focused on every minute of that testimony. No. He very, very specifically and carefully articulated exactly why he built the potato cannon, so that he could shoot glass at varying speeds at the plastic that is the same plastic as the tail light until he was able to get the tail light to break and the glass to shatter. And he documented every speed at which he was able to accomplish this. How else do you test materials? That's not the same as an experiment where a human body gets struck with something. No. That's very, very different. That is testing the fucking strength of material. Oh yeah, it was an air cannon. It was an air cannon. It wasn't a potato cannon. It was an air cannon. I wanted to build this so bad. So this is not. Stop trying to make the false equivalence. This is complete deflection. It is a bullshit argument. It doesn't hold water. It is 100% not proper to make this argument. It's bullshit. Plus, I don't give a fuck about the ARCCA experts when it comes to yours. You are trying to adduce this information in direct examination and your case in chief. You are trying to proffer this expert not to rebut or refute the ARCCA experts. In fact, the ARCCA experts are defense experts that are intended to refute and rebut your experts. So this is not the same. They're not the same. You are in different postures. This is stupid.
No evidence that anybody threw a glass, but apparently it was a cool idea. He cited on the stand.
Fucking asshole. One, factually accurate. It was a cool fucking idea. So, and two, there was a pretty damn good reason. And had you actually read the transcripts like you keep saying you did, you would know exactly why it was done. This is stupid.
That wasn't tethered to a specific study. That didn't lay out the methodology of the potato cannon.
Yes, it did. They did increasing speeds and velocities until they broke the fucking glass. That's how they laid out the methodology. And they basically said, this is the speed at which the glass had to be traveling in order to shatter. Seems to me like that lays out a fucking methodology. So.
That wasn't repeated or validated. There was no specific literature that was referred to in that report. And yet,
Yes, he did.
not only were they allowed to offer this evidence, it wasn't inappropriate. Now, it would be nice to know a little bit about the potato cannon, maybe a picture or a video or some specs on it, or maybe some details on how it actually operated. See, these are the things that Dr. Welcher provides to the defense. He doesn't just provide.
Oh, good. He said Dr. Welcher's name for the first time in the last 7 minutes. This is so dumb. This is not a proper legal argument.
The information, the raw data, and the studies. He actually shows the demonstrations. He doesn't hide from his basis of his opinions and conclusions. He shows and demonstrates them with videos and pictures and photographs. Quite unlike ARCCA, where it is just simply a conclusion based on just trust me. And so when you look.
You're out of your mind. You are out of your mind. Guys, Ian stepped away for a minute. He's pulled himself off stage. I see his avatar. See, he's back. I told you.
Are people freaking out? I just went to
He's fine.
Get a glass.
He's fine. Did you shoot it with an air cannon? Because you should have.
I did not. I did think about putting on the flamethrower, and then I was like, I don't know YouTube's policies on that. They might, because they won't let you handle a firearm on stream, but they might. I don't know if they consider a flamethrower a firearm. And then I was like, I'm not going to risk Rob's stream messing around with that.
Maybe not.
So, what is it? But yeah, no, I just, used a machine in the small room and then grabbed a glass so that I could have some scotch.
This one argument from Brennan was my most infuriating moment of the entire day.
Which one?
His argument in response to Alessi's here. Just everything was about ARCCA. Everything was conflating the issue. Nothing addressed what was being alleged as to his experts. And he inaccurately restates the conclusions of the ARCCA experts and what happened at the past trial. Which is par for the course, but it really just pissed me off. Especially in the face of a very concise
starting
argument.
to really get on my nerves.
At the production by Dr. Welcher, it is not comparable to the standard that the defense accepts for their experts. He is a biomechanical engineer. That is a combination and study of engineering and physics and science. And it also details medicine. He's not a medical doctor. He's not diagnosing an injury, but it includes all of those arts. Now this. This is the same thing that ARCCA says in their report. If you look at their report, they talk about the study. And they outline what they believe the study of being a biomechanical engineer is all about. In fact, one of the complaints by Attorney Alessi is Mr. Welcher's drop test. If you look at the ARCCA report on page 10, they do the very same thing, except that they don't show it. They don't actually demonstrate it. It's pale in comparison, but they give the conclusions and they give a chart. No different. And so there are no medical diagnoses by Dr. Welcher. These are his opinions based on a study of the evidence, and he goes to the extent of actually demonstrating those different assessments that he has made. In particular, the defense.
This is the kid that read the back page of a book before the book report was due. Like, he read the back cover and the front cover, and he looked at the picture on the front, and he just kept on saying the words he saw over and over and over.
I got an A on a paper where all I'd read was the Coles Notes summary, and
this is what he's doing,
and the first 2 chapters. I couldn't get any further than that on Wuthering Heights. That book broke me. I hated it so much.
Martha, if he had read the Cliff Notes, he would have a better understanding of the material. It is so clear that he actually doesn't have a grasp of what it is that these experts do. That's the scary part of this. The scary part of this is that he is offering and trying to represent to the court the parameters of this expert field and the conclusions they reach and why the conclusions they are reaching are appropriate given the analysis and methodology they used. But he doesn't understand the analysis, the methodology, or the field. He just keeps repeating words over and over again. I'm fairly confident I understand more about biomechanical engineering than Mr. Brennan does in this moment. I'm pretty sure my little one, mini Mischief, if I gave him an air cannon, he would probably understand more about biomechanical engineering than Mr. Brennan does right now shooting this, like making this argument.
I want an air cannon.
And just as a general
now,
emphatically. You were away when I was telling the chat about everyone.
I might have to make an air cannon. And just like start shooting glasses at something.
And I get you disagree. I'm telling you, he doesn't have a fucking clue. This is a person who just proffered to the court that we turned over 8 gigs of data and was like, that was massive. He doesn't have an understanding. He doesn't.
They would like the ARCCA witnesses to come in and say that the injuries were not consistent with strike.
This is not about ARCCA. This is about your expert.
The taillight of the Lexus. That's what they want to say. Dr. Welcher's opinion is different. It's the same engineering, it's the same science, it's the same concept. It's just a different opinion than they like. So if they like the opinion, all of these standards that Attorney Alessi is insisting on are excused, but if they don't like the opinion, somehow should be excluded. They're really polar opposites when you think about the perspective and the opinions they give. They both have a different opinion about the taillight causing the injury to Mr. O'Keefe's arm. One the defense likes, one they don't. It is the same science, same study, same analysis. And so if it's acceptable for ARCCA, it must be acceptable for Dr. Welcher.
Here's the problem. Here's the problem. That argument is going to play. That argument is going to play with Judge Beth.
Yeah, I mean, it was a good argument.
It is so annoying that it's conflated. It's stupid. They stand in different positions. You know, ARCCA is responsive to the accident reconstructionist by the prosecution. It is very different, but that argument's going to play. I hate it, but I think that argument's going to win the day.
Actually downloaded the text stream data. He didn't ignore it. He didn't know that it didn't exist. He didn't fail to consider it. He actually downloaded it himself. And
with what qualifications did he have to do that? That part. What are you fucking saying? So now he's not just an ARCCA. He's not ARCCA. He's not. God damn it, Hank! You got me saying ARCCA 9 million times just because you say it. He's not just a biomechanical engineer, but now he's downloading data and interpreting data from a fucking vehicle.
He's
Are
a
you
Swiss
kidding
Army
me?
expert.
I wish there was a Swiss Army expert. It would save a lot of money in trials.
There is. It's
Any
Dr.
expert
Russell.
called by the Commonwealth.
Dr. Russell, I feel like, is an
Oh,
expert
that's
in multiple
true.
things.
Yeah. Dr. Russell.
He is experienced.
And Trooper
He
Paul
knows
has
material, studied
equal
the
expertise in all
No.
fields.
How dare you raise that name on this live stream? Don't you dare.
His expertise is equal in every field you might you might name.
Equally incompetent in every field? Is that how we're measuring equal? Because I think that they don't say the same thing. I mean, he does speak to crime scenes, which is a skill. I didn't realize it existed, but he speaks to crime scenes.
I think that most people haven't realized that exists.
But he does. Like, there are some people that speak to the trees. He speaks to crime scenes.
I mean, I can speak to crime scenes too. It just goes like this. Hey, crime scene. And then the crime scene says, because it's a crime scene and they don't talk.
Material. The tech stream data is critical in this case because it shows time and place with the new information that we have. So we know from the Waze information exactly where that car went from the waterfall to.
All right, y'all got to stop with this. First, I've got Smithers, which I can't get out of my head. Now I've got from Beautiful Messy Ball. For some reason, when I look at Hank, all I see is Ralphie from the Christmas Story in his pink bunny PJs. I don't know why. Because it's accurate, damn it. Like, why did you have to go and put that in everyone's head? It's not nice. Now everyone is old. Now everyone's seeing that.
To the flagpole. We know where it did and didn't stop along the way. We know, based on the phone data, Mr. O'Keefe's phone data, when he was in the car until. We have all that evidence, and as a bioengineer, he can consider all of that technical data, which will be introduced to the witnesses at trial before he testifies. And it's important. The location and timing of that car is important. This is all science and data. It's not witness testimony. It's science and data. And it puts that car.
The more times you say science and data, it does not make it any more scientific. It doesn't. It doesn't.
More repetition is more science.
It's more science. Ian, you're science and data.
I mean, that's
Did you
just
know that
science
this
and
is
data.
science and data? It's just science and data. Guys, it's just science and data. You know what it is? Probably science and data. Judge Bev, why did you overrule my objection? Science and data?
I got a headache. You know what it is? It's science and data.
It's just science and data.
Are at that flagpole at the time Mr. O'Keefe is there with his cell phone, locked into the Bluetooth in that Lexus until he gets out of the car after 12:30. And within 2 minutes, we allege this collision occurs. And there's Apple Health data, there's location data, there's cell phone battery temperature. It all coincides. He should be able to consider these things in his study. This is what he does.
I like that Aiden is back there. Aiden knows that timeline doesn't work, which is why he's sitting there shooting his head back and forth. So that's
The demonstration at Meadowbrook, John O'Keefe's house, is depicted by measurements which has been provided, science and data. Ring video.
Oh, Jesus
drink.
Christ.
Everyone drink.
This is gonna kill me if I drink every time he says that.
Chat as he is saying it.
Those which will be independently admissible. And we see the gentle nudging of that Lexus into Mr. O'Keefe's car. And there has been allegations.
Wait, hold up. The gentle nudging. So now we're conceding gentle nudging because at the last trial, you were adamant that there was no contact. None. Adamant. Like 1,000% adamant. So does this mean that you are now bound by that position in front of the jury in this instance?
No.
Where in front of the jury, you cannot argue that there was no contact?
No.
I think that this argument here means this is pretty gross.
Claims, suggestions that that's where the taillight may have broken despite the other contrary evidence. You can see in the presentation, he actually shows not only the nudging in the car leaving through the ring video, but analyzes it, and you can see exactly where those two cars came into contact, and it wasn't the taillight. You can see through his demonstration or through his study of the materials he presented that the snow is on the back of Mr. O'Keefe's bumper until the nudge, and you can see the exact spots where the snow comes off. This is science and data. This is an opinion. This isn't witness testimony.
Drink.
And the jury should see that very evidence. It'll be admissible not only through him, but through independent witnesses. The defense takes issue with Dr. Welcher providing an opinion that the lacerations and cuts are consistent with the geometry and orientation of the right tail light. There has been many claims about alternative sources, which the Commonwealth disagrees with, as to those abrasions. But if you've seen the PowerPoint that's been presented and provided to the court, will be presented to the jury, it shows the symmetry of the arm and the location of the arm, the height of the broken tail light, and it shows with great continuity the height, location of that broken tail light, and how it relates to a bent arm. And that is based on engineering, biomechanics, the same things that ARCCA employs. They just didn't do this.
Say it. Are you
So
gonna say
that's
it?
not witness testimony. That's not beyond the bounds of anything. That is powerful evidence, and we intend to introduce that.
Come on, you can say it.
And then, as I mentioned, finally, the drop test. This is the same information that ARCCA proposes in their report. For some reason, I don't think that was offered at evidence at trial, but it's clearly within the bailiwick of this expert. And so we will file on Monday a PowerPoint presentation redacting all the inadmissible parts of it, which is witness statements. And we expect to present the demonstrations to support the opinions as corroborative evidence of those opinions rather than just naked opinions. And there will be no trial by ambush. Now, we will be studious in getting that information to the defense. We would like them to be as studious getting us the ARCCA information. It does.
Stop conflating the fucking issue. My God. Kristen
I
makes
just gotta
a really good
say,
point.
I do laugh at that because that was actually a good dig.
That last parting jab, but you do it once.
That was a
You
good
don't-
dig.
You don't make the entire argument about that. Kristen says we need your thumbnail guy to add pink ears. I can make the inquiry. It might be possible. And then you'll never unsee it, or I'll have him put Smithers in the background somewhere. I don't know. The Radio Man says Judge Kennedy believes in science. I see what you did there. Like, science. Clever.
Concern me delaying that information because, as Attorney Alessi eloquently said, you need time to prepare. We know he's a very prepared attorney. We'd like to prepare.
You know what would make you a prepared attorney? Pronouncing his fucking name right. That might start.
As well, and if we wait to get records and information and know who wrote what part of the report, we won't be prepared. There's a third engineer in their team that wasn't called. We'll have to add him to the witness list if he has any relevance. We won't know until we question those witnesses. So I think I'm also inclined to ask the court to consider we have that questioning well before their testimony. But we will meet our commitment and provide those slides on.
She already ruled. You get it the day before. Shut up.
All right. And Mr. Alessi, again, you've already said you agree to talk to Mr. Brennan about the reciprocal discovery. Okay. Sure.
Like with Dr. Welcher's report, what Attorney Brennan did not say is even more important than what he did say moments ago. He didn't state or even address where is the methodology employed by Dr. Welcher tethered to a study, the scientific literature. He kept using the phrase, it's science and data, quote.
God damn it, Alessi. Now we got to drink because of you. Shit.
Someone alleging that it's science and data doesn't even begin to approach that the methodology is established in the literature or satisfies the Dalbert-Lanigan factors. So, Your Honor, on the record before you, there's no better evidence that that tethering doesn't exist than the absence now for the fourth time upon challenge of that in Attorney Brennan's comments. That dooms Dr. Welcher. Now I want to address the false equivalency argument of Attorney Brennan. Attorney Brennan said falsely just now that the ARCCA report does not set forth the methodology. There are 14 footnotes in the ARCCA report. I just looked at them again. Footnotes 1, 2, and 3 tether the methodology of the ARCCA experts to the literature, The methodology is documented. I do not understand how an attorney can get up and say a report.
Because he's doing it a lot. I don't like people doing this, like the whole like lying and misstating. Well, here's the challenge. Stop fucking doing it. It's not hard. If you're getting up and you're going to make an argument that something is or is not in the document, at least have read the document. And if you haven't read the document, then don't make that large of a statement.
Court doesn't have something without having a basis for saying it on a key issue that is disputed. Attorney Brennan also falsely stated that ARCCA did exactly what Dr. Welcher did with regard to medicine and medical issues. That is completely false. ARCCA, as is clear as day from the report, and I'll repeat it, did a force net equals mass time acceleration calculation and said the forces that come from 15 miles an hour, 24 miles an hour, and then so the unknown is the force, the F in the calculation. What is known is the M and the A. The M is the mass of the head and the mass of the arm. The mass of the head is 11 pounds. The mass of the arm is 11 pounds. You then take the acceleration theory, even assuming the theory of the Commonwealth, which we can test, which is it's 15 miles per hour or 24 miles per hour. You multiply the mass times the acceleration, and you get a.
This is someone who understands biomechanical engineering. This is effective.
Force. And then they said this force is expected to cause or not cause these types of injuries. That is a proper biomechanical engineering analysis. The ARCCA experts didn't get into pattern recognition with regard to the wounds, the orientation, etc. But most importantly, there is no equivalency between what ARCCA did and what Dr. Welcher did. With regard to Mr. Brennan stating, quote, this is what he does, referring to Dr. Welcher. The question is not, is this what he does? The question is what he does rooted in science. And what it means is not just any science, it has to be a commonly accepted, his methodology commonly accepted or satisfying the Dalbert factors. And Mr. Brennan did not contest one aspect. He didn't say, Your Honor, here is where what Dr. Welcher did can be found. It's commonly accepted, either in court opinions, which the court could take judicial notice of, or in peer-reviewed literature, because it's not there. And with regard to the 5 non-exclusive Dalbert factors, I covered that in my presentation in the beginning. I'm not going to repeat it, only to say that Mr. Brennan didn't address any of those 5 factors to show a proper foundation for that. With regard to what Mr. Brennan called arm experiment, relating to a bent arm, relating to injuries. I understand what Dr. Welcher did. The question is not what did he do, but is it accepted in the medical literature? So with regard to the arm experiment that Mr. Brennan just went through, he talked about it, but he didn't mention once where that's rooted in the literature. He finally concluded by saying, this is within the bailiwick of Dr. Welcher. I don't know what this is, but bailiwick is a tautology. It doesn't say anything about whether what he did is rooted in the literature or that it satisfies the Dalbert factors. So in conclusion, Your Honor, I go back to Rintala, I go back to Misc, I go back to Case of Caravan. The Commonwealth has not today, not before, this is their 4th time, has not satisfied what the Supreme Judicial Court requires in these instances. And what it has come down to is the defendants, which stands in a different position. This equivalency between ARCCA, I've shown, and it's easily documented, the court can see it, that contrary to Attorney Brennan's false statements, ARCCA did cite to and tether their methodology to the literature. But
that is a well-stated, articulate, intelligent objection. Denied.
I know. And it makes me so mad. It does. Because it really makes me so mad. And I lost hope for it with Crosby. I did. Any hope that I would have that there would be a common sense ruling on an expert was just gone with Crosby. So hey, to the almost 4,000 of you that are here,
Holy crap.
hit the like button, please. And consider
Also-
subscribing.
Check me out on Monday. Well, I don't know if I'll be able to do one Monday. I'm still.
Well, why not? Because I'm not going to be able to get to the entirety of the motion regarding that hearing is on Tuesday, isn't it?
Yeah, I mean, I am buried in. I got to get
might
20
be able to-
pages done, but it's 20 pages of Supreme Court.
Oh, that's right. You're writing. Damn it.
And this is like a necessary break from that. I'm still sort of typing away occasionally as something occurs to me. But the problem is I'll like write 10 pages and I'll be like, this needs to be 2 pages. And so then I gotta boil it down and so forth. I'll do, you know what? I'm gonna do something Monday. So
Okay. And the thing is,
I will
my
do
trial,
some stuff Monday. Check me out on Monday. So
my trial
yeah.
settled. My trial that was supposed to go forward next week settled, which means that I've got some capacity to get caught up on some of this stuff.
Well,
Otherwise, I was planning on like prepping binders and prepping for trial all weekend and being in trial Monday, Tuesday, Wednesday. So now that that's resolved, I might be able to do that.
come check me out on Monday, and yeah, Rob, you're always welcome.
I know I have access to the
You have the ability
behind the
to
scenes.
sneak in.
I can sneak in. Yeah. So, and I think that's where I'm going to have to, if there is coverage of the motion regarding the text messages and communications, we can mention it briefly, but I think that's where that's going to have to be. It's going to have to, because we're 4 hours and 31 minutes in, and I still have to get to one of my favorite moments of this hearing so far.
Yeah, and I hate that one so much. Yeah.
Is here. To have no methodology, to have no tailoring to the literature, that's, as Your Honor knows, the gatekeeper's function to stop those opinions from going to the jury, to ensure not what the defense has created, but what the Supreme Judicial Court has created, which is the purpose is to allow for cross-examination and a fair trial. They haven't satisfied their burden. They have the preponderance of the evidence burden, and the consequences should be borne by the Commonwealth, not the defendant.
Okay. Go ahead, I'll hear a quick response.
Great question, Apocalypse DOA. I think that would have been the immediate response by Jackson and Yannetti. And I actually think that in this instance, it would have been appropriate. Could Alessi have just gotten up and said, I thought are we arguing ARCCA or are we arguing Welcher? And I think it would have been a fair game, like as a one shot. And Alessi did have the opportunity. But of course, Hank Brennan gets up. He was very offended. Very offended.
Regrettably, I know Attorney Alessi has decided to join the fray of disparagement. Now, he has said 3 times that I've made false statements.
Oh,
This is the
fuck
first
off.
time that Mr. Alessi has tried to portray the Commonwealth as being disingenuous, because they know full well this is being covered by the media, and they want to create a sense
Oh,
to dehumanize.
No, I don't need to. I don't need to see. I don't need to just listen to the statement being made. I can watch your lips and watch you openly
he
lying.
needs to like invent a new kind of fuck in which he can off, because I am just like, just fuck off in a manner that nobody has ever fucked and off before. Because come on, dude, you have been nonstop with this shit, and now you're gonna be
Absolutely.
like all like, he's like, can somebody loan me some pearls to clutch?
Oh,
It's
geez.
like
it is so rich, and it is so. And for those of you in the chat who are catching this for the first time, I got a shitload of hate when Hank Brennan first made his appearance in the case and started arguing, and I was like, this sounds like somewhat effective argument. And
I
God,
got the same. I was like, I actually like this guy. I think he's gonna do well. I think he's gonna bring some class to this. And then
he was saying the right things.
And over
first.
time, he got shittier and shittier and snipier and snipier.
And whinier.
And now I'm just like, if this guy could just, like, maybe he could go, like, go climb down a cliff, but without a rope. Like, I'm just like,
it's so absolutely frustrating. One, to have people who have criticized you for taking his side. And I wasn't taking his side, but I was giving him a chance. You give him a chance, and then to be proven wrong. Like, oh no.
oh yeah,
I gave you the chance, and you really just.
There's a lot of people in chat who are like, I hate this guy. Runkle, why are you saying that this guy? And I'm like, he's being a good, effective advocate. He's not. And I was like, and he's keeping his head above the fray. Sure, he's got a little bit of frustration, and then now he's just like, oh my God, I am. I'm sorry, chat. I thought this guy was like coming here to, run a trial, but he's actually here to be like just the entire circus carnival full of clowns. I
held out hope, and I continued doing so for the longest time. And then it became the whining that started getting to me first, and it was the pearl clutching and the, oh my gosh, I'm offended and hurt my feelings, and I don't have this, and then it was the.
He's like, it's so unfair. I'm not afraid of ARCCA. It's so unfair. I only have the infinite power of the state behind me. Like,
how many times do you talk about the ARCCA witnesses and the information? This guy, just always the whining. It's a fucking child with a tantrum, and how unfair life is. Meanwhile, said child has roof over head, clothes on body, fed every day. Like, how unfair life is. Please complain more.
Oh, I mean, this guy feels it's really unfair that he's got to wear a diaper because he would just like to leave a brown streak.
No, he doesn't. He doesn't have to wear a diaper. Ian, he doesn't have to wear a diaper. He throws his shit.
I mean, he's leaving some brown all over the place, and yeah.
Well, and then where I lost all patience and respect for him was when he made those how did he phrase it? The misstatements that he made about the discovery disclosures, and in the argument where he was not asking for counsel to be removed, but was in fact asking for counsel to be removed. That part where he didn't get up and immediately correct the record, that was where I was like, nope, you're done. So I express frustration with Yannetti and Jackson sometimes, and a little bit of frustration with Alessi when he goes on a little bit long, but that ain't nothing compared to this asshole. And I'm sorry, I didn't mean to be that way. I didn't want to be that way. Yes, race-based. We know he can do it. He accidentally pronounced Alessi correctly once. He did. He just did. He pronounced it correctly. I know. We know he can do it. It is absolutely...
He just chooses not to.
Lola the good dog. Hank plus Judge Bev equals my brain needs a shower. That phrase, my brain needs a shower, I think I need to borrow that. That's not bad.
Anything that they don't like, whether it's the government, the prosecution, the witnesses, or the evidence. There's no place for it. 3 times. This follows when he made representations, reckless representations in court, that Brennan lied 10 times. We found some of those transcripts, and I took enough dignity not to mention it because I didn't think I needed to.
Please tell me how much dignity you took. I just can't wait till you tell me about all the dignity that you took in misstating certain things repeatedly during every motion all the time. And you didn't want to mention it, then why bring it up now?
That the transcripts were not even accurate. Mr. Alessi was actually wrong when he was claiming I was lying about reading reports. Now, I don't want to stand up here and have a dispute, but when you use words like false statements as an officer of the court, they better be supported. That is a
when the statements are false, they're supported.
Strong statement to repeatedly make, and it's a tactical one. It's purposeful. Attorney Alessi is joining the fray, and that is all part of the strategy here. Now, if you look at page 13 and 14 of
Dr. Welch's report.
You mean statements that are joining the strategy and, you know, inflammatory for no other purpose whatsoever? They're like saying that you have nothing, no Rule 14 disclosures from ARCCA, nothing about these witnesses. You have no discovery from the other side. You were shocked to learn that what you got in your possession from the government, not even from the defense. The government gave you this. The defense didn't have the dignity to give it to you. The defense gave it to it. You have to be fucking kidding me. This is the ex-girlfriend, boyfriend, take your pick. This is the ex who just gaslights the fuck out of you. And then you, at the end of the day, you just sit there and going, wait, hang on. Am I the bad one? Did I say that? Really? I don't think I did.
Perhaps that was missed in the review. There are resources in that report that number 26 different items of resources. And so if we're talking about support and tethering, it is
No. Citing resources, like a table of fucking contents, like at the end, like this is my appendix, this is what I cited to, is not tethering. That is like me here. Let me actually explain what Brennan is arguing here. That is like me or Ian, who's writing
not
a
even
Supreme
tether
Court.
ball.
Well, he's got his tethers balls to something. But that's like Ian, who's
Rob.
I don't know. It just slipped out. I don't get it. It wasn't the worst one I made. The worst one I made was when he was talking about the penetrometer or whatever it was. Where I think someone had a super chat about it. Where was it? The penetrometer? That was the worst comment I think I made, was when he was talking about the penetrometer, and he kept on saying, I was like, what the fuck are you talking about? He says, yeah, it measures how much things can penetrate into solid ground. I was like, oh my God, did you put this in your motion? About how far down? 6 inches. If you know what No. But the thing is, this would be like Ian, who's writing the Supreme Court brief. Ian saying, when the judge says, Mr. Runkle, that's great. What case do you suggest counts for that proposition? Well, Judge, my appendix cites all of the law in Canada. You're like, no, that's not actually like making a connection between why I should believe you in this argument. Like, that's not tethering. That's just, you're just saying.
It's just kind of gesturing vaguely at stuff.
Yeah, and you're just kind of saying, so experts say this true, and that all is my reasoning for saying that's the case.
at the end of the report. It's not footnoted like ARCCA, it's at the end of the report. It's all there.
All right, thank you. So we're going to move on to try and get some motions in quickly. The motion regarding the chalks, is there an objection to the Commonwealth's motion requesting the use of chalks and directing both parties to provide visual?
No one objects
presentations
to that.
of
Then we have
chalks?
Jackson, and then we got Jackson,
Okay,
and I want to get to this part
583.
real quick. 'Cause we're running very quickly out of time because I get to do something tomorrow morning that I haven't done in a long time.
Particular people.
Golf.
Interaction at work.
Very excited.
Holy
about it.
crap.
I know. I'm very excited about it. Like I said,
Now, what if the ground is frozen and you
God
need
damn it.
some sort of trometer in order to determine how far the
don't do that to me. The penetrometer.
How will you get your golf tee into the ground?
No. The thing is, this is too. Oh no, Sergeant. Okay, now it's been well past 2 hours. So I can actually say Sergeant Bukaki's tainted evidence. Penetrometer. Around here, we call him Pisto Roboto. Oh my God,
That's awful.
it's way too quick and way too smart though. No, the penetrometer on the ground being frozen. No, but maybe I could use a biomechanical engineer when I hit someone with a golf club and find out what it does to the human body. Hosfarta penetrating the cold. Oh my God. Okay. So
For
it's,
you for 2 minutes. I told you to 2 minutes. I've got the stand on it.
so here's the thing. Judge Bev does something after the lunch break that she should have fucking done at the beginning. She starts giving the lawyers time estimates at the very beginning. And this is the thing. If you allow a lawyer to say, if you as a judge look at a lawyer and you say, counsel, how long do you think it'll take you to make this argument? The lawyer's going to say, probably 45 minutes. Realistically, if you tell that lawyer, counsel, you have 10 minutes to make your argument, that lawyer will take that 45 and condense it to 10 real fucking quick. Like, they have the power. Do not give lawyers the microphone and say how long you want to hold on to the microphone, because they're not going to let it go. So Judge Bev kind of picks up on this with these arguments that keep on going and going and going. And she does after the lunch break what she should have done from the very fucking beginning, which is to say, counsel, you got 4 minutes. Counsel, you got 2 minutes. I'm going to give you 6. And then she looks at her clerk and says, keep time. Side note, that actually happens in court. In our motions that I argue in Fairfax, the judge tells the law clerk how much time you have. And the law clerk will ask you, would you like a yellow light? And you're like, what the fuck are you talking about? Turns out
The answer is yes.
yes. The answer is yes. Turns out the law clerk holds up a yellow piece of paper when you're at 1 minute before the conclusion of your argument.
There are places like it depends, because I've argued in courts that have two different things. I've argued in courts that have green light, which is you've got like what, and then yellow light is at like typically 5 minutes.
Yeah.
And then red light is you're done. Shut up.
You're done. Shut up.
And and the court may let you talk over your time, but it's up to them. They could, and I've seen courts. I have literally seen courts go mid-sentence and you're done. Sit down.
Oh,
I've also seen courts. I've had a court ask me to keep talking for like 30 minutes over my 30 minutes. So yeah. What is it?
Speaking
now,
of
I
not
see
needing...
one complaint that my mic is too loud, but everyone else was complaining earlier it was too quiet. So I don't know, but what is it? I have seen ones that have just a countdown timer that tells you exactly how much time you have. The other common thing is just they'll just say you're out of time and you've got nothing to look at.
Joe, I'm gonna get your comment in a second. The countdown thing. I told you about my last trial where I was doing the trial and there was another attorney that was in the courtroom, and I actually had a chess clock pulled up on my laptop where I hit the button and it showed, because I don't know, but the judge gives me a time estimate at the very beginning, of how many minutes I have to argue my case, and I log that and I start clicking click, and then it just lets it go. But there was another criminal prosecutor who's in the back watching my trial. And he said, civil is weird. In criminal law, we can just keep on talking. He said, I saw you change your argument entirely when you realized you only had 5 minutes left. I was like, yeah, you get real good at, but Joe, calling this out because 1, I cannot believe you're actually watching having just had a child. 2, congratulations on the baby. I hope you, baby, everyone is healthy and happy. Congratulations. That is wonderful. I also apologize that you are probably going to lose tons and tons and tons of sleep, but ultimately it's for probably one of the cutest, most adorable and special things of your whole life. So congratulations. That is amazing news. And thank you for sharing it with us and for being here. That is wonderful. God, what a great piece of news. Wonderful.
Your Honor, I can't do this in 2 minutes.
Well, then we'll hold it. We'll hold it to the end.
That's fine.
Can you hold it, or do I have to pull over? Is what she's asking.
It is. It was. That was the exact energy that just happened. That was the energy. Hang on.
Your Honor, I can't do.
Jim, why don't you stand when it's done? Can you stand when it's done?
Your Honor, I can't do this in 2 minutes.
You stand when it's done. This is great. God, I love this. This is how to effectively run a courtroom. Keep the lawyers in check and do it to both sides. Oh.
Culprit, your time is up at this point.
See.
I've read your motion. I've read your memo.
Okay.
She cuts him off. For everyone that says she's never rude to Brennan.
I'm with a hope or an expectation or intention to pursue third-party culprit, but we have no basis for it. The court has been very clear on third-party culprit. And they can't just come in and start accusing people arbitrarily of committing the crime of murder. Section 1105 of Mass Rule of Evidence makes clear that evidence that a third party committed the crime charged against the defendant.
So I will read again the Mass Guide to Evidence. I'm familiar with the law on third-party culprit. Your time is up at this point.
See,
That should have been the whole time. Why? Why did it take you? Where are we? We are 4 hours and 52 minutes into a hearing. 4 hours and 52 minutes into a hearing. And here's the best part. She holds Brandon to a time. And now you have Yannetti responding to Brandon's motion. And Yannetti gets up and goes, I can't do this in 2 minutes.
I've read your motion. I've read your memo.
okay,
Or the pleadings.
Thank you.
All right, Mr. Yannetti. Jim, why don't you stand when it's done? Can you stand when it's done?
Your Honor, I can't do this in 2 minutes.
Well, then we'll hold it. We'll
That's
hold it
fine.
to the end.
That's fine.
All right, Mr. Alessi, I'm going to hold
Can
you
you
to
hold
2
it?
minutes. I've got the Commonwealth's motion on the Celebrate demonstration.
Yeah.
I'll hear you for.
Did you use the bathroom before we started the argument? Did you? Counsel, we're about to start our argument. Do you want to go outside and use the bathroom? No, I don't have to. Good, because when you start talking, I am not pulling this courtroom over and letting you go outside to pee.
2 minutes on that.
My 2 minutes start when I get to the podium? Yes. Thank you.
Wait, doesn't he ask? He asks, when does it start?
Commonwealth's motion on the Celebrate demonstration. I'll hear you for 2 minutes on that.
My 2 minutes start when I get to the podium? Yes. Thank you.
Again, my 2 minutes start when I get to the podium. So
I'm wondering if that's a shout out because, or like, did you see my little, my little video on that one, the short?
No, I didn't. Was this the,
Okay.
this is the 60 seconds. Yes. Gone in 60 seconds. I did. I
Yes.
loved it. It was phenomenal. Made me laugh my ass
But
off.
I started the timer immediately and included Judge Bev's sigh, right? Because he's like, I can do this in 60 seconds. And then I start the timer and there's.
It is
and he
so-
still gets it
is
done in
so
60
wild.
seconds.
And what's
So it'll
what's
be
funny
like,
about it is, and this is the part about courtrooms that people don't really understand. Yes, we get contentious. Yes, we think we get rulings wrong, or rulings are read disfavorably. Yes, we think the judge can sometimes be rude, but there are moments of levity. This is one where Judge Bev may have missed the mark in what she thought was a cute remark earlier and caught Alessi off guard, and Alessi was a little insulted. But Alessi, Bev goes, you got 2 minutes. And Alessi fires back and says, can it start when I get to the podium? And the entire courtroom starts laughing.
So I once had a matter in front of this judge, and she's now Justice Richardson. I love, she's my favorite justice. Just straight up. She's been elevated to King's Bench, but at the time she was in provincial court. Favorite justice, but she was we were in 265, which is like docket appearance court. And so it's kind of strictly limited as to time. And I was like, I would like to do a guilty plea on this matter. And she's like, well, Mr. Uncle, we limit matters to, like, you have 10, like, this matter has to be done in 10 minutes. And I said, well, as long as my friend can be pretty precise on the, on the facts, we can get this done in 10 minutes. And she says, Mr. Runkle will hold you to that. I said, okay. We're at like 10:02. Go. Like, oh, Crown, go. And the Crown like reads out their facts. And then, they take about 2 minutes to basically say what happened. And I'm like, those facts are acknowledged. Here's the, here's the details. And when I got done, I was like, and I would just like to note it is, that's been 8 minutes, Your Honor. So there's 2 minutes for questions. And like she had this little, sort of smirk there. And the thing is, it was fun kind of banter, but it was like, yes, we can get this done in 10 minutes. And the thing is she also would have held me to it, because if I had gone to 15 minutes, she would have been like, Mr. Runkle, you are on my shit list.
Yeah. So there's a really good question, and this one was from Mama MSN, and this is perhaps a not to say a teaching moment, but a moment where it's kind of important to kind of realize that what you are seeing might feel at all times completely horrible, but it's not. There's a lot of this that's common practice. Is it truly legal though to put a time limit on this? Absolutely. In federal court, they rule on the papers, which means that if you put it in writing, you don't get oral argument on these motions all the time. They will rule on the pleadings routinely. And if you don't get to make a point, you don't get to reemphasize, you don't get to do anything else. There was a comment made earlier about lawyers are like goldfish. They grow to the size of the fishbowl you give them. Yes. It was a great comment, because lawyers are, especially trial lawyers, they're theatrical creatures. If you give them a stage, they will take the stage. If you give them time, they'll take the time. If you give them the opportunity, they will take it.
And also, less politely, a lot of lawyers, myself included, don't necessarily know when to shut up. I've had a judge tell me as I'm making, he's like, Mr. Runkle, I'm going to give you what you're asking for, but you are welcome to talk me out of it. And you know how much willpower it took for me to say, I'm not going to talk you out of it. All the willpower, because you just want to, you're like, what your brain is thinking is, I've got 3 more points to make, Judge. And what you have to do is be like, well, then I'm going to stop talking, because why would I talk you out of the thing that, that is what I want.
You have to be very good at managing, which is odd for someone with ADHD, but that's where that hyper focus comes in really well for me. Like when I was talking about the example of having the clock up on my laptop.
Yep.
If a witness goes long in their answer, and I realize, or if I have to make an argument over an evidentiary issue, and I realize that, holy shit, that argument just consumed 10 minutes of my time, I have to reassess my next line of questions. And this is all within a heartbeat, by the way. Reassess the line of questions, what I need, what I don't need, how I can strategically cut some of those questions, and how I can get through those in rapid fashion, but still make them credible in a heartbeat, and still get in under my time, because the time constraints, especially in motions arguments, in arguments or in testimonial matters, maybe you'll get more latitude, but in motions practice and in appellate practice, they will cut you off mid-sentence routinely. So, EDB said the fishbowl quote. See, mine is the microphone. My quote is always the microphone.
I have watched appeals where they have literally said, counsel, you're at time.
Yeah.
The second they ran out of time. The other thing is I've done moot court stuff where I'm like a moot court judge. And, sometimes you got to decide how you're going to do it. And sometimes I've been like the designated asshole judge, like the one that will ask you the tough questions.
Yeah.
And at one point I had a guy who was just meandering. And he got to his time and he was like, justices, I have 2 more points. And I said, no.
Yeah.
And he's like, what? And I'm like, no, counsel, thank you very much for your submissions. And he's like, but, and I'm like, next lawyer, please.
This is a lesson that has to be taught. Now, you were gracious in teaching that lesson in moot court to a student.
That's the thing, is the student initially didn't think it was that gracious, because the student initially was like, that's not fair. And the moot court administrator there was like, No, you got to realize that'll happen. The other thing that there will be lawyers who you get page limits, and there will be lawyers who submit over page limit things, depending
they
on
won't
the
even read it.
courts. There's
They won't
one
read
of
it.
two things that they may do. They may bounce it, in which case you may be over time if you can't fix it in time to get it in. Some of them will just, but the other thing they'll do, and I've literally seen a justice do this in appeals court, is they will say, we're stopping reading at, you're allowed 30 pages. We're going to stop reading at 30 pages. And so I have quite literally seen a justice with the guy's appeal book with extra pages torn out of it.
Oh no.
And he showed counsel. He's like, if what you're referencing is is past 30 pages, I tore those out of the appeal book and I will not consider them. And he's like,
wow.
He's just like, rip, out it goes.
This is also why we have full appellate law opinions on how text gets formatted and how many pages and spaces and lines and formatted text you can use. Because if you give lawyers an inch, they will take an inch and an eighth. Like they will.
It
push
is
the boundaries.
literally, they will, they specify approved fonts. They specify your margins. They specify, the one thing I haven't seen them specify is the kerning. But getting into messing with kerning is a bit of
for those in the chat, that is the shrinking of the space between the actual letters.
That is getting into a little bit of sorcery.
I was going to say, ask me how I know, because we have 5-page motions limits, and sometimes that Times New Roman likes to put a little bit of extra space between like the I and the S,
and you're like, no, adjust kerning.
Oh God, someday a judge is going to see one of these and I'm going to be in so much trouble.
Yeah, they're going to be like, Mr. Morton, let's talk about your kerning. And you're going to be like, oh shit.
Yeah, exactly. Wait, so there was a request to replay this there were several requests to replay this. So Unetti finishes and says, I can't do it in 2 minutes. He says, fine.
Mr. Alessi, I'm going to hold you to 2 minutes. I've got the Commonwealth's motion on the Celebrate demonstration. I'll hear you for 2 minutes on that.
My 2 minutes start when I get to the podium. Yes, thank you.
Made my 2 minutes start when I get to the podium. That's the best. That's the best line of the day. And he gets his binder and everything prepped. So he
The
just
demonstration that the Commonwealth proposes is incredibly vague, and it, to the extent it can be understood, is impermissible. I'm fully aware of what happened in trial one. Not only did I read.
All right, we're going to slow this down, because when I tell you that lawyers can change based on the parameters given by the judge, and that they have elected to take longer than they need to, this is what I mean. And by the way, this is when I think Alessi is his most effective. If you put Alessi in constraints, like on time constraints, I think he's more effective.
The courtroom demonstration that the Commonwealth proposes is incredibly vague, and it, to the extent it can be understood, is impermissible. I'm fully aware of what happened in trial one. Not only did I read the transcript, I went back and watched the video.
That's
The
a
Commonwealth
shot.
states that they want to conduct, I'm reading verbatim on page 1, a courtroom demonstration of how data was stored within Jen McCabe's cell phone. That's it. No elaboration what it's going to be. They're looking to me this is a blank check. Similarly, with regard to Jessica
He's not
Hyde,
wrong.
we'll use a courtroom demonstration to show jurors information and data on both the phones to explain concepts and to illustrate particular information of importance. Vague, again, we have no idea what it's going to be, nor does the court. And there are similar statements, and also on page 2, they concede they want Mr. Whiffen to use the highly
He's on
disputed
Zoom.
extraction reports to demonstrate Celebrate software. It says this demonstration would closely mirror the actual Google searches, but we don't know how. It's obviously not going to do it. And lastly, with regard to the law, section 1006 talks about the witness presenting the summary is not permitted to state deductions or inferences. That's right in the note to the rule, and that's exactly what they want them to do, is to give the deduction and the inference that the 227 timestamp means it came to at 6:30. It's in direct violation of the rule. And secondly, under 1006, the appeals court held that because the presentation selectively presented excerpts of other exhibits and evidence in such a way that it served to both bolster the Commonwealth case and rebut the defendant's case, it was not merely a neutral summary. It was more akin to an argument than evidence. The Commonwealth concedes that's the case. And with regard to Commonwealth v. Sosa, page 14, the only thing that was allowed in Sosa, the case they cite, it says the complete video footage contained several camera angles of the property, and the condensed video merely was a compilation of that which already existed. They just shortened it down. What they're proposing to do is anything but that.
This is
Damn,
my
he's good.
favorite in the world. Side note, my opening statements are always very fast because I'm usually very nervous, and that's also when like the most caffeine and adrenaline is in my system. So I'm usually very quick in opening statements and in preliminary motions, to the point where I've had judges tell me to slow down. I've had a judge tell me they will give me more time if I just slow down so that they can hear me. And for those of you in the chat who have talked about when I get on rants
Were
and
you
start
on
speaking really
full
quickly,
hummingbird?
well, the chat has made comments that when I end up getting on rants, I end up speaking really quick. And that's the case when I'm nervous in court or when I'm frustrated or stressed. So I've had judges tell me to slow down, and I've had judges offer more time because they want to hear what I have to say. But there was a motion made by the chat, which the motion is going to be granted. And I'm just telling you right now, it's going to be granted. Can we get an encore of that at 2 times speed for fun? Absolutely yes. Because I want to hear what this sounds like at 2 times speed. And I think it's going to sound, I actually feel like this is going to hurt my feelings a little bit, because I think it might sound like how I sound at what I think is 2 times speed. So we're going to go 2 times speed. We're going to go ahead and set the settings now. 2 times speed. Oh my God. I don't know what it's going to be. This is going to be wild. Ready? All right.
The courtroom demonstration that the Commonwealth proposes is incredibly vague, and it, to the extent it can be understood, is impermissible. I'm fully aware of what happened in trial 1. Not only did I read the transcript, I went back and watched the video. The Commonwealth states that they want to conduct, I'm reading verbatim on page 1, a courtroom demonstration of how data was stored within Jen McCabe's cell phone. That's it. No elaboration of what it's going to be. They're looking, to me, this is a blank check. Similarly, with regard to Jessica Hyde, we'll use a courtroom demonstration to show jurors information and data on both the phones to explain concepts and to illustrate particular information of importance. Vague, and we have no idea what it's going to be, nor does the court. And there are similar statements, and also on page 2, they concede they want Mr. Whiffen to use the highly disputed extraction reports to demonstrate Celebrate Software says this demonstration would closely mirror the actual Google searches, but we don't know how. It's obviously not going to do it. And lastly, with regard to the law, section 1006 talks about the witness presenting summary is not permitted to state deductions or inferences. That's right in the note to the rule, and that's exactly what they want them to do, is to give the deduction and the inference that the 227 timestamp means it came to at 6:30. It's in direct violation of the rule. And secondly, under 1006, the appeals court held that because the presentation selectively presented excerpts of other exhibits and evidence in such a way that it served to both bolster the Commonwealth case and rebut the defendant's case, it was not merely a neutral summary. It was more akin to an argument than evidence. The Commonwealth concedes that's the case. And with regard to Commonwealth v. Sosa, page 14, the only thing that was allowed in Sosa, the case they cite, it says the complete video footage contained several camera angles of the property, and the condensed video merely was a compilation of that which already existed. They just shortened it down. What they're proposing to do is anything but that.
I'm just stunned he's like totally understandable, because that was like 100% comprehensible. I could follow that perfectly. Damn. You
That
put
is
me
what
at 2 times speed,
enunciation
it
does.
sounds like, oh.
Wow, that was something else. Mr. Alessi, holy crap. That is what enunciation is, and that's what it looks like and sounds like. Holy shit. Okay. All right. Now, unfortunately, we have to listen to Brennan. That's going to be the end of it for the rest of the day.
Appreciate your brevity too. Thank you.
You're welcome.
Mr. Brennan?
The appreciation of brevity, people thought that was a slight. That wasn't. That was actually a recognition that the argument was made very concisely, holding to her time, wasn't needed to be warned. that's an actual compliment, folks. That one is an actual compliment.
The demonstration we would be asking Ian Whiffen to engage in is the same demonstration as he did at the first trial. No different, based on the same qualifications, based on the same experience. It is essential that the jury understand and be able to see the data in action so they can appreciate the legitimacy of how the data is stored and how those windows are opened. As far as Jessica Hyde, we've provided a number of different reports. We would like to provide chalks that come directly from those reports. So if there's anything that's particularly offensive in those chalks, I'm willing to discuss it with the defense. There would be nothing new or different than hasn't already been provided. It would be simply blowing up the photographs or the exhibits in her reports so that the jury can read along and see them.
Okay, thank you very much. I'll get it.
That's brevity. Okay. The chat is also saying I have to get to the point that Jackson makes. It's at the end, wasn't it?
Over to the crime lab, how that's supposed to be done, what types of logs are kept and why those logs are kept, how you bag evidence, how you secure evidence, how you maintain the integrity of evidence,
How you
and
solo
things
cup
of
the
that
evidence.
of that nature.
I hate you for that, but it's also very accurate. How you solo cut or how you solo cup evidence. Yeah. So
Hey, listen, if evidence wasn't supposed to be solo cupped.
So here's the thing. So there is a defense that you can run where it's not necessarily pointing to a third party directly. It's not necessarily saying, you know, they don't have the evidence to prove that I did it. What it is called a Bowden Defense in Massachusetts. And what it basically says is the investigation was so shitty that they ignored actual individuals that could have done it to the exclusion of everybody else. They focus on this one person. And they got the wrong person.
And you might be saying, why is this a thing? Well, because this is not the first person it's happened to.
It is not. You ever see the cases where individuals will come back to the court on a habeas petition several years later after another person who was incarcerated ends up confessing to the crime? They do DNA check and it's like, oh, this person did it. That is this type of defense. So it's, you need to be able to challenge an investigation. You can absolutely challenge an investigation. But what Hank Brennan makes is a very conflated argument. Go figure. That's his modus operandi. To say that, you know, if we allow them to put on an expert to say that the investigation was bad, then I should be allowed to put on an expert to say the investigation was good. 2 points. One, no, you cannot take something and put on bolstering testimony about your own fucking investigation. It's a fundamental premise that it is a fundamental flaw in understanding the two different roles between the parties. The defense can challenge the investigation. You don't get to bolster it. Now, Brennan makes a point of, well, if they challenge it, then shouldn't I be allowed in redirect to bring up that, oh no, it was in fact a good investigation, which is actually true. If they challenge the investigation, I get to come back up and say, no, it was good. We followed rules. We followed standards. There was nothing about the investigation that led us into a different path or to the exclusion of other potential witnesses or not witnesses, defendants.
There is certainly, I would indicate to the court that 702 in Massachusetts.
Oh, Julie, you're trying to make me mad. But Rob, the Commonwealth has rights. For those of you who have not heard my rant on this previously, or who have not been to the channel, I am always going to lean a little bit further towards the defense side than the state side, just natural inclination, for several reasons. One of which is I think that people have a fundamental misunderstanding of what beyond a reasonable doubt actually means. I think too many people and too much culture has been focused on bad guy did bad thing, therefore bad. And it is too easy for people to misunderstand the burden of proof that's placed on the prosecution. 2, the prosecution is an arm of the state. The arm of the state is and has all of the resources available to it infinite money, infinite resources, infinite experts. Take a look at this trial, for example. They didn't like the experts they had at the first trial, so they swapped them out, got new ones. They don't want the ME, so they have a new expert. They have the power of investigative subpoena, warrants, etc. They have everything. So when the state gets up and says that I have a fair trial, no, you don't. Respectfully, no, you don't. You don't have the right to a fair trial. You already have everything else that slants the deck against the defendant. The defendant has the right to prevent you, the arm of the state, from overusing that authority and power to bludgeon them into an unfair outcome.
This is like prime of his life Arnold Schwarzenegger complaining that he's not getting a fair fight against Stephen Hawking. Like, you know, it's like, sorry. You know, and it's like, it's not a fair fight because he's got that powered chair. It's like, yeah, no shit.
Yeah.
Like,
and I wish that this, I had a very uncomfortable discussion a while back, a couple weeks ago, and I finally got the question asked by Mini Mischief 1, who is 11 years old. And I was kind of surprised. No, it wasn't really. It was about the right age when I would expect it to be asked. How do you defend bad people? First time it came up. How do you defend bad people?
You're like, with a knife.
No, it was asked in earnest, and it was very interesting. How do you defend bad people? And it was going back to, well, bad people deserve defending because you cannot make the rules based on the worst of us, and giving that explanation of it. And then also kind of saying about the power of the state, the power of the prosecution. And what I really do wish is that that question would not need to be asked of me. I really wish that our schools did a better job of educating individuals in civics, which we need to bring back into schools, of what this standard actually means. What it actually means to hold someone to account beyond a reasonable doubt and hold that burden of proof to the full extent that it's required. We've lost that in our education system. It's not there anymore. There is no more presumption of innocence. People might say it, but it doesn't exist. Not in social media, not in the news, not in the daily communication between friends. The number of times that I get looked at skeptically when I try to talk about people that are criminal defendants or people that are my clients. It is asinine. Well, not asinine. It is wild to me how just immediately offended people are by the fact that I represent people in family court. And then I tell them something that's even more astounding.
Well,
I
at
say
least
that
one side has to be the asshole in family court. And the thing is, it's almost always both of them.
Exactly. Like, thank you.
At least one of you has to be the asshole, and they're fighting over who it is, and they both think
and
it's
usually,
them.
I don't even go so far as to say that someone has to be the asshole, but they all make bad decisions. You just do. It's a consequence of being a parent. And then it's a natural consequence of being two parents that are remarkably adverse to one another. So in family court cases, there is no person that is the quote unquote bad person. I get a lot of shit for that. But when I start breaking down cases and talk about the gray area that exists in these cases, it becomes very, 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 I don't know. And then you start to see people defying logic, where I start to give them the cases and the analysis of it, and they start to really argue against me. And it's they want to find the exception without understanding that the general premise is the rule. So you start to see a shift in culture and how culture views these things. And right now, on the criminal side, in the context of criminal accusations and criminal defenses, and honestly, even in the civil side, when there's certain accusations being made against people in social media, it is pretty wild to me that we as a culture have completely lost the presumption of innocence that exists in the criminal context. Civil is different, but criminal context. And we have lost an understanding of what it means to require the Commonwealth or the state with all of its infinite resources to prove that someone is guilty beyond a reasonable doubt. So I always lean a little bit further towards the defense, and I will always adamantly argue that the defendant, the individual defendant who is the individual, not the arm of the state. The individual has the right to the fair trial.
And Rob, you've got a weird
have that.
echoey something with the audio.
I'm
And
sorry.
it's not me because I tried muting, and it's still there.
My rant is over anyways.
Yeah, I don't know if there's a way to like reset the audio or something because
I can try. Let me see. Hang on. Maybe I was just staying away from the microphone. Either way. Oh, people are saying they don't hear an echo. Either way. Yeah. That's why I get my back up when there's arguments about people that make the argument of, but the Commonwealth has a right and the state has a right to a fair trial, or people start making comments about defendants or how do you defend bad people because they deserve to be defended.
Massachusetts mirrors very specifically 702 in the federal courts. It's literally, I looked at them side by side. They're nearly word for word. And the advisory committee notes for federal rules of evidence 702 is very, very instructive on this particular issue, specifically as it pertains to somebody with the expertise in a field like crime scene investigations and investigative protocols. And what the advisory committee notes say is, quote, 702, the rule is broadly phrased. The fields of knowledge which may be drawn upon are not merely limited to, quote, scientific and, quote, technical, the scientific and the technical, but extend to all specialized knowledge. Similarly, the expert is viewed not in a narrow sense, but as a person qualified by knowledge, skill, experience, training, or education. Thus, within the scope of the rule are not only experts in the strictest sense of the word, for example, physicians, physicists, and architects.
Guys, given the time that we've been going 5 hours and 20 minutes, I have to start pulling chats up. I'm going to start pulling them up and leaving the questions, but I'm going to start pulling those up while arguments being made.
But also the large group, sometimes called skilled witnesses, such as bankers and landowners testifying to land values. Now, again, obviously, we're not dealing with a banker or landowner, but the advisory notes and the advisory committee on the rules of evidence 702, the federal rules of evidence 702 clearly lay out this is exactly the type of field that is subject to expert opinion. Clearly, the Rule 702 allows for experts with specialized experience, specialized knowledge, specialized education, beyond that of an average layperson, in particular, in a field without, or in a particular field, without resort to, for instance, the generalized scientific methodology that we've heard so much about in some of these motions in limine. I can go through some of his credentials, but Mr. Easter is eminently qualified to provide the jury information about proper and accepted investigative techniques and protocols. As the court noted, or as I just noted to the court, he was an FBI special agent for more than 20 years. He formally coordinated with multi-agency investigative gang task forces in Los Angeles. He worked with multiple agencies responding to dozens of crime scenes, including shootings, stabbings, abductions, child abductions, both domestically and internationally. He was the lead case agent who oversaw arrests and indictments. He received awards and recognitions for his work with the FBI, as well as with state agencies in which he was a task force member. For 11 years, he primarily assisted homicide detectives from LAPD, the Los Angeles Sheriff's Department, and the Los Angeles District Attorney, numerous other agencies as well, state and local agencies, with investigations and prosecution of thousands and thousands of homicides, robberies, kidnappings, other violent crimes. His work and assistance on investigations in LA and across the United States and ultimately internationally has been noted by not only the FBI, but those agencies as well. Just a few of Mr. Easter's experiences and involvements in some of the domestic and international cases include the 2015 San Bernardino mass shooting.
So are these all on his CV that you're going to give me a copy of?
Everything.
Yes.
I believe all.
So I don't need you time again of the restraint. If you're going to give me a copy of the CV, I can read it. You don't need to recite it.
It's either what I was reciting is either in the CV or in his report. What
Okay,
are
so
the other?
that's what I need. That would be much more helpful to me.
Then I don't know what more the court would like for
So
me
I
to have
wanted to know
specifics.
specifically what you intend to have him testify on. But if it's
It is the part of Bev that bothers me and a lot of other people is when you contrast this with the first judge didn't make you guess. Like he came straight out and he was like, I need to know A, B, C, D, E. And then when you started giving your answers, like, no, I want to redirect you here. Bev says, it's your motion, make your argument. But then halfway through says, is this all in there? And you're like, well, yeah, but you told me to make my argument. And then you say, I don't know what else you want. And then she starts to say, but well, you made this comment and starts alluding to something, but just ask the fucking question. Equality made a really cute comment. If my membership was a baby, he'd be talking. That's cute. So, all right, go on,
It's in his
Jackson.
report.
It's in his, it broadly is in his report. I don't know exactly every question I'm going to ask him, but I can tell the court in broad brushstrokes. Obviously, we're going to ask him, we've already asked him to review. He's reviewed NOD 1 through 59. We're going to give him the additional NODs that we've got as well. He's going to review everything. And from that, he's going to
Coming on the earlier
I
judge,
expect,
yes,
render
I
an
would
opinion
love to trade.
about whether or not the investigation followed standards and training, best case practices for an investigative
So I guess
technique.
that's my question. So without seeing the report, where are there standards and best practices? Is that something that somebody can turn to and see codification of it? Or is
So-
it just his experience?
No, it's not just his experience. Those standards and practices are oftentimes reduced to writing. They have been reduced to writing with the Massachusetts State Police. So he's reviewed the protocols that are in place for the MSP.
Okay.
He's very familiar with FBI's protocols for investigative techniques and investigative protocols. He'll utilize those skills and that knowledge base to assess his opinion, or to render an opinion and a conclusion concerning what he believes are the proper protocols that should have been followed in this case. That goes directly to our Bowden defense, and he is the primary expert that we would use to propound that Bowden defense.
All right, can you get me that report before you leave? Do you have it extra?
I think
All right.
I think we probably have an extra copy of it. Yes.
Mr. Brennan, did you want to respond?
They did talk about ARCCA.
Mr.
Drain
Easter
the
was
water.
a agent who did CAST. He did the CLSI. He may have been in hundreds of cases. I'd like to know what cases he's come in.
Was he air quotes? Did he air quotes that?
Mr. Easter was a agent who did CAST. He did the CLSI. He may have been in hundreds of cases. I'd like to know what cases he's come into court and given his subjective opinion about how he feels an investigation was done. Not a report, not an assignment, but as an expert witness in Bowden. How many cases has he gone into court and testified and been allowed to testify about his personal opinion? His experience in the FBI is different than Canton Police Department and the state police. This is just Monday morning quarterbacking, and it's an attempt to bolster argument by counsel so that they can use.
No.
His experience is different with the FBI because the FBI is competent.
Arguable. Competent at
More
certain
so
things.
than this.
Oh, yeah, no, you're not gonna have an argument there. I mean, remember I talked about the minis? I think I could teach Mini Mischief 1 and 2 about evidence collection. They might do better than this. We should test them. I like this idea. Yeah. No, he's not bolstering their argument. He is articulating from a factual basis, using the actual standards that are employed by the Massachusetts State Police, that the investigation here was below and subpar, which is what they're allowed to do in a Bowden defense.
You know what qualifications you need to determine that this investigation was below and subpar?
Reading?
You need to have studied at the University of Having a Fucking Pulse.
Yeah.
The graduation test is, can you fog a mirror?
Well, the graduation test wasn't snowing.
Like,
use some type of opinion to lean on when they're arguing to the jury. They should have doubt because of the police investigation. I don't see any recognition under 702 or in law where somebody can come in and subjectively give their opinions. If there is a state police protocol that wasn't.
I told you there's a penetrometer comment. I told you Baby Gator had it. I think Hank is bringing up the gigabytes. It's just him wanting to have a dick measuring contest. Time to pull out the penetrometer. I told you.
Follow, then the defense can see if that state police protocol is appropriate. If they're speaking to a state police officer, question them about it and ask them if they did it and why. If this person comes in and gives opinions, there'll be a slew of opinions that are shot like a shotgun approach that we'll never be able to have an opportunity to explain. Are we going to call in the Canton Police?
No, I'm pretty sure I can explain why collecting blood evidence in a solo cup is a bad idea. I'm pretty sure I have enough expertise to do that. Or why
again, the University of Having a Pulse.
Or why putting evidence in a quick stop or a ShopRite or a shop bag is not an appropriate method of storing evidence, or that a fucking leaf blower is not what you would use to clear shit out of the way at the scene of a crime. I'm pretty sure I could do those without, going into like a million different things. Just guessing.
Police department again and call in the state police for a second round so they can explain why they show certain actions that Mr. Easter is criticizing. I don't think this is an appropriate ground for an expert witness. I don't see any cases, I've looked at the state and federal court, that allow an expert to come in on a Bowden defense and give their subjective opinion about an investigation they weren't involved with. I don't know that this witness has ever been qualified as a Bowden type witness in any court. He may have testified, but about what? And so I think this is a very dangerous proposition. What if the Commonwealth wants to counter and bring in a state police officer to say that the investigation was fantastic, that everybody did a remarkable job under the circumstances? What if we bring in a witness to talk about the fact that the evidence is so overwhelming that it should imply a certain finding by the jury? This invites that.
The thing is who are they going to find to come in and testify under oath that this was a great investigation? Because I can tell you, I would need a lot of money for that, because that would be the kind of money you need to retire
And your
on.
career. Retire.
It would be like,
because you're not ever testifying again.
Yeah, it'd be like, so how much did they pay you to do this? $37 million. And was that enough money?
Yeah,
I don't know.
I would
Probably not.
Oh. Reading drug side effects. Yeah. Defense witness list equals a royal flush. Commonwealth is a pair of twos. I'm not even looking at the witness list. It's just.
This guy is the opposite of a drug side effect. Whatever having an erection for 6 hours is, he's the opposite of that.
Oh my God. Oh. Okay. Guys, Ian said it, not me. Just saying. Okay.
This invites a debate between people's personal opinions. That's done outside of the courtroom, not in a courtroom. We will never have an opportunity to be able to have all the witnesses come back to explain what this witness subjectively thinks was a deficiency. I don't think it's appropriate for expert witness testimony. This is argument by counsel.
Very briefly, I gently disagree with Mr. Brennan. He indicates that we want to use an expert.
This new I gently disagree.
Don't
It's
gently
really
disagree
starting to
with
bug
him.
me. You don't gently disagree. You violently disagree. Let's be honest. I violently disagree with that premise. Just say it. We all know it.
Our argument. There's another word for that, or another phrase for that. It's called presenting a defense for someone charged with murder. He indicates, well, what are we going to do? This guy's going to go up there and testify. What am I supposed to do? Call a bunch of other Canton PD officers to talk about how great their investigative techniques were? Yeah, there's another word for that. It's called rebuttal. That's what you're supposed to do. And then he says, well, hang on.
Be objecting if they called somebody in rebuttal to reinforce.
Well, here's the thing. Rhetorically speaking, any lawyer would absolutely be objecting if someone called someone in rebuttal to say the investigation was perfect. They would be objecting because you have to object. Whether a judge allows it or not because you open the door to challenging the investigation, I don't know.
A great investigation.
Oh, no. Mr. Brennan said, what if I called in a Massachusetts state police officer to say that this was the best investigation ever? I have two words. Do it. Do it. I'd love that. I'd love a shot at that.
So I said, let's take.
He's like, this isn't an insult. This is
an invitation. It's an invitation. And you know what? Bev makes the point. Like I told you to keep the hyperbole down. Now here's the challenge. Hold them both to that standard. But which I wish you would, but you don't routinely, and it bothers me a lot. It is a little hyperbolic. But judge, here's the other question. Actually, I take that back. It's not hyperbolic because the judge set it up that way. The judge literally asked him a question that begs the hyperbolic answer. You wouldn't object if they called someone to say that this was a terrible investigation. You're either saying absolutely I would object, or yeah, fucking do it. I take it back. That answer is appropriate.
That was that investigation ever. I have two words. Do it. Do it. I'd love that. I'd love a shot
Okay,
at that.
so I said, let's take personal.
That's not an invective. That's not a personal shot, Mr. Brennan. I'm just saying, do it. You want to call in another expert? That's a classic battle of the experts. That's fine. I'll put Mike Easter up against any expert they want to call. But the reality is, Your Honor, we're in.
I thought he said Mike Easter. I was like, sir, why are we talking about your keister? No, he said Mike Easter. Wow.
You know that he got mocked for that, like, throughout his life.
I'll put my keister.
He's like, I'll put my keister up on this.
Because it actually makes sense when you say it that way. I'll put my keister against anybody. I'll put my ass against it. Maybe it doesn't make sense. No, but Mike Easter makes more sense.
Entitled to present a defense. And part of that defense, the Bowden defense, is the adequacy of the investigation. And there's no question that a proper homicide investigation is not something within.
I don't know. So if you can give me a case site for that, all right, that expert testimony regarding a Bowden defense, I've never seen it. I've never seen it in research or anything. So
I've got
a
it.
Case site.
There are certainly cases outside the jurisdiction.
Yep, Massachusetts case. If not, you can give me the outside.
Didn't they put one on in South Carolina, Murdoch?
I think so, yep.
Cases, but I don't believe there's a Massachusetts case where this has been done.
We have searched and searched for a specific case in Massachusetts. There, to our finding, there isn't one directly on point, but there are plenty. There's a myriad cases outside the jurisdiction where investigators are called consistently, especially on behalf of the defense, to talk about adequacy of an investigation.
Right.
That is an expert field, one that's utilized throughout the country all the
some
time.
authority, and the more persuasive the authority, the better chance you have at this. Okay.
Sure.
All right. So I think that's it for the motions in limine. Did I miss anything? All right. I need that. Oh,
Your Honor, earlier you alluded to, this is what defense wanted to talk further about the ARCCA issue, the Rule 14. You said we'll wait for it. We'll put that off until the end, if I heard you correctly.
I thought you and Mr. Brennan were going to talk about it first. Is that your understanding, Mr. Brennan?
Yes, and we have none.
Yes. So that was my understanding. So impanelment, you don't have anything for me for impanelment?
We have not spoken.
Karen, if I may, on one point on the impanelment.
Sure.
I just know it's the court's preference to have a one-page front and back questionnaire.
Yes.
I was wondering if, in light of the unprecedented pretrial publicity in this case, if Your Honor would consider an additional one-page juror questionnaire that deals with just pretrial publicity. Last month in the Chisholm case, the SJC outlined kind of appropriate questions.
Right.
If in additional to the front and back, there was just one questionnaire that focused just on pretrial publicity, I think that would expedite the impanelment process.
I think that makes sense. Is there any objection from the defense on that?
No.
There's been an extraordinary amount of publicity, even far more than the last trial, and so close to jury impanelment. It makes sense to me.
Oh, I'm sorry, Your Honor. I was looking at outside cases. No, there's no objection.
All right. So I need the joint questionnaire, and it can be that third page, Ms. McLaughlin. I think that's a great idea. And I was thinking about Chisholm earlier when I was expecting something from the parties. All right. File your questionnaire, file your proposed questions that you would like me to ask the venire and that you would like to ask at sidebar. I need that by tomorrow. So tomorrow by the close of business, I need that. So if I need to see you again next week, we'll let you know on Monday. All right?
Yes, Your Honor.
Okay.
Well, obviously, it'd be the day after Monday, right?
Yes, Mr. Chair, it would be after Monday.
We did file 2 motions today that at some point we'll need a hearing on.
Okay.
The defense just received notice this morning, so we're not prepared for today, but we would want a hearing on both of those motions. The sooner, the better for us.
So why don't we come in next week?
Jade, you can't investigate the attorneys. I mean, that would be done by the bar first rather than the feds. It
unless
likely
they
is
did
the
something really
yeah, really bad. All right, that's the end of today's legal proceedings. A couple of questions I wanted to highlight, and a couple of the larger super chats that I had missed. I tried to get through as many as I could, folks. I really do apologize. It was a lot to cover. Let's see. Strains credulity. We pulled this up earlier. Questions. Why did Bev say material and deliberate, but then make 0 sanctions? Why make such a big deal? To make a point. That was it. It doesn't have any impact. Lawyers take that on the chin, and we keep on moving. Will the Proctor's firing affect the Commonwealth case? Will he plead the 5th? Likely No on the 5th. I don't see any criminal behavior because he's likely protected under some form of privilege, qualified immunity, etc. How it will affect the Commonwealth's case, I don't know that it does.
I mean, it certainly will, at least a little bit.
It will. I mean, what I mean from the
Defense is going
Commonwealth's
to bring it up
perspective,
nonstop.
that's what I mean. For the defense is going to bring it up. The Commonwealth getting in front of it, I don't know that there's really anything they can do. I think they have to.
I think
you
they
cannot
try.
not put on Proctor. You can't not call him from the Commonwealth's perspective.
Yeah, and I think they try to get ahead of it.
Yeah.
I mean, the interesting thing will be, what is Proctor's take on everything? Because it's sometimes you get people like this who might be pissed, right? He might come in and he might be upset that he's been fired, and he might be like, "This is not fair."
Well,
It's possible he comes in vengeful, but I doubt it.
It might play for the prosecution, though.
Maybe
it could. I mean, think about it. It could. He's been reprimanded for the poor conduct. It doesn't mean that the investigation was shit.
Well, and the other thing they could say is he's been reprimanded, like he's been, removed. He's no longer got any incentive to say anything, because he's already had every bit of punishment he can have on this. And therefore, he's totally believable. I could see them spinning it like that.
Mm-hmm. Will the Karen Reed documentary hinder the case? Let's make this more broad. Will the extrajudicial statements made by Karen Reed to third parties, including news media,
if this gets Yannetti, like her messages with her lawyer in, then yes. Like that is hurting the case if that goes in. And because they'll find something in there.
Yeah. Purple Dragonair, can you and Runkle give the fur babies extra love for me? Absolutely. I just lost one of my fur babies today. I'm so sorry, Purple Dragonair. He was an old man that had been on decline for some time. Well, the Rainbow Bridge
doesn't necessarily make it easier.
The Rainbow Bridge exists. We lose our loved ones, and it doesn't make it easy, but those fur babies deserve all the love because they give us all the love without anything withheld.
And
Creative Chaos,
every one of them, you keep a piece of them.
Absolutely.
So
Creative Chaos, I think jobs should still hire you whether you have a felony or misdemeanor.
I'm not sure if that's on purpose, but that is some impressive maybe that might be.
I get felony misdemeanor.
I think jobs should still hire you.
Oh,
if you have a felony or misdemeanor.
Okay.
That's what I so it's like, yeah, maybe a criminal record shouldn't be disqualifying from getting work. I can get behind that.
No, not from getting work. I'm behind that. Yeah. Terry Lebeth, my 85-year-old mom just was diagnosed with non-Hodgkin's lymphoma cancer within her brain, asymptomatic. Saw a brain scan. One is golf ball size, several other spots. Thanks for distraction. Terry, I'm very sorry. That is very rough news to get. Hope that you hold your family dear, close, and hopefully the distraction tonight was a little helpful in dealing with these challenges. But I've said it before, fuck cancer and the horse you rode in on. I think we can all agree in that regard. So my thoughts and prayers go out to you. Marmar coming in with celebratory news. I'm a party to the case. This is the case involving the case that she's been messaging me about. They'll not try to remove me as guardian. Uphill battle for right now, but I have a good lawyer and lots of docs. Good lawyer and lots of docs is a good way to go. Congratulations. Fingers crossed indeed. Beautiful messy ball. I apologize if objection that this was asked and answered already, but why is Brennan even on the Turtleboy case? He was not. He was asking in the Karen Reed case for discovery of material in this other case. So he was not on that other case. He was asking it from another Commonwealth attorney. Semper Props Since this is a new trial, can witnesses from the first trial be impeached if they're called to be a witness in this trial? Yes. Their testimony in the past trial is absolutely can be used for impeachment. They have to be careful about how they use it, but how they bring it up. They have to say essentially, you've testified under oath in this case before, right? But they can't refer a prior trial, but yeah, it can be used. Also, can Lolly be called as a witness? No. Texas Prime, it doesn't seem like a win for Brennan if he wanted the whole phone, just got through the whole phone himself, just to go through it himself. It wasn't. He picked his wins and he picked his losses and he knew where the wind was blowing. So he basically scaled back his request to something more reasonable and the judge gave it to him. Blessed in Texas.
There's a lot of blowing there.
All right, the phone handover. What do you say to someone who says, I don't have anything to hide? Facepalm. I say facepalm. That's what I say. I say facepalm. Purple Dragonair with the intelligent comment. My phone factory resets if you try to guess my password too many times. Proper. Froggy Girl, will this be part of the trials of the century? God, I hope not. I can't imagine it will be. There's not. I don't know. I don't know. We'll have to see how the second trial goes. Blessed in Texas, what do y'all think of AJ criticizing Judge Bev in the docuseries? This comment got made about Alessi and the
So
the comments get made about the decorum and the way the lawyers treat each other and the way the judge treats each other. Here's the thing. As a lawyer, as a litigant, or as a litigator, you have a thick skin. You can't make it very long in this profession if you don't. There's a whole lot that a lot of people would view as very insulting, demeaning, disrespectful that we hear on a daily basis. There's a reason lawyer jokes like lawyer jokes are a thing. So judges, some can be more prideful than others. It shouldn't impact their rulings. It does sometimes. I don't know that I would have made the same comments, but again, I'm not trying this case. Zoe, number one thing I've learned working with AUSAs is a lot of people's computers are concerningly gross. Like, I thought the Duggar case was an outlier, but nope. It's a lot. Just because if Karen Reed could get a federal investigation done for her benefit, why would she not be able to mess with MSP or CPD? I don't know. Greg, fellas, kind of off topic, kind of not. Badero released a new letter on to Morrissey and has revealed that Colin Albert's mom, Julie, wrote Morrissey and possibly had editorial control over his hostage video. Well, that would be very fascinating. Karen Bobaron, any update on the pen? It's sitting right here, not rushing, just curious. It's sitting right here next to me, literally. I still have it. I'm sorry. I have screwed up the printed box 3 times. To get it right, it will be on its way. I promise you. And you have the right to start rushing me. You 100% have the right to start rushing me. I am feeling pressure, and I should. Crispy Cookie, first FNF in a while. Life has been getting in the way. So glad to hear y'all. One of my favorite things about this whole session is Nathan Reed's facial expression. Thanks for all you do. It was pretty wild. There's a lot of facial expressions today. Well, yesterday. Actually, Linnell, I think Brennan's best statement was, quote, Karen wanted the FBI to look into her case, end quote. What guilty person does or goes to the feds and says, can you help me? You're trying for a murder. Make it make sense. That was what Ian was making the comment about, is no sane person says, hey, let's introduce the fact these people did the investigation and say they were from the FBI when they are the defendant.
Yeah. I mean, because what are they going to assume? They're going to assume you are, that the FBI was investigating her because that she was somehow in the wrong or at fault.
Yeah. John comment, question, what's the purpose of Lolly being in the courtroom anymore? I don't know the answer to this question. He's not spoken in months, and when the camera is on him, he's just staring down. I don't know the answer to this question. Maybe this is punishment for him not getting the first trial to a conviction. Maybe. I don't know. But I can see why he would be a benefit being in the back office or being there for very important hearings. But every hearing, I don't know. Edward Kirkpatrick, Commonwealth has been devious before. There is a colorable argument if Karen Reed is not there for a hearing on her case number. She has broken the bond that says she must be present for every hearing. Oh, I didn't even think about that.
I think they'd have a hard time with that.
I don't think
Especially
there's
if
a
they
judge.
denied her ability to be there.
Yeah, I don't think there's a judge in any jurisdiction, no matter who, it's going to be able to grant that one. Greg, I think what Unetti was asking is totally fair. They don't need to tell the jury why or when the FBI hired them, just that they did. It begs the question for additional questions. That was the point that I was making. Baby Gator, Your Honor, I'm not trying to stifle the defense, but I'm trying to stifle the defense. Yes, the most egregious of Hank Brennan's misstatements this today, not misstatements, but mispronunciations, was instead of using the term stifle, as in to stifle or to quash or to quelch or to stifle, he said stiffle, which is a pronunciation I had never in my life heard before. But,
and you'll probably never hear again unless Brennan does it again.
Gonna be something worse, I guarantee you. Kate Maybe, are we going to cover the motion for Unetti and Karen's texts? Curious your thoughts on if her making public statements waives her privilege. So here's what I'll say about this, because there's been a lot of questions about this, and I know that Ian has a summary or a statement. Let me pull this back up. Let me get through some of the others, and I'll get back to this one. Potato, sup boys? I'm having a crappy day. Probably not as bad as Karen's. I hope the weekend is brighter for all of us. Prayers for all. Hope is there for tomorrow. Indeed, Potato. Thank you very much. Nicole has ADHD. Perseveration is like really sticky hyperfocus. I loved that comment. Texas Prime put it this way: I miss Judge Carroll from the Kowalski trial. Me too. I would love to see Alessi in Judge Carroll's courtroom. 1,000%. I think those two would vibe. Lady Fang, how shocked were we that Proctor was fired? Surprised.
I was stunned.
Pleasantly surprised. Not because I wish ill on anyone, but because that offense deserved firing. That's it. Happy Annie, is it the defense's responsibility to provide info on people they aren't calling? No. The third expert wasn't called, and it was Bev's ruling why he wasn't. I know, which is why I hate the conflated issue. Kelly Kell, my law school professor quotes, I forget who it is. I'm sorry for such a long letter. I didn't have time to write something short.
Yes.
Very lawyer quote. Lucy Wu, thank you for all the Friday nights that you kept me company for the last 20 months. I've completed my MBA program in February. Yes. With F&F as my focus, noise. I appreciate you and Runkle so much. Lucy Wu, congratulations. That's amazing news.
That is
Megan.
That's a huge achievement. So.
Absolutely. Megan, aka Meg, is autistic. I listen to you and Ian on in EDB on 2x speed all the time. I'm sorry, Meg. I'm sorry. But apparently not, because it stops you from drifting off in my mind. Alessi on 2x is perfection for my brain. Enjoy golf. Thank you, Meg. JB,
now
guilty
imagine
until
Alessi at 4 times.
No. Bad. I can't do it. Shay B, guilty until proven innocent for those accused. That tends to be, once the accusation is made, it's very difficult to walk back from that. Almost impossible.
Oh, and the number of people who've had their lives ruined by the accusation is not a small number.
No. Absolutely not. Let's see. Last few. Shay B made the comment, please support the Playground Project. So there is a chat pinned at the top of the chat. I'll also put in the description below. For those of you watching, please, it would be very much appreciated if you wouldn't mind taking a look at that link. A very dear friend of ours is running a 10K and a half marathon at Disney, and doing so in support of rebuilding a playground in honor of 2 children who lost their lives in a house fire. So that is what's pinned at the top, and it's a friend of ours that is doing that run. So please, if you want to, please consider donating to that. it would be very much appreciated. Sophie and Madigan's playground project. So that's pinned. I'll also put in the description below. Sparkly Cupcake, they should get an expert from the law enforcement accreditation body, CALEA, regarding best practices. Best practices is not really an indication of a shoddy investigation. Best practices is best practices. It does not necessarily mean you failed in every regard, which is what they actually want to get to.
I was going to say they failed in every regard as well.
Yeah, I agree. Nikki ZBZZ, my opinion on the Commonwealth adding defense attorneys as a witness. Give me 1 second. Shay B must have a pen. Shay B, I wish I could indulge everybody. I've got a couple in a backlog to make. We do auction them occasionally, so stick around. There might be a time when we can auction them, but that can occur. So getting to these two questions, the opinion on Commonwealth and defense attorneys witnesses and the text messages between Yannetti and Karen Reed. So the impetus of this motion is there's a motion that's been filed to turn over these text messages between Karen Reed and Yannetti because in the docu-series and in one of these interviews, Karen Reed talks about conversations that she had with her attorney. And one of the first rules to attorney-client communications is that communication is sacrosanct and it is privileged, except and unless it is waived. And certain things can waive the privilege. You don't have to expressly come out and say, I hereby waive the privilege. You can engage in conduct that waives the privilege. Let me give you a really good example.
Which is far more common.
Very common. Really good example. I have people that want to meet with me as attorney and client when they want to have their parent or a sibling in the room while we have a consultation or a meeting.
And you're like,
the sheer act of having them in that room vitiates, which means extinguishes, it's a waiver of attorney-client privilege. If there's someone else present in that room when I am having a discussion with my client, anything said in that room, whether it's said by me or whether it's said by my client, is not privileged anymore. Similarly,
I have
the
people who like forward your emails to, to like their brother or whatever. It's like, oh shit.
Well, it's funny you say that because I had a case recently where my client, I had blind copied them on correspondence to counsel, and I was on the phone with them while I blind copied them and said, while on the phone, hey, I'm blind copying on this, sending it now at this very moment. Don't hit reply. This is just to keep you informed. 2:00 in the morning, they hit reply all and added the opposing party.
No.
That is definitionally a waiver of attorney-client privilege. Similarly, let's say that person was out in public and said, I had a conversation with my lawyer and I told my lawyer X. It's no longer privileged. I had a conversation with my lawyer told me X. No longer privileged. So Karen Reed making comments about communications with her attorney might actually vitiate the privilege. It might be an actual waiver, and it's going to depend on the case law and how it reads. Is a judge going to be very... Go ahead.
The other thing is going to be the scope of the waiver, because let's say they say she waived with respect to that conversation. Does it also waive with respect to other stuff that might have been discussed around that? And the answer is maybe, because sometimes it can sort of bleed to certain topics and so forth. So all of that
also depends on it also depends on what is said, because if you make the comment that you had a conversation, so the existence of a conversation, but not the substance of the communication, have you waived privilege as to the fact that a conversation occurred? Yeah, you did. You said there was a conversation. Did you waive privilege as to the substance of that communication? Did you talk about it at all? No. So have you waived it as the substance? I don't think so. These are very contested, and I will tell you that when the judge is considering attorney-client privilege and waiver issues, you are at your very highest level of scrutiny. And I think the argument that this opens the door to a knowing waiver and access to all communications is a pretty
It's a scary
big
one.
leap. It's a very scary big leap. Yeah. And one that
I
a
think
judge would
that
be,
they would be
very
less
hesitant
likely
to make.
I think that they'd be less likely to do it if not for the fact that it's Judge Bev.
I agree. I don't think this motion gets made if it's not Bev.
So
Okay. That wraps us for the evening. It was a 6-hour live stream. It was a long one, folks. Appreciate you guys being here. I didn't expect it would be this long. So please check out Ian on Monday if you can. If he is live, if he's not, he's not, and we will work together whenever we can. Very much appreciate it, guys.
I'm gonna try. I just gotta get some more pages down that are good pages and not, like, it's really easy to hammer out 20 pages. It's really hard to hammer out 20 pages that are 20 pages that, because it's got to be clear, and it's got to be dense, and it's got to be well researched. So yeah.
All right. Thank you guys for being here. Much appreciated. For those of you who are still sticking around, please hit the like button. Please consider subscribing, and we will hope to catch you the next time. Much appreciated. Have a lovely weekend. Go outside, get in the shop, get somewhere, go make something. You'll feel better. And we will see you next time. Good night, guys.